Section 56 of American State Trials, Volume 2. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 2 by John D. Lawson. Trial of Thomas O. Selfridge for the killing of Charles Austin. Boston, Massachusetts, 1806, Part 7. Mr. Gore. Gentlemen of the jury, before I proceed, I shall beg leave to read a few sentences from Grecian. No man is permitted to destroy another except in defense of that which, if once lost, is irrevocable forever, as life and chastity. 2 Grecian 19. If a man is assaulted in such a manner that his life shall appear in inevitable danger, he may not only make war upon, but very justly destroy the aggressor. And from this instance, which everyone must allow us, it appears that such a private war may be just and lawful. For it is to be observed that this right or property of self-defense is what nature has implanted in every creature, without regard to the intention of the aggressors. 2 Grecian 7. What shall we then say of the danger of losing a limb, or a member, especially if one of the principles is of the highest consequence, and even equal to life itself? And it is besides doubtful whether we can survive the loss. It is certain if there be no possibility of avoiding the misfortune, the criminal person may be lawfully and instantly killed. 2 Grecian 10. So is he, reputed innocent by the laws of all known nations, who by arms defends himself against him, that assaults his life, which so manifests a consent, is a plain testimony that there is nothing in it contrary to the law of nature. 1 Grecian 117. If I cannot otherwise save my life, I may by any force whatever repel him who attempts it, though perhaps he who does so is not any ways to blame, because this right does not properly arise from the other's crime, but from that prerogative with which nature has invested me, of defending myself. 3 Grecian 2. After having made a few preliminary observations which I thought pertinent, merely with a view to placing you in a situation in which I presume you are disposed to be placed, that of being free from every bias or prejudice, and I in the like manner wish to be heard, as the Attorney General said he was disposed to be heard, that is, as if there were a cause between two indifferent persons of whom you know nothing. But that I presume to be the very essence of justice, and if it were possible that a court and jury should ever decide the suit between them, abstracted from the parties, and merely by fictitious names, we should have decisions more correct than we now have. Not that I mean to find fault with our own jurisprudence, or the organization of our courts, but it is sometimes impossible to be unaffected by the parties who are to be benefited or to suffer. It was therefore that I took the liberty to remark on the danger of prejudice, and to illustrate it by propositions so simple and plain that they would receive the assent not only of the minds to which directed, but of every human being to whom they could be addressed. The consequences that followed were so natural and necessary that they could not be mistaken, and I did flatter myself, and I do flatter myself, that they apply to the cause I now defend. Having stated the law from the several authorities which I have read in support of the principles I laid down, I went into the examination of the evidence, and you have heard it with an attention and patience which will enable you to determine this issue according to the dictates of impartial justice. This is a day of anxiety and solicitude to my client, and of interest to his counsel. Yet I can say that it is a day of humble hope and tranquillity, a day of firm confidence in the truth and justice of his case, for it is on these that he must depend for his acquittal, and on these alone does he wish to depend. I should say, this was to him a day not only of consolation, but of joy. If joy could be presumed to enter the heart of a man who for more than 4 months has been immured within the damp and unwholesome walls of a prison, when his constitution demanded free and open air, who required liberty for the discharge of the usual duties of life, but who felt himself at that time subject to the most unfounded calumny, yet would not, from his respect to the law of his country, reply. But though he could have replied, he did not. No speeches were made, no observations were addressed to the public, except to request that they would not prejudge his cause, but wait patiently for the time when he might have it in his power to state fairly to the world the law and facts of his case, when he would put himself on trial by his country, which country you, gentlemen of the jury, are. And it is now on that law and on those facts, as they shall be laid before you, that he is willing to depend for his acquittal. With respect to the law, it is my duty, and I have no disposition to go beyond it, to state the principles as they have been read to you from the books, to ascertain what it is in this case, and when that is done, to state the facts, that you may apply the one to the other, and come to a just issue. The law I read to you is not of this day. It is not novel or of recent date. It is older than any of us, older than society, old as nature herself. It is founded in nature and in the principles of society, and without it man could not exist. Of the authorities that were read, one of the first was from Lord Coke, who says, that if A assaults B so fiercely and violently, and in such place in such a manner, that if he should give back he should be in danger of his life, B may defend himself, and if in that defense he killeth A, it is se defendendo, because it is not done velio animo. Whatever a man does in preservation of his person, he does not do feloniously. This I take to be the sense of the doctrine laid down by Lord Coke. I took the liberty of reading another authority from Grecian, one of the first and brightest ornaments of the age in which he lived, which has done more for civilizing and humanizing the world than any author who ever wrote, who has written more forcibly and effectually on the rights of man and in support of the religion of Jesus than perhaps any divine, however celebrated. What says he? He says that if a person be in danger of life, or losing a limb or a member, especially one of the highest consequence, and it be ever doubtful if he can survive the loss, and there be no probability of avoiding it, the criminal person may be lawfully and instantly slain. We then come to Judge Foster, one of the ablest judges that ever sat on a British bench. He tells us that the injured party may repel force with force, in defense of his person, habitation, or property, against one who manifestly endeavors, with violence and surprise, to commit a known felony upon either. In these cases, he is not obliged to retreat, but may pursue his adversary till he find himself out of danger, and if in the conflict he happen to kill, such killing is justifiable self-defense. You have the same doctrine laid down by Lord Hale, who is one of the best and most humane of judges, as well as one of the most devout Christians that ever appeared. Both he and Hawkins support the same doctrine, and in Hawkins it is further said, if the party assaulted cannot conveniently and safely retreat, and if he kill the assailant to avoid this beating, it is justifiable homicide. This is the law from those writers. The next is Blackstone, whose doctrines have never been controverted. He tells you that the party assaulted must flee as far as the fierceness of the assault will permit him, for it may be so fierce as not to allow him to yield a step without manifest danger of his life or enormous bodily harm, and then in his defense he may kill his assailant. He does not put it on the question of life being in danger, but says that where a man is in danger of any enormous bodily harm, he is not to wait till the case has happened, but has a right to kill his assailant. This forms the law of justifiable homicide, and is the doctrine of universal justice, as well as of our municipal law. Thus, gentlemen, I have shown from the book the principles that govern in relation to justifiable homicide. I will now read one or two cases which more perfectly establish this doctrine, and show what is the nature of the assault that justifies the assaulted in taking the life of the assailant. In Mortgage's case, who, upon the words of anger being between him and a Mr. Cope, threw a bottle with great violence at the head of the latter, and immediately drew his sword, on which Mr. Cope returned the bottle with equal violence. Lord Holt says, it was lawful for Mr. Cope so to do, for he who hath shown that he had malice against another is not fit to be trusted with a dangerous weapon in his hand. And he adds it was reasonable for Mr. Cope to suppose his life in danger when attacked with so dangerous a weapon, and the assault followed up by another act indicating an intention of pursuing his life. It appears to me that this case justifies him who shall kill, where a weapon is used which would endanger his life, though it have not the effect, and that the person assaulted has a right to attempt the destruction of the assailant, that he himself might not be destroyed. You there have the particular case. This case will depend on the law of justifiable homicide. It therefore is not necessary to have recourse to such as are so strong as that I have read. The law says that if there be reasonable ground to suspect that life is in danger, a man shall be excused, if he exercise the right nature has given him to destroy and take away the life of him, by whom his own has been endangered. As to Naylor's case, I do not mean to contradict it any further than it is contradicted by the doctrine I state. You recollect, gentlemen, that it was a case where a son, in consequence of hearing a scuffle between his father and brother, rose from his bed, threw his brother on the ground, fell upon him, and beat him, that while in this situation he who was undermost, not being able to escape or avoid the blows he received, gave his brother a mortal wound with a penknife. This was ruled to be manslaughter because the prisoner was in the first place in the wrong, as much so as any man can be who offends against the law of society and of nature by fighting with his father, and further because he was not necessitated from the attack of his brother, which brother was without a weapon in his hand, to have recourse to such violent means for defense, because also he was in a wrong act, and then made use of a mischievous weapon. For, says the book, from the manner in which he was attacked, there was no reason to believe his life ever was in danger. But had he been attacked with a dangerous weapon, then he would have been clear of crime. The law will not countenance a man in destroying his assailant, unless there be a reasonable ground to believe that his life or person is in imminent danger, and whether it be so or not may be determined from the circumstance of the weapon, whether it appear to be such a one, with which life might be destroyed. On this apparency of intent and reasonable ground of apprehension that life was in danger, was determined the case of the servant, who coming up found his master robbed and slain, and instantly killed the murderer, although not attacked himself, yet on account of the apprehension which it was supposed he might be under of being attacked, and his own life put in danger, it was held excusable homicide. That is the principle on which some writers defend the authority given by the law of destroying the robber who demands your purse, because the same man who comes to rob would, if necessary for his purpose, take your life. Further, if an officer going to arrest a man in a civil suit break into a house which he is not justifiable in doing, and the person within kill him knowing him to be a bailiff, it is manslaughter. but adds the authority if he had not known him to be a civil officer. The breaking in would have afforded a reasonable ground of suspicion that it was done with a felonious intent, and of course, excusable homicide. There is another case read to you, which it is important perhaps to notice. It is that of the officer who entered the chamber of a gentleman who was in bed, on which he sprang out of bed, seized a sword, and ran the officer through the body. This was determined to be manslaughter, because he did not use sufficient caution, and because the officer had no weapon in his hand. But had there been any, that circumstance may have led the gentleman to think there was a felonious intent in entering his room, and then it would have been excusable homicide. It will be important, gentlemen of the jury, for you to keep these doctrines in your minds when you come to consider this case on the evidence. It will be incumbent on you to further recollect the decision of Moggridge's case as to excusable homicide, as distinguished from manslaughter. If I recollect aright, the true criterion between homicide and chance meddling upon self-defense and manslaughter is where both parties are actually fighting at the time when the mortal stroke is given. The slayer is guilty of manslaughter, but if the slayer had not begun to fight, or having begun had endeavored to decline any further struggle, and afterwards, being closely pressed by his adversary, kill him to avoid his own destruction, this is homicide excusable in his own defense. Manslaughter, therefore, on a sudden provocation, differs from excusable homicide, se defendendo, in this, that in the one there is apparent necessity, for self-preservation, to kill the aggressor. In the other there is no necessity at all, being only a sudden act of revenge, and then it is manslaughter. This distinction I wish you gentlemen to keep in your minds when you come to examine this particular case. Having stated the law as I conceive it to be, on reflection, it will be found to be supported by the books which have been read, and as it will, I presume, be given to you by the court. I now come to state the facts, for it is my duty only to state the facts as they have appeared in evidence, without arguing upon them. In doing this, although I do not mean to go into a critical examination of the testimony you have heard from some of the witnesses, nor in the least to question their veracity, yet there is a fitness and propriety that some of them should be laid out of the way. I mean Mr. Lane, and though I have not the slightest intention of impeaching his character, yet it is manifest from the whole current of the testimony delivered that Mr. Pickman must have been right, and Mr. Lane, as well as the other witnesses who were examined in support of his evidence, mistaken, because Mr. Lane says that the transactions he testified to were on the brick pavement, when all the other witnesses, as well as Mr. Pickman, who was with him, say the scene was in the middle of the street. I shall say no more on this point. It would be wasting time to suppose you can attach the least weight to the testimony of Mr. Lane. On that of Mr. Howe, I have only to beg you will compare it with that of the other witnesses, because, as the first time he saw the parties together was when they were on the brick pavement, he could not have seen the first blow in the earlier parts of the transaction. He could not have witnessed all those ingredients which go to enable you to make a just conclusion from the whole. He could not have seen those circumstances which took place before the firing. On the previous circumstances that have been detailed to you, I mean the misunderstandings that take place between the defendant and Mr. Benjamin Austin, the father of the deceased, it is not necessary to say much. I shall merely ask you to consider the statement made to you by the witnesses examined. It is from them only that I wish you to judge the serious provocation received. You have the testimony of Messrs. Babcock, Scott, and Russell as to expressions used by Mr. Austin and the manner in which they were delivered. It is by putting yourself in the situation in which these witnesses stood that you must examine the force of Mr. Austen's expressions. Mr. Scott so perfectly understood the meaning of Mr. Austen that he went to Mr. Selfridge to communicate it, and permit me to say that whatever took place at that time, if from the general apprehension of yourselves you think it was applicable to Mr. Selfridge, you will believe and suppose it to be true, that Mr. Austen meant to charge Mr. Selfridge with being the damned federal lawyer who had solicited the action, and in a court of law cannot but be believed it was as high a charge as could be made. It amounted to a criminal offense, for it was that he went about stirring up and soliciting suits. You saw Mr. Scott on the examination stand, and have to decide whether he did or could believe it was Mr. Selfridge that was meant. The story for Mr. Austen is that he had contradicted the report to the very persons to whom he mentioned it. Mr. Scott says that he never did. Mr. Russell, who also heard the imputation and knew, it appears, how it was intended to be implied, says that Mr. Austen never did contradict that fact. The conduct, then, of the defendant in demanding a written recantation from Mr. Austen must appear, I trust, to have been perfectly justifiable and warranted from the general charge against him. He did not persist in his demand of reparation more pertinaciously than what in duty to himself and family he was bound to do. He asked only for the means of proving that Mr. Austen himself had acquitted him from the charge he had made against him, as he found Mr. Austen would not do it himself. This satisfaction was refused. You have it in evidence that he never received anything like a satisfaction, which a man of honor in his profession, or as a man of any decent standing in society, could be satisfied with. For there is not the smallest evidence that there was a contradiction of the report, but only an evasion. Mr. Austen did not contradict the charge that he had made. He merely said that he had not used the name of Mr. Selfridge. This, too, was not done by way of disavowal to the man himself, to whom he had said it, and was, from the very manner, rather a confirmation than denial. Having thus acknowledged that he had not used the name of Mr. Selfridge, Mr. Austen satisfies his conscience that he had made every amends. Can any honorable man say that he had, when Mr. Russell and Mr. Scott say that he never had contradicted it to them? When asked, "Did you contradict it to Mr. Babcock?" he in the first place says that he heard it from Mr. Babcock, and that this was after the suit was brought. I shall not enlarge on this point. I refer you to the evidence of Mr. Austen's behavior. His own testimony is against him. Can you then have any doubt that Mr. Selfridge persisted more than he ought to have done in requiring Mr. Austen to contradict in writing what he had circulated? Because, Mr. Selfridge, I find that when you say you have contradicted the assertion in person, these very people to whom you say you have done it declare it has not been done. Was it then honorable in Mr. Austen to refuse giving to the defendant a written acknowledgment that the report was without foundation? I put it to you, gentlemen, if you had stated to various persons from misinformation that which bore hard on the character of anyone, and you were asked to give a note in writing that you were misinformed, would either of you have refused that small and honest avowal? No, I know you too well to think it, for I know that no honorable man could or would refuse it. For where I have undesignedly done an injury by spreading a false report of another, would I not try to retract it, that I might make reparation as much as I could, and even put it in his power to show that he was right and I in an error? Examine whether there was, throughout the whole, a desire in the defendant of Mr. Austen to do anything more than to enable him to have this retraction, that it might be in his power to use it for his own justification. He says in his conversation with Mr. Welch that his only motive in moving in the affair was to rescue his professional conduct from imputation. that he could not relinquish this pursuit, but before he adopted other measures, he would leave Mr. Lawson a day or two to reflect. Was this the language of a man who sought revenge? No, it was that of a calm and mild expostulation, asking redress for an injury sustained. I shall say no more on this part of the testimony than to observe, it rests with you. If you give credit to Mr. Austin, you must believe Mr. Welsh tells a falsehood. You must believe that Eager, Russell, and Scott all tell falsehoods, or at most strangely, not to say grossly mistaken. You cannot, I say, believe the relation of Mr. Austin, unless you believe that all these persons are mistaken. I now come to the motives and to the conduct of the defendant on this unhappy day. If you are of opinion that there was no felonious intent on the part of Mr. Selfridge at that time, then you cannot find him guilty of manslaughter, because manslaughter must be committed with a felonious intent. If there were no felony in his mind, no crime in his heart, he must be decided by your verdict to be an innocent man. I wish now to trace the conduct of Mr. Selfridge on that day. You find that there had been a suit prosecuted by him, in which he was by the desire of Captain Ingraham to sue out an execution and deliver it on change. Captain Ingraham is positive that he told the defendant on Saturday or Sunday evening to get the execution, and that he himself went twice to the exchange for the purpose of receiving it from Mr. Selfridge. You have therefore the very reason why the defendant went there, when in the common practice of his profession it would be natural to go on the exchange in the general course of business. But here is a particular piece of business to meet a person by appointment. There can therefore be no doubt that he went there for that purpose and for that only. In the conversation with Mr. Richardson, the defendant said he could not confine himself, that his business was of a peculiar nature, and that he must go about it as usual. Perhaps he recollected at the time that he was to go out on special business, and that was the reason why he spoke to Mr. Richardson as he did. When this took place with Mr. Richardson, he had no idea of the affray which afterwards happened. It is hardly possible, if he had entertained the smallest intention of provoking a quarrel, that he should not have mentioned it in conversation to Mr. Welsh and Mr. Richardson, persons who were in his intimate professional acquaintances. After Mr. Selfridge left his office, you find him walking on change, in as calm and deliberate a manner as ever he did in his life. And if any of you gentlemen have ever observed Mr. Selfridge walk, you must recollect that he does hold his hands in walking, exactly as the witnesses have described, for it is the natural position of a man who would wish to aid the debility of his body, and the manner in which Mr. Selfridge is stated to have walked, given the exact description of the walk of a weak and feeble man. From the testimony offered you will further find, and particularly by the evidence of Brooks, for I wish to trace the defendant down to the exchange, that he is clear Mr. Selfridge's hands were behind him, and not in his pocket. Mr. Brooks stood at Clark's shop and observed Mr. Selfridge from the moment of his entering State Street. He therefore must have seen the position of his arms best. Some of the witnesses supposed that his hands were in his pocket. This was a mistake that might easily arise from not having a full view of his body. It would be difficult in some kinds of coats which have the pockets behind to ascertain whether the hands were actually in them or not. But Brooks, who saw him pass first in the front and then in the rear, must be the best qualified to determine what was the actual situation of the defendant's hands. Irwin tells us that his hands were behind him, that in this position he came down the street, but that when Austin came out from the sidewalk, Mr. Selfridge held up his left hand as if to guard his head, took his right hand from behind him, put it into his pocket, drew out a pistol, extended his arm, and fired. Take this with the testimony of French, Bailey, and Shaw, who received from the defendant the execution he sued out of the request of Mr. Ingraham, and the current of evidence from other witnesses. For on these facts it is that you have to determine, and if you must judge from the weight of evidence and decide according to the number of witnesses, you can have no doubt that the defendant, instead of going to meet an affray, was going down to change on special business with his hands behind him and walking very deliberately when he was assaulted by young Mr. Austen, to further prove that he could not have gone to seek this insult. You will please to recollect that he went with his face looking towards the branch bank and not towards the place where the deceased was. When in the situation, judge you whether a man with, as you are told, the sun in his eyes and his hat flapped or slouched over them, could have seen Mr. Austen, who stood with his back against Mr. Townsend's shop. It is manifest that Mr. Selfridge could not, from the course he was taking, have looked that way, and it is in evidence that he did not bear towards Mr. Townsend's shop, till obliged, from the violence of young Austen's attack, to turn to defend himself. Some say that he stepped back, others that he turned round to do this. It would seem that when the defendant had got a little to the southward of the middle of the street, the unfortunate young man rushed out and made an attack upon him. Let us, for the purpose of ascertaining this, now compare the testimony. Louis Glover states to you that he went into State Street that day for the express purpose of seeing what would take place, supposing there would be an affray between Mr. Selfridge and some other person, in consequence of the publication in the Gazette. He says he took a station where he had a full view of the defendant as he came down the street, that he walked very deliberately with his hands behind him, that Austen went from the pavement with a quick pace directly against Selfridge, with his cane uplifted, and gave the defendant a violent blow. And as he was giving the second, Selfridge fired. If you believe this, it was before the discharge of the pistol, as violent a blow given as could be struck by an athletic young man directly on the defendant's head. The witness's credit stands totally unimpeached, even if alone. But is it not corroborated? For was not Edwards also in expectation of some affray, and stopped before Mr. Townsend's shop? He saw Mr. Selfridge walking in a direction that would have brought him on the brick pavement near the branch bank, when a person brushed by him and got near the middle of the street with a stick in his hand. He adds that it was uplifted, but whether in the attitude of giving or receiving a blow he could not say, but that the cane descended and the pistol was fired at the same instant. You have it, however, in evidence that just before, something caught the eye of Mr. Edwards, and he turned his head to Mr. French. Does not this interval afford time for the first blow deposed to by Glover? Were there no other testimony that delivered by these two witnesses? Would not this of Edwards be the strongest corroboration of that by Glover? Would you not, on giving a due credit to both, say that his evidence is confirmed by the statement of Edwards? Consider the situation of the parties. Selfridge coming down the street pursuing a course that would have taken him to the left of Austen, towards the branch bank. As soon as Austen perceived him, he changed his stick from the left to the right hand, and brushed by everyone with a quick pace. Consider the distance between him and Selfridge, the few paces that intervened, that Mr. Austen was running on the defendant, as you have been told, as if he was going to attack a wild beast, that he sprung from the pavement and rushed on him, when it was not possible for Mr. Selfridge, whose hat was over his eyes, and when his hands were behind him, to guard himself before a blow could have been given. The circumstances of the case render the testimony of Glover so connected as not to leave you a possibility of doubting it, and unless what is testified be contradicted, you cannot reject it. But if it be of such a nature that it can be reconciled with, and is supported by circumstances and other evidence, you cannot but believe it. See how this is established more and more by every comparison. Wiggin says that he was in State Street also, for the purpose of seeing anything that might take place, that he was conversing about young Austin and Selfridge, that he saw Mr. Austin with a stick in his hand, and Selfridge coming down the street, that he looked around for Austin. After having seen Mr. Selfridge, and while his eye was thus momentarily directed, he heard a blow. Can you account for this and the other blow which followed, unless there was one given before the pistol was fired? Mr. Wiggin could not have been deceived when all his attention was awake for the purpose of observation, and he saw, when the pistol was fired, the hand descending again. There is a corroboration as strong as possible of this fact, that a blow was given before the discharge of the pistol, from the testimony of Bailey and French. They tell you the assault was as violent as possible, and that they could not tell which was first, the blow or the firing of the pistol. Now, if their eyes were turned aside, but for an instant, there can be no doubt but that the evidence is true, and that they did not see the whole of the transaction. From some of the testimony, it appears that in wounds of this kind, the strength is very great, and the muscular action quicker and more sudden. Do not these circumstances go to corroborate the statement of Mr. Glover, and to account for the instantaneous act of the blow and discharge of the pistol? It is but fair to draw this conclusion, that when witnesses testify positively to a fact which other persons might not have seen, but which is neither contradicted by nor contradicts the testimony given by others, to believe that what was seen by some of the witnesses might have escaped the observation of the others, because if you do this, you give credit to each party without supposing either to have sworn falsely. End of section 56. Section 57 of American State Trials, Volume 2. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 2 by John D. Lawson. Trial of Thomas O. Selfridge for the killing of Charles Austin. Boston, Massachusetts, 1806. Part 8. I now come to the testimony of Mr. Fales. I mean not by any means to discredit him. I believe him to be an honorable young man, nor has anything that has taken place caused me to doubt it. I, however, do believe that when a transaction is recent and fresh, the impressions are stronger than at a future day. I need not contend for a proposition like this. There is no reason to suppose that he could, then, tell what was untrue. He relates that there was some conversation between young Austin and himself about the cane, from which you will draw your own conclusions. It appears, however, that he had some apprehensions about his friend's having this cane, for he asked young Austin to give it to him, and he states that when at Townsend's shop the deceased brushed by him and went toward Mr. Selfridge. He further tells you, and he tells you very candidly, that he cannot tell which was first, the blow or the firing of the pistol. When you see the sensibility of this young gentleman, who could not but be agitated on the occasion, when he was deceived and deluded by his friend, who had told him he was not on this errand, could he be unruffled, calm, and unagitated? Surely not, for even at our time of life, when the nerves are hardened, when we are not so liable to be agitated as a young man like Mr. Fales, should we see a person spring forward to do that which we should so earnestly wish he was not going to do, would we not feel agitated and alarmed? Had he any motive on earth not to declare the actual fact? Had he any occasion to prevaricate? None. Would you, gentlemen of the jury, or would you not believe what he said at that time? Can you think he did not then feel every disposition to speak in favor of his friend, who lay bleeding and dead on the spot he had left? He must have had every feeling alive to the memory of his friend, and would have been happy to raise it in the estimation of those he addressed. It is but natural that he should, but it is not in nature that he should wish to say anything against him. How then can you account for the answer? It was the undisguised voice of truth, at a moment when she could be the least concealed, in answer to a distinct and positive question. It is on that answer that I would rely, and it is on that you will, I trust, also rely. Look to the further declarations of Mr. Fields on this unhappy occasion. In the course of the evening, when Mr. Benjamin Austen must have felt all that resentment which a parent may be supposed to feel against the man who had taken the life of his son, when he could not wish to hear his child deemed the aggressor, when Mr. Fields could not have wished to plant a dagger in a father's bosom, when he must have gone to the house of Mr. Austen with far different intentions, when he went to administer balm and consolation to an aged and afflicted parent, when it might, without impeaching the character of Mr. Fields, be well supposed he wished to hide the truth, but truth must be told. What was it that he then answered to a father's question? Your son struck a blow first, a violent blow before the pistol was fired. Had Mr. Fields the least motive to represent his friend's conduct as influenced by bravado spirit, or to give that color to the transaction? Mr. Nichols went and made a memorandum of the words. You have this fact fully in evidence. There was then every motive on earth but that of truth, to tell a different story from the representations made by the friend of the deceased at the very hour of his death, from his answer to an inquiring and afflicted parent. You, therefore, had the testimony of Glover most fully and completely corroborated. There must necessarily have been one violent blow first, and on the second blow descending, the pistol was fired. Thus then stands the evidence of this important fact. You have to it the positive testimony of Glover, corroborated by that of Edwards and of Wigan, by a circumstance as strong as if he had seen the blow, for he heard it. You have it corroborated not only by the first declarations of Mr. Fields, but from probability arising from the manner in which he delivered his testimony when on the stand. This, then, was the situation of the defendant. He was going down State Street not only on his just and ordinary business, but on a special engagement to meet a client there for a particular purpose. True, he had noticed that some person was to be hired to destroy or attack him. It may have been said that he could have gone to a magistrate and obtained the protection of the laws of his country, and have taken security for keeping the peace. I agree that this would have been a fair answer to the question of, what could he do? If Mr. Cabot had said, young Austen is to attack you, speaking as I do in a court of justice, it was, under such a circumstance, his duty to have done so. But it was not so said to him. It was merely mentioned to him that some person was to be hired or employed to destroy or beat him. He had it not, then, in his power to avail himself of the protection of the law by taking security, for he did not know by whom he was to be assailed. It became then, as the laws of his country could not afford him protection, a duty in him to protect his own life by all the means in his power. The particular purpose for which he had the pistol in his pocket I know not. What it was is not fully in evidence, but the plain fact is this, that the defendant with the pistol in his pocket was going down to the exchange on business, and was met by a man coming upon him like a person attacking a wild beast. A blow was struck on his head which would have fractured his skull had it not been for the hat which he had on. What did nature, what did law and reason prompt to do on such an occasion? Was it not to make use of every means in his power to defend himself? Let me here ask, what were these means? You have heard accounts of his debilitated state, his total want of muscular strength. He could not have defended himself by his hands. He could not have gone out of the way, for he was unable to fly. You have it in evidence that Austin was on the run. He could not then have even turned around without receiving 2 or 3 blows, perhaps fatal ones. What then could he do? That only which he could do in defense of his life. The only remaining thing he had to do was what he was compelled to do. He took his pistol from his pocket and, after having received 1 blow, killed as he was receiving another from the assailant who would have killed him. This is the defense we make to the charge against Mr. Selfridge. This we contend to be the legal and proper one, of justifiable homicide to preserve his own life. If this be unwarrantable, our defense is gone. But if nature, if reason, if instinct impel every created being, one attack to make use of all the means in his power to defend his life and person, you cannot adjudge this to have been unlawful in the defendant, without reducing everyone that is assailed by a ruffian to his dreadful alternative of perishing by the hand of violence or by the verdict of a jury. After this was done, Mr. Selfridge defended himself by holding up his hands. Some say he struck. I must say that from the testimony, it appears to me he did not. But allowing that he did, it was natural that he should do so. He threw his pistol, it is true, but whether at the deceased or not does not appear. The person says it was thrown at his head, and Howe tells us it rolled toward Mr. Russell's printing office. The conflict over, no violence was seen on the part of Mr. Selfridge. Nothing barbarous, nothing even like anger or rage. He went forward as if exhausted, and leaned against Mr. Townsend's shop. Some cried out, "Who is the rascal that has killed him?" "I," said the defendant, "am the man. I mean not to go away. I know what I have done, and am ready to answer for it to the laws of my country." Mr. Melville came up to him and said, "You ought not to go away." "I do not intend to," was still the answer. One other person, seeing the crowd assembled, and violence talked of, advised him to retire. He went off, sending for the officers of justice, that he might be ready to answer to the laws of his country, if he had offended against them. He desired Mr. Bourne to let Bell be informed where he was to be found. This was the conduct not of guilt, but of conscious innocence. It is attempted to be done away by saying that he was to have dined with Mr. Bell, but could any man, especially a lawyer, after an act of this sort, have imagined that he might take his dinner without interruption in a public house? There can be no doubt, therefore, that he told where he was to be found by the sheriff of the county. True, he went away, but not to fly. It was in that awful moment, as in this, that he appealed from the passions of the people to their judgment, from their imagination to their reason, from their feelings to their sense of justice, from their violence to his country. You, gentlemen of the jury, are that country. It is not possible to conceive any motive to do this act, but what arose from necessity, imposed at the very instant. It is hardly an evidence that Mr. Selfridge knew this unfortunate young man. If there had been any feelings of revenge to gratify, would he have gone on the exchange to indulge them? No, he would have sought some other opportunity. And what was his behavior there? He was tranquil and calm. Look at his after conduct. It was not the result of hardness of heart, but of that conscious innocence which protects the man unpolluted with sin, when every friend flies from him, which in the hour of terror and dismay whispers comfort and consolation to his soul. For the heart which knows no crime can be tormented with no remorse. This, gentlemen, is, I believe, the whole of our story. I am not permitted by the rules of the court to go into argument on the facts. I have barely stated the law, not what are my notions of it, but from the books. I took especial care not to state the case before the witnesses were examined, but it was not my wish either to exaggerate or diminish. I meant to place it on the ground of the evidence itself, and to leave, without any appeal to the passions, your minds open to receive the fair impressions from the testimony I have attempted to recapitulate. Having said nothing but what they testified, I have done all the duty which in this state of the case I am at liberty to perform. I therefore leave the defendant with you, merely stating my own conviction as a lawyer, a Christian, and a man that he has committed no offense, either against the law of society, of religion, or of nature. That he is not against the law of society, I bottom myself on the authorities which have been read. That he is not against the laws of religion, I infer from the duty which every created being owes to him, who in his beneficence brought us into existence, to defend life by all the means in his power, not against the law of nature, for whatever theorists or speculative men may say to the contrary. Yet, when the alternative arises, whether a man must fall, or whether it must be he who assaults him, whether he must sacrifice all his duties to God, to religion, and to society, or would put to death the man by whom he is assailed, nature would assert her prerogative. The aggressor must die, and the innocent man remain alive. Stephen Skelton. Very shortly after the death, I saw the defendant. He was standing near the post office. A gentleman that was by him said to him, "You are agitated." He replied that he was not. He had done as he meant to do, or what he meant to do, or no more than he meant to do. Richard Edwards was by when Mr. Selfridge went from State Street, had been observing him to see if he was going away, and which way he should go. Heard him say that he was the man, that he did not intend to go away. When Major Melville came up and told him he hoped he would not think of going away, he said he was not going off. Afterwards, Mr. Ritchie pressed him and took him away with him. Heard no such observation as Mr. Skelton has testified to. William Ritchie. Heard nothing of the speech which Mr. Skelton had testified to. When I advised him to go with me, he would not. Had hold of his arm, and was pressing him to go, when Major Melville spoke to him. He broke from me and refused to go. He said he was not so much agitated as I was. He knew very well what he had done. He afterwards went with me to my house, and when he heard of the death, I had no belief that Lawson was dead before I went home. He expressed great regret, and said if he should be permitted to attend the funeral, he believed he should be as sincere a mourner as anyone in the procession except the parents themselves. Joe Bass. First saw Mr. Selfridge standing at his office door. Saw him walk down the corner of the old State House. When past the corner, he put his hands behind him and walked slowly towards Congress Street. Saw Mr. Austin standing near Mr. Townsend's shop, and when he stepped out towards Mr. Selfridge, he raised his right arm. Mr. Selfridge's arm was removed from behind him and raised to a horizontal position. The pistol went off immediately, and then Mr. Austin struck him violently across the forehead. End of section 57. Section 58 of American State Trials, Volume 2. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 2 by John D. Lawson. Trial of Thomas O. Selfridge for the killing of Charles Austin, Boston, Massachusetts, 1806. Part 9. Mr. Dexter. Gentlemen of the jury, it is my duty to submit to your consideration some observations in the close of the defense of this important and interesting cause. In doing it, though I feel perfectly satisfied that you are men of pure minds, yet I reflect with anxiety that no exertion or zeal on the part of the defendant's counsel can possibly ensure justice, unless you likewise perform your duty. Do not suppose that I mean to suggest the least suspicion with respect to your principles or motives. I know you have been selected in a manner most likely to obtain impartial justice, and doubtless you have honestly resolved and endeavored to lay aside all opinions which you may have entertained previous to this trial. But the difficulty of doing this is perhaps not fully estimated. A man deceives himself oftener than he misleads others, and he does injustice from his errors when his principles are all on the side of rectitude. To exhort him to overcome his prejudices is like telling a blind man to see. He may be disposed to overcome them, and yet be unable because they are unknown to himself. When prejudice is once known, it is no longer prejudice, it becomes corruption. But so long as it is not known, the possessor cherishes it without guilt. He feels indignation for vice and pays homage to virtue, and yet does injustice. It is the apprehension that you may thus mistake, that you may call your prejudices principles, and believe them such, and that their effects may appear to you the fruits of virtue, which leads us so anxiously to repeat the request that you would examine your hearts and ascertain that you do not come here with partial minds. In ordinary cases, there is no reason for this precaution. Jurors are so appointed by the institutions of our country as to place them out of the reach of improper influence on common occasions, at least as much so as frail humanity will permit. But when a cause has been a long time the subject of party discussion, when every man among us belongs to one party or the other, or at least is so considered, when the democratic presses throughout the country have teemed with publications fraught with appeals to the passions and bitter invective against the defendant, when on one side everything has been done that party rage could do to prejudice this case, and on the other, little has been said in vindication of the supposed offender, though on one occasion I admit that too much has been said, when silence has been opposed to clamor and patient waiting for a trial to systematic labor to prevent justice, when the friends of the accused, restrained by respect to the laws, have kept silence because it was the exclusive right of a court of justice to speak, when no voice has been heard from the walls of the defendant's prison, but a request that he may not be condemned without a trial. The necessary consequence must be that opinion will progress one way, that the stream of incessant exertion will wear a channel in the public mind, and the current may be strong enough to carry away those who may be jurors, though they not know how or when they receive the impulse that hurries them forward. I am fortunate enough not to know, with respect to most of you, to what political party you belong. Are you Republican Federalists? I ask you to forget it. Leave all your political opinions behind you, for it would be more mischievous that you should acquit the defendant from the influence of these than that an innocent man by mistake should be convicted. In the latter case, his would be the misfortune, and to him would it be confined. But in the other, you violate a principle, and the consequence may be ruin. Consider what would be the effect of an impression on the public mind that in consequence of party opinion and feelings, the defendant was acquitted. Would there still be recourse to the laws and to the justice of the country? Would the passions of the citizen, in a moment of frenzy, be calmed by looking forward to the decision of courts of law for justice? Rather, every individual would become the avenger of imaginary transgression. Violence would be repaid with violence. Havoc would produce havoc, and instead of a peaceable recurrence to the tribunals of justice, the specter of civil discord would be seen stalking through our streets, scattering desolation, misery, and crimes. Such may be the consequences of indulging political prejudice on this day, and if so, you are amenable to your country and your God. This I say to you who are Federalists, and have I not as much right to speak thus to those who are Democratic Republicans? that liberty which you cherish with so much ardor depends on your preserving yourselves impartial in a court of justice. It is proved by the history of man, at least civil society, that the moment the judicial powers become corrupt, liberty expires. What is liberty but the enjoyment of your rights, free from outrage or danger? And what security have you for these but an impartial administration of justice? Life, liberty, reputation, property, and domestic happiness are all under its peculiar protection. It is the judicial power, uncorrupted, that brings to the dwelling of every citizen all the blessings of civil society and makes it dear to man. Little has the private citizen to do with the other branches of government. What to him are the great and splendid events that aggrandize a few eminent men and make a figure in history? His domestic happiness is not less real because it will not be recorded for posterity. But this happiness is his no longer than courts of justice protected. It is true, injuries cannot always be prevented, but while the fountains of justice are pure, the sufferer is sure of a recompense. Contemplate the intermediate horrors and final despotism that must result from mutual deeds of vengeance when there is no longer an impartial judiciary to which contending parties may appeal, with full confidence that principles will be respected. Fearful must be the interval of anarchy, fierce the alternate pangs of rage and terror, till one party shall destroy the other, and a gloomy despotism terminate the struggles of conflicting factions. Again, I beseech you to abjure your prejudices. In the language once addressed from heaven to the Hebrew prophet, put off your shoes, for the ground on which you stand is holy. You are the professed friends, the devoted worshippers of civil liberty. Will you violate her sanctuary? Will you profane her temple of justice? Will you commit sacrilege while you kneel at her altar? I will now proceed to state the nature of the charge on which you are to decide, and of the defense which we oppose to it. Then examine the evidence to ascertain the facts, and then inquire what is the law applicable to those facts. The charge is for manslaughter, but it has been stated in the opening that it may be necessary to know something of each species of homicide in order to obtain a correct idea of that which you are now to consider. Homicide, as a general term, includes in law every mode of killing a human being. The highest and most atrocious is murder, the discriminating feature of which is previous malice. With that the defendant is not charged. The grand jury did not think that by the evidence submitted to them they were authorized to accuse him of that enormous crime. They have therefore charged him with manslaughter only. The very definition of this crime excludes previous malice. Therefore it is settled that there cannot, with respect to this offense, be an accessory before the fact, because the intention of committing it is first conceived at the moment of the offense, and executed in the heat of a sudden passion, or it happens without any such intent, in doing some unlawful act. It will not be contended that the defendant is guilty of either of these descriptions of manslaughter. Neither party suggests that the defendant was under any particular impulse of passion at the moment, and had not time to reflect. On the contrary, he is said to have been too cool and deliberate. The case in which it is important to inquire whether the act was done in the heat of blood is where the indictment is for murder, and the intent of the defense is to reduce the crime from murder to manslaughter. But Selfridge is not charged with murder. There is nothing in the evidence that has the least tendency to prove an accidental killing while doing some unlawful act. It is difficult to say from this view of manslaughter, when compared with the evidence on what legal ground the defendant can be convicted, unless it be that he is to be considered as proof guilty of a crime which might have been charged as murder, and by law, if he now stood before you under an indictment for murder, you might find him guilty of manslaughter, and therefore you may now convict him. This does not appear to be true, but the evidence would not apply to reduce the offense from murder to manslaughter on either of the aforementioned grounds. Perhaps it may be said that every greater includes the less, and therefore manslaughter is included in murder, and that it is on this principle that a conviction for manslaughter may take place on an indictment for murder. I will not detain you to examine this, but it is not doing justice to the defendant to admit for a moment, even for the sake of argument, that the evidence proves murder. Our time will be more usefully employed in considering the principles of the defense. Let it be admitted, then, as stated by the counsel for government, that, the killing being proved, it is incumbent on the defendant to discharge himself from guilt. Our defense is simply this, that the killing was necessary in self-defense, or in other words, that the defendant was in such imminent danger of being killed or suffering other enormous bodily harm that he had no reasonable prospect of escaping but by killing the assailant. This is the principle of the defense stripped of all technical language. It is not important to state the difference between justifiable and excusable homicide, or to show to which the evidence will apply, because by our law, either being proved, the defendant is entitled to a general acquittal. Let us now recur to the evidence and see whether this defense be not clearly established. Mr. Dexter then went into a minute examination of the whole evidence. In the course of it, he endeavored to prove that Mr. Selfridge went on the exchange about his lawful business, and without any design of engaging in an affray, that he was in the practice of carrying pistols, and that it was uncertain whether he took the weapon in his pocket in consequence of expecting an attack, that if he did, he had a right so to do, provided he made no unlawful use of it, that the attack was so violent and was so dangerous a weapon that he was in imminent danger, that it was so sudden and himself so feeble that retreat would have been attended with extreme hazard, that the pistol was not discharged until it was certain that none would interfere for his relief, and that blows, which perhaps might kill him and probably would fracture his skull, were inevitable in any other way, and that the previous quarrel with the father of the deceased, if it could be considered as affecting the cause, arose from the misbehavior of old Mr. Austin, and that the defendant had been greatly injured in that affair. It cannot be necessary, gentlemen, for the defendant to satisfy you beyond doubt that he received a blow before the discharge of the pistol. There is positive evidence from one witness that the fact was so, and other witnesses say much that renders it probable. But if the defendant waited until the cane was descending, or even uplifted within reach of him, reason and common sense say it is the same thing. No man is bound to wait until he is killed, and being knocked down would disable him for defense. The killing can be justified only on the ground that it was necessary to prevent an injury that was feared, not that it was to punish for one that was past. This would be revenge, and not self-defense. The same law authorities which tell you that a man must retreat as far as he can say also that if the assault be so violent that he cannot retreat without imminent danger, he is excused from so doing. If this means anything, it is applicable to our case, for perhaps you can hardly imagine a more violent or more sudden assault, when to this is added the muscular debility of the defendant. It certainly forms a very strong case. He could neither fight nor fly. Had he attempted the latter, he must have been overtaken by his more athletic and active antagonist, and either knocked down or maimed or murdered, as the passions of that antagonist might dictate. But it is said, and some passages from law books are read to prove it, that the necessity which excuses killing a man must not be produced by the party killing, and that he must be without fault. You are then told that the defendant sought the affray and armed himself for it, and that he had been faulty in calling Mr. Austen the father, opprobrious names in the newspaper. As to the affray being sought by the defendant, there is no evidence to support such an assertion, but what arises from his conversations with Mr. Richardson and Mr. Whitman, or from the fact of his having a pistol in his pocket. These only prove that he was prepared to defend himself if attacked, and if he did defend himself lawfully, this is the best evidence to show what was his intention. It cannot be presumed that he took the pistol with an unlawful intent, when he never expressed such intent, and when his subsequent conduct was lawful. He had been informed that he should be attacked by a bully. In such case was his duty? Was he bound to shut himself up in his own house? Was he bound to hire a guard? If he had done so, this would have been urged as the strongest evidence of his intention to commit an affray. Could he obtain surety of the peace from a future assailant, whose name was unknown to him? Or was he bound to go about his business, constitutionally feeble and unarmed, at the peril of his life? There would be more color for this suggestion if the defendant had gone on the exchange and there insulted either old Mr. Austen or his son, or voluntarily engaged in altercation with either of them. But he went peaceably about his ordinary business, and made use of his weapon only when an unavoidable necessity happened. A man, when about to travel a road infested with robbers, lawfully arms himself with pistols. If he should be attacked by a robber, and from necessity kill him, is he to be charged with having sought this necessity, because he voluntarily undertook the journey, knowing the danger that attended it, and took weapons to defend himself against it? As little is the defendant to be censured for going about his ordinary business, when he knew that it would be attended with danger in arming himself for defense, in case such an emergency should happen, as that the laws could not afford him protection. I have here supposed that the pistol was taken for the purpose for which it was used. This, however, is far from being certain from the evidence, as it is in proof that the defendant had daily occasion for pistols in passing between Boston and Medford, a road that has been thought attended with some danger of robbery, and that he sometimes carried pistols in his pocket. There is not the least pretense for saying that he expected an affray with young Mr. Austen. He could not presume that his father would employ him, and it is not probable that he knew in the confusion that the sudden attack must have produced. As to the publication in the newspaper against old Mr. Austen, though this might be in some sense a fault, it is far from being within the principle established by the books. When it is said the party must be without fault, it is evidence that nothing more is meant than that he must be without fault in that particular transaction. If we are to leave this and look back, where are we to stop? Are we to go through the life of the party to examine his conduct? If the defendant had libelled Mr. Austen, that was a previous and distinct offence, for which he was and yet is liable to an action or an indictment, and unless it be presumed without evidence and against all probability that it was intended to produce this affray, it can have no connection with the principle stated. There is another obvious motive for it, and there is nothing in the evidence tending to convince you that it was intended to provoke an attack. The defendant had been defamed. Retaliation was the natural punishment, and there is no reason to presume that anything more was intended, unless it was to blunt the shafts of calumny from Mr. Austen by destroying his credit and standing in society. It is true that it is said by several respectable compilers of law that the party killing must be without fault, but they all refer to one adjudged case, which is found stated in 1 Hawkins PC 440, and by recurring to the statement of this case, it appears that the persons who killed, and would have excused it on the ground of necessary self-defense, had forcibly entered and seized the rightful owner of a house, and continued forcibly to detain it against him. in an attempt by the owner forcibly to recover possession. Those who held wrongfully were reduced to the necessity of killing, and it was holden that, as they were then engaged in an unlawful act, namely, forcibly detaining the house against him who had a right to enter, they had produced this necessity by their own wrongful conduct, and therefore it should not excuse them. So that this principle seems to be related to another, and in reality to be involved in it. I mean the well-known principle that he who kills another by accident while performing an unlawful act should be guilty of manslaughter. It would be absurd that a man who kills by accident while performing an unlawful act should be guilty of manslaughter, and yet he who kills from design while performing an unlawful act, however necessary it may have become, should be guiltless. It is settled that if on a sudden affray, A makes an assault on B, and afterwards the assaulter be driven to the wall so that he can retreat no farther, and then kill B necessarily in his own defense, that is excusable homicide in A. And yet here A was in fault in this very affray by making the first assault, but having afterwards retreated as far as he could, the law extends to him the right of self-defense. This shows that unless at the moment of killing the party be doing wrong, the principle contended for on the other side does not apply. In proof of this, I will also read to you an authority from 1 Hales PC 479. There is malice between A and B. They meet casually. A assaults B and drives him to the wall. B in his own defense kills A. This is se defendendo, and shall not be heightened by the form of malice into murder or homicide at large, but was not a killing on a form of malice, but upon a necessity imposed upon him by the assault of A. A assaults B, and B presently thereupon strikes A without flight, whereof A dies. This is manslaughter in B, and not se defendendo. But if B strikes A again, but not mortally, and blows pass between them, and at length B retires to the wall, and being pressed upon by A, gives him a mortal wound whereof A dies, there is only homicide se defendendo, although that B had given divers other strokes that were not mortal before he retired to the wall, or as far as he could. But now suppose that A by malice makes a sudden assault upon B, who strikes again in pursuing hard upon A. A retreats to the wall, and in saving his own life, kills B. Some have said this to be murder, and not se defendendo, because A gave the first assault. Crop Fall 22b, grounding upon the book of 3 Edward 3, Itinerary North Corona, 287. But Mr. Dalton, ubi subra, thinketh it to be se defendendo, though A made the first assault either with or without malice, and then retreated. I am bound in candor to add that the law, as above laid down on the authority of Dalton, has since been doubted as to that part of it which supposes previous malice. This passage has been reviewed by Hawkins and East in their several treatises on common law, and I have chosen it to read from this very circumstance, because it appears that it has been well considered, and when subsequent and eminent writers on full examination reject a part and admit the residue to be law, it is strong confirmation of that residue. It is that alone on which I rely, and it is amply sufficient to prove what I have before stated, that if A first assault B on a sudden affray without malice, A may still excuse killing B from a subsequent necessity in his own defense, and yet none will deny the first assaulting B, though without malice, was a fault. On this point I submit to your consideration one further remark. The publication in the newspaper is nothing more than provoking language. Now, if the defendant had immediately before the affray made use of the same language to old Mr. Austen. No lawyer will pretend that this would have been such a fault as would have precluded the defendant from excusing himself for the subsequent necessary killing on the principle of self-defense. If it were so, we should find it so stated in books of authority that treat on this subject, but the case must often have happened as provoking language generally precedes blows. On the contrary, we find it settled that even making the first assault does not deprive the party of this defense. It would be absurd then to say that rude and offensive language, which cannot even justify an assault, should produce this effect. It can hardly be necessary to add that, if these words spoken at the moment would not have deprived the defendant of this defense, having published them before in a newspaper cannot produce this consequence. I have hitherto admitted that the publication in the newspaper was a fault in the defendant, nor am I disposed entirely to justify it. Its circumstances existed which went far to extenuate it. It had been defamed on a subject, the delicacy of which, perhaps, will not be understood by you, as you are not lawyers, without some explanation. Exciting persons to bring suits is an infamous offense, for which a lawyer is liable to indictment, and to be turned away from the bar. It is so fatal to the reputation of a lawyer that it is wounding him in the nicest point to charge him with it. It is the point of honor, and charging him with barratry or stirring up suits is like calling a soldier a coward. Mr. Austen, the father, had accused the defendant publicly of this offense, respecting a transition in which his conduct had been punctiliously correct. The defendant first applied to him in person, and with good temper, to retract the charge. Afterwards, in conversation with Mr. Welsh, Mr. Austen acknowledged the accusation to be false, and promised to contradict it publicly as he had made it. Yet he neglected to do it. Again he said he had done it, but the fact appeared to be otherwise. This induced the defendant to demand a denial of it in writing. Though Mr. Austen privately acknowledged he had injured Mr. Selfridge, yet he refused to make him an adequate recompense, when he neglected to make the denial as public as the charge. This was a state of war between them upon this subject, in which the more the defendant annoyed his enemy, the less power he had to hurt him. It was therefore a species of self-defense, and Mr. Austen, who had first been guilty of defamation, perhaps had little cause to complain. To try the correctness of this, we will imagine an extreme case. Suppose a man should have established his reputation as a common slanderer and calumniator by libeling the most virtuous and eminent characters of his country, from Washington and Adams down through the whole list of American patriots. Suppose such a one to have stood for 20 years in the kennel and thrown mud at every well-dressed passenger. Suppose him to have published libels until this style of defamation has become as notorious as his face. Would not everyone that such conduct was some excuse for bespattering him in turn? I do not apply this to any individual, but it is a strong case to try a principle. And if such conduct would amount almost to a justification of him who should retaliate, will not the slander of Mr. Austen against Mr. Selfridge furnish some excuse for him? It has also been stated to you, gentlemen, and some books have been read to prove it, that a man cannot be justified or excused in killing another in his own defense, unless a felony was attempted or intended. Some confusion seems to have been produced by this, which I will attempt to dissipate. It has been settled that if a felony be attempted, the party injured may kill the offender without retreating as far as he safely can, but that if the offense intended be not a felony, he cannot excuse the killing in his own defense, unless he so retreat, provided circumstances will permit. On this principle, all the books that have been read to this point may easily be reconciled, but the position contended for by the opposing counsel is in direct contradiction to one authority which they themselves have read in the 4th volume of Blackstone's Commentaries, page 185. The law is laid down as follows. The party assaulted must therefore flee as far as he conveniently can, either by reason of some wall, ditch, or other impediment, or as far as the fierceness of the assault will permit him, for it may be so fierce as not to allow him to yield a step, without manifest danger of his life or enormous bodily harm, and then in his defense he may kill his assailant instantly, and this is the doctrine of universal justice. And now I am to consider homicide se defendendo, which seems to be where one, who has no other possible means of preserving his life, from one who combats with him on a sudden quarrel, or of defending his person from one who attempts to beat him, especially if such attempt be made upon him in his own house, kills the person by whom he is reduced to such an inevitable necessity. From these two highly respectable authorities, it appears that, though nothing more be attempted than to do great bodily injury, or even to beat a man, and there be no possibility of avoiding it, but by killing the assailant, it is excusable so to do, when the weight and strength of the cane, or rather cudgel, which the deceased selected, is considered, and the violence with which it was used, can it be doubted that great bodily harm would have been the consequence if Selfridge had not defended himself? The difference between this weapon and the pistol made use of by the defendant perhaps is greatly exaggerated by the imagination. The danger from the former might be nearly as great as from the latter. When a pistol is discharged at a man in a moment of confusion and agitation, it is very uncertain whether it will take effect at all. And if it should, the chances are perhaps 4 to 1 that the wound will not be mortal. Still further, when the pistol is once discharged, it is of little or no use, but with the cane a man, within reach of his object, can hardly miss him, and if the first blow should prove ineffectual, he can repeat his strokes until he has destroyed his enemy. If it were intended to excite contempt for the laws of the country, a more effectual method could hardly be taken than to tell a man who has a soul within him that if one attempts to rob him of a $10 bill, this is a felony, and therefore esteemed by the law an injury of so exaggerated a nature that he may lawfully kill the aggressor, but that, if the same man should whip and kick him on the public exchange, this is only a trespass, to which he is bound to submit rather than put in jeopardy the life of the assailant, and the laws will recompense him in damages. Imagine that you read in a Washington newspaper that on a certain day, immediately on the rising of Congress, Mr. A. of Virginia called Mr. B. of Massachusetts a scoundrel for voting against his resolution, and proceeded deliberately to cut off his ears. Mr. B. was armed with a good sword cane, but observed that his duty as a citizen forbade him to endanger the life of Mr. A., but that cutting off a man's ears was by law no felony, and he had read in law books that courts of justice were the only proper vindici injuriarum, and that he doubted not that by means of a lawsuit he should obtain a reasonable compensation for his ears. What are the emotions excited in your breasts at this supposed indignity and exemplary patience of the representative of your country? Would you bow to him with profound respect on his return? Or rather would not his dignity and usefulness by universal consent be lost forever? We have now taken a view of the facts and the positive rules of law that apply to them, and it is submitted to you with great confidence that the defendant has brought himself within the strictest rules and completely substantiated his defense by showing that he was under a terrible necessity of doing the act, and that by law he is excused. It must have occurred to you, however, in the course of this investigation, that our law has not been abundant in its provisions for protecting a man from gross insult and disgrace. Indeed, it was hardly to be expected that the sturdy hunters who laid the foundations of the common law would be very refined in their notions. There is in truth much intrinsic difficulty in legislating on this subject. Laws must be made to operate equally on all members of the community, and such is the difference in the situations and feelings of men that no general rule on this subject can properly apply to all. That which is an irreparable injury to one man, and which he would feel himself bound to repel even by the instantaneous death of the aggressor, or by his own, would be a very trivial misfortune to another. There are men in every civilized community whose happiness and usefulness would be forever destroyed by a beating, which another member of the same community would voluntarily receive for a $5 bill. Were the laws to authorize a man of elevated mind and refined feelings of honor to defend himself from indignity by the death of the aggressor, they must at the same time furnish an excuse to the meanest chimney sweeper in the country for punishing his sooty companion, who should fillip him on the cheek by instantly thrusting his scraper into his belly. But it is too much to conclude from this difficulty in stating exceptions to the general rule that extreme cases do not furnish them. It is vain and worse than vain to prescribe laws to a community which will require a dereliction of all dignity of character and subject the most elevated to outrages from the most vile. If such laws did exist, the best that could be hoped would be that they would be broken. Extreme cases are in their nature exceptions to all rules, and when a good citizen says that, the law not having specified them, he must have a right to use his own discretion on the subject. He only treats the law of his country in the same manner in which every Christian necessarily treats the precepts of his religion. The law of his master is, resist not evil. If a man smite thee on one cheek, turn to him the other also. No exceptions to these rules are stated. It does not every rational Christian necessarily make them. I have been led to make these observations, not because I think them necessary in the defense of Mr. Selfridge, but because I will have no voluntary agency in degrading the spirit of my country. The greatest of all public calamities would be pusillanimous spirit, that would tamely surrender personal dignity to every invader. The opposing counsel have read to you from books of acknowledged authority that the right of self-defense was not given by the law of civil society, and that law cannot take it away. It is founded, then, on the law of nature, which is of higher authority than any human institution. This law enjoins us to be useful in proportion to our capacities, to protect the powers of being useful by all means that nature has given us, and to secure our own happiness as well as that of others. These sacred precepts cannot be obeyed without securing to ourselves the respect of others. Surely, I need not say to you that the man who is daily beaten on the public exchange cannot retain his standing in society by recurring to the laws. Recovering daily damages will rather aggravate the contempt that the community will heap upon him, nor need I say that when a man has patiently suffered one beating, he has almost ensured a repetition of the insult. It is a most serious calamity for a man of high qualifications for usefulness and delicate sense of honor to be driven to such a crisis. Should it become inevitable, he is bound to meet it like a man, to summon all the energies of the soul, rise above ordinary maxims, poise himself on his own magnanimity, and hold himself responsible only to his God. Whatever may be the consequences, he is bound to bear them, to stand like Mount Atlas, when storms and tempests thunder on its brow, and oceans break their billows at his feet. Do not believe that I am inculcating opinions tending to disturb the peace of society. On the contrary, they are the only principles that can preserve it. It is more dangerous for the laws to give security to a man disposed to commit outrages on the person of his fellow citizens than to authorize those who must otherwise meet irreparable injury to defend themselves at every hazard. Men of eminent talents and virtues on whose exertions in perilous times the honor and happiness of their country must depend, will always be liable to be degraded by every daring miscreant, if they cannot defend themselves from personal insult and outrage. Men of this description must always feel that to submit to degradation and dishonor is impossible. Nor is this feeling confined to men of that eminent grade. We have thousands in our country who possess this spirit, and without them we should soon deservedly cease to exist as an independent nation. I respect the laws of my country, and revere the precepts of our holy religion. I should shudder at shedding human blood. I would practice moderation and forbearance to avoid so terrible a calamity. Yet, should I ever be driven to that impassable point, where degradation and disgrace begin, may this arm shrink palsied from its socket, if I fail to defend my own honor. It has been intimated that the principles of Christianity condemn the defendant. If he is to be tried by this law, he certainly has a right to avail himself of one of its fundamental principles. I call on you then to do to him, as in similar circumstances you would expect others to do to you. Change situations for a moment and ask yourselves, what would you have done if attacked as he was? And instead of being necessitated to act at the moment and without reflection, take time to deliberate. Permit me to state for you your train of thought. You would say to this man who attacks me, appears young, athletic, active, and violent. I am feeble and incapable of resisting him. He has a heavy cane, which is undoubtedly a strong one, as he had leisure to select it for the purpose. He may intend to kill me. He may, from the violence of his passion, destroy me without intending it. He may maim or greatly injure me. By beating me, he must disgrace me. This alone destroys all my prospects, all my happiness, and all my usefulness. Where shall I fly when thus rendered contemptible? Shall I go abroad? Everyone will point at me the finger of scorn. Shall I go home? My children, I have taught them to shrink from dishonor. Will they call me father? What is life to me after suffering this outrage? Why should I endure this accumulated wretchedness, which is worse than death, rather than to put in hazard the life of my enemy? Ask yourselves whether you would not make use of any weapon that might be within your power to repel the injury, and if it should happen to be a pistol, might you not, with sincere feelings of piety, call on the Father of mercies to direct the stroke? While we reverence the precepts of Christianity, let us not make them void by impracticable construction. They cannot be set in opposition to the law of our nature. They are a second edition of that law. They both proceed from the same author. Gentlemen, all that is dear to the defendant in his future life is by the law of his country placed in your power. He cheerfully leaves it there. Hitherto he has suffered all that his duty as a good citizen required, with fortitude and patience, and if more be yet in store for him, he will exhibit to his accusers an example of patient submission to the laws. Yet permit me to say in concluding his defense that he feels full confidence that your verdict will terminate his sufferings. End of section 58. Section 59 of American State Trials, Volume 2. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 2 by John D. Lawson. Trial of Thomas O. Selfridge for the killing of Charles Austin, Boston, Massachusetts, 1806, Part 10. The Attorney General. Gentlemen of the jury, it is my official duty to close this cause on the part of the government. If I can perform this duty by a simple, accurate, and intelligible arrangement of the facts, and a just and pertinent application of the legal principles which they are governed, I shall be satisfied. I will not play the orator before you, or pretend to make a speech if I was capable. I would not do it on this occasion. Circumstanced as I am, nothing but my duty could induce me to undertake the task. No pecuniary reward could engage me in the cause. Nothing, I repeat it, but the sense I have of my official duty and a compliance with the public expectation could induce me to appear this day before you on this occasion. But I thank God that through a course of what may be called a long life, I have had firmness to do my duty when I had a duty to do. The prosecution of this cause on the part of the government has been conducted in every respect similar to prosecutions in other cases on like occasions. When it was said that one of our fellow citizens in the open street at noonday had undertaken to destroy the life of another, it was necessary to inquire by what authority he did it, what legal process or warrant of law he had, but conduct of such consequence to the public, as well as to an individual citizen. Is there any cause of wonder that on the day it happened, he should be apprehended and carried before a magistrate, who exercised the same power in this particular as he would have been obliged to do had it been the case of either you gentlemen of the jury or any other member of the community? The magistrate found the killing to have been voluntary and not occasioned by any accident. What ought the magistrate to do? Was he to undertake to decide the difficulties which you have to encounter in this case? Was he to undertake to say that the act of the killing amounted to murder or manslaughter, or to justifiable or excusable homicide? The magistrate was bound to commit him to take his trial, to which he is now brought. Was there anything wrong in this? If there was, he had the remedy in his own power. The Supreme Court, upon a habeas corpus, might have set him at liberty. It is a writ of right, and would have been granted if by law it ought, as of course if he had applied for it. If he chose to decline the application and lay in prison, he had his reasons for it. He as a lawyer must have known the consequences. Would not every other man in the community have had to suffer a like inconvenience with that sustained by the defendant under similar circumstances? Certainly they would. Why then this warm and eloquent address to the passions and feelings of the public? Do they expect to influence you, gentlemen of the jury, and divert your attention from the justice of the case by an appeal to the feebleness of his health and the weakness of his person? Is it to injure the reputation of the officer who, ex officio, moved the commitment of the defendant to prison, that his counsel apply to your compassion and tender feelings? Be it so, but I hope that I shall continue conscientiously to discharge the duties of my public function, regardless of every other consideration than that of the duty which I owe the Commonwealth. It is said that a great crowd has attended the court during this trial, and we are asked the reason. Many, I suppose, attend from curiosity. Is it to be wondered at that a crowd attended also at the exchange on the day that the defendant shot the young man in State Street? The human mind naturally shudders at death, and when a man destroys his fellow citizen, it naturally draws the attention of all men to the fact. The insinuation respecting a crowd in this courtroom seems to glance at party spirit, but had party spirit anything to do with the crowd that assembled on the exchange? When one man has struck another out of being, so far as being depends upon his existence in this world, is it marvelous that the public attention should be on tiptoe on this occasion? Is the agitation anything more than the effect of nature's laws? Is it anything more than the uniform principle of our holy revealed religion? Is it not the voice of God? It is true, when the crowd assembled in State Street, an inquiry was made, who was the man that did this? The defendant boldly stood forth and said, I am the man. And it appears that he raised himself in the middle of the crowd to make the declaration. He had courage in the midst of this universal cry of who is the man that has done this, to stand forth and avow himself the perpetrator. But courage is not the criterion of truth. This firmness of nerve, this unexampled boldness has not changed the nature of the crime, nor can give it us the law to govern the fact. Does the definition of an offense or the rights of men in civil society depend on the character of individuals or the different constitutions of men? The question before you is this: has the government produced evidence to convince you beyond a reasonable doubt that the defendant killed Charles Austin in the manner and form as set forth in the indictment? If you are satisfied of this question, then the burden of this cause has devolved upon you, and you must undertake it, whatever may be the consequences. If you are not satisfied of this fact, there is no further inquiry to be made. But if you are, then there is a second question. Has the defendant shown you beyond a reasonable doubt that the fact of killing, independent of any previous circumstances against him, attached to it, was done in such a manner as will render the killing lawful and excuse him from any share of guilt? Why this devolves upon him, I will show from an authority in which it is better expressed than I can express it in my own language. Faust, CL 255. In every charge of murder, the fact of killing being first proved, all circumstances of accident, necessity, or infirmity are to be satisfactorily proved by the prisoner, unless they arise out of the evidence produced against him. For the law presumeth the fact to have been founded in malice, until the contrary appeareth. And very right it is that the law should so presume. The defendant in this instance standeth upon just the same foot that every other defendant doth. The matters tending to justify, excuse, or alleviate must appear in evidence before he can avail himself of them. And why must it devolve upon him? Because if he had a legal warrant, he could produce it, whether there was malice or not. In killing, upon any legal authority, depends upon the feelings of the heart, and no man can be so well acquainted with them as the person who perpetrates the act. I will adduce another authority to the same point from 1 East CL 224. The implication of malice arises in every instance of homicide, amounting in point of law to murder, and in every charge of murder, the fact of killing be first proved, all the circumstances of accident, necessity, or infirmity are to be satisfactorily proved by the prisoner, unless they arise out of the evidence produced against him. The question you have before you is, whether the defendant has proved either accident or necessity, as fully as the government has proved the fact of killing. If he has not, he is guilty of the homicide charged in the indictment. Has he proved circumstances that will reduce it to excusable homicide, or that he has done nothing but what he had a right to do? If there was any premeditation, a share of blame attaches itself to the fact, though it were but momentary. The law makes it a crime in that case, and it cannot be less than manslaughter. But if the defendant has proved beyond a reasonable doubt by the evidence he has offered, or what arose out of the evidence offered on the part of the government, that the fact of killing, in the manner it was committed, independent of any previous circumstances attached to it, or explanatory of it, was excusable homicide. Yet if the government has given convincing proof of a premeditation, his excuse cannot avail him. First, have we proved the fact of killing? That is admitted to be proved beyond doubt. And you have secondly to inquire whether the defendant has given evidence to justify what he has done, or to show it to be excusable from a legal necessity. Thirdly, You will inquire whether the government has given evidence of such facts and circumstances previous to the transaction as will take from the defendant all his claim of excuse and render him guilty of a felonious homicide. These three questions include every fact and every principle of law that can arise in the cause. They will embrace and call into examination every circumstance which has been given in evidence by the witnesses, and every principle of law by which the facts are to be governed and decided upon. This cause is an important one, and presents to our discussion a question of principles. It is of no consequence who are the parties, or what the facts are, on which the issue rests, otherwise than to call into examination the principles that are to guide you to a verdict. It would be desirable to lay out of the question the persons of the deceased and the defendant, and to consider the cause in the abstract, as if between persons of whom you had never before heard. The principles on which this cause is to be tried must stand or fall by themselves, without any regard to the parties. The principles on which the issue rests must be fixed and determined. Without fixed and permanent principles, religion itself is a delusion. Morality is a cheat. Politics are a source of oppression and cruelty, and the forms of law the vehicle of corruption, the mask of chicane and injustice. Principles are no other but the primordial nature of things upon which systems are predicated for the use and happiness of rational nature. Without those, all is insecurity and confusion. The world is a waste, society is a curse, and life itself but a dream of misery. While religion, founded in the self-existence of the deity and the relation of man to the divine nature, while morals, predicated upon the connection between man and man as brethren, while stubborn nature, fixed on eternal and unchangeable laws, deny to yield to man the inflexibility of their principles, he is left to raise for himself those systems of civil social government and jurisprudence which are best adapted to his situation and circumstances, and in this society is left to decide for itself. When the sovereign will of the civil community has arranged these, the obligation of each member to submission becomes a moral obligation. Crimes result from disobedience. To disobedience, penalties must be attached. Despotism is adapted to a state of savage barbarity, where fear is the only motive to action or forbearance. Yet even there, the will of the people, let it be founded in what it may, either in prudence or in cowardice, is the foundation of the sovereignty. A monarchy and aristocracy, mixed together to form a government, supports a state of servile dependence, where the hopes of favor and interest exclude the idea of reward for merit, bring patriotism and public virtue into base contempt, and render fraud, deceit, chicane, and cunning the insolent claimants of the rights of truth, talents, and integrity. In a free government only, it is that principles founded in the nature of social virtue can claim the decision of what is right between man and man, or between an individual and civil society, without the corruptions arising from the destruction or irregularity of rights and privileges, from party distinctions, from the frauds of chicanery, incident to factitious morals, and cunningly devised systems of religion and policy. I will not spend any more of your time by such an appeal as has been made by the counsel for the defendant, who have preceded me. I will not invoke you to put aside your prejudices, if you have any. An appeal on this head is altogether nugatory, for if you will not obey the obligation which devolves upon you, from your situation resting on your consciences by the sacred solemnity of an oath, you are not to be reasoned into it by the powers of rhetoric. I therefore consider it as improper to attempt it. I conceive that it must necessarily follow from the circumstances of your situation that a verdict will be given upon the facts according to the rules of law. To a jury acquainted with the obligations of an oath, a caution against being led astray by their prejudices is to caution them against acting corruptly and against doing willfully wrong. If their oath cannot guide their consciences, I should despair of guiding them by anything that I can say. I should have spared myself these observations as altogether irrelevant to the issue, had not the defendant's counsel gone largely and learnedly into the subject, and urged you to do your duty free from the influence of party prejudices, regardless of the clamors of newspaper writers or addresses to the people. In this caution, the counsel for the government heartily concur. The misconduct of newspapers in publishing matters relative to a trial, while it is pending, is to be deprecated. So is all conversation tending to spread false reports. Yet such are the feelings of mankind throughout the world that they will talk and also print on such subjects where the press is free. It is one of those alloys which mingle with the precious metals. Better it is to enjoy the freedom of the press, though attended with this inconvenience, than to restrain it by governmental laws, as is the case in every other country. The impressions made in that way are very inconsiderable. The enlightened minds of this jury are above all considerations. Arising from that source, whatever you may have heard out of doors is left at the threshold of this sanctuary of justice, and passes by like the idle wind, and is no more regarded than the whistling of a schoolboy, trudging along with his satchel in his hand. As the report of this cause will probably be published, the world will judge how far your decision is made up from the testimony you have heard at this bar. They will know how to estimate the various reports you have heard, and the newspaper clamors, and the artfully devised handbills. These, with the papers themselves, will be consigned ultimately to the neglect they deserve. One man has killed another. The laws of God and of our government call upon you to inquire if he can excuse himself. This is no light subject. There is an omniscient judge, before whose seat we shall all appear to answer for our conduct on this solemn day. We must therefore decide with purity and integrity, if we expect to avoid the judgment pronounced against those who corrupt the tribunals of human justice. I will place a mirror before your eyes, by which each of us can compare the fairness and justice of his intentions in the case, and perceive how far he is misled by his prejudices or political principles. Suppose the slander which is said to be traced to the father of the deceased was correct, and suppose B. Austin to have gone forth armed with a deadly weapon in expectation of an assault from Selfridge or his friends, that Selfridge had made an attack on him, as young Austin did on Selfridge, and Austin the father had, with the weapon carried as Selfridge carried his, killed him at noonday in a crowded street. What would be your verdict on such a case? I flatter myself your verdict will be the same as that which you will give in this cause. This is the standard of security. This is the solid tenure by which our fellow citizens hold their equal right to public justice, ensured to us by our Constitution and our laws. End of section 59. Section 60 of American State Trials, Volume 2. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 2 by John D. Lawson. Trial of Thomas O. Selfridge for the killing of Charles Austin. Boston, Massachusetts, 1806, Part 11. The counsel for the defendant has addressed you with warmth and energy, as a politician. He supposes you to consist of two conflicting parties, and with elegance of manner and strength of language peculiar to himself, he has conjured you to lay aside all political impressions, whether they be favorable to the federal Republican or Democratic Party. He particularly addressed himself to those who are of the same way of thinking as himself. I will imitate him in some degree, but I will address you as being all of the same way of thinking as myself, for I believe none of you wish to subvert the government or infringe the law. If then you mean to support our happy Constitution and obey the dictates of our holy religion, you are of the same party as myself. Would you break up the foundation of the great deep and destroy the basis of the present federal government, and leave it to chance when or how we should obtain another? You may think the present Constitution might be made better, but it might be made worse, and though, like other human inventions, it has its imperfections, you would not necessarily encounter the hazard. I say, then, you are all of my party. If you prefer our democratic government to a monarchy, an aristocracy, or a mixed government, then we all think alike. Is there one of you who would alter our system of jurisprudence, or relinquish the inestimable right of trial by jury? If there is not, then, you all think as I do. If there is one of you who thinks the millions of money expended at the city of Washington in the public buildings and improvements for the accommodation of the general government, which serves to tie the several states of this continent in the indissoluble knot of perpetual union and amity, if you think that money well employed is a mean of producing that grand effect, I think so also. Is there one of you but believes that State House on Beacon Hill was intended for and will produce the happy purpose of combining the interests of the several parts of the state of Massachusetts? Although attended with expense, it may prove a blessing. All of you join in this belief. I also am of your opinion. The gentlemen who are strangers and reporting this cause will pardon me for being so local. They are not perhaps acquainted with our domestic politics, but I love and feel for my native state, and the circumstance I have alluded to has been of importance. If you think of your union at home and our foreign relations, as Washington the Great and Good thought, and as he has written in his farewell address to the citizens of the United States, you will engrave it on the tablet of your memory, teach it to your children, and bind it as a talisman to your heart, in order to perpetuate the freedom of our common country to the end of time. Is there one of you who would engage your country in foreign wars in order to benefit a few great men who would become the leaders, as they have been the agitators of such a desperate measure? The consequences of war are known to many who hear me. Never more do I wish to see the parched earth of my country drenched with the blood of my fellow men, the tender mothers, wives, and children flying from their dwellings into the wilderness to escape the foe. You, gentlemen of the jury, are friends to the peace of your country, and therein I cordially join with you. I address you as the lovers of your country, and there is no difference in our opinions. To return from this episode to the question in the cause, I will proceed to inquire whether the fact of T.O. Selfridge's killing young Austin is proved by the government. That catastrophe has been clearly made manifest by the testimony of Dr. Danforth, Edward Howe, John Lane, Ichabod Frost, Isaac Warren, and many others. I will not attempt an argument on it. The second question is, has the defendant shown you, beyond a reasonable doubt, that the fact of killing was done under such circumstances as that it was lawful, and he is excusable of blame? In this inquiry, and certainly it is an important one, we must have some guide, some settled rule, some law, some known established principles, or society no longer exists. A confused state of nature reigns. Every man's arm, his art, or his cunning is his own safety, and every man is the avenger of his own wrongs. Had I the sentiments expressed by my learned brother Dexter, feeble and imbecile as I am, I would go forth from day to day in arms, trusting in mine own arm alone, with the aid of such weapons as my strength would bear. Magistrates should be avoided, and the volumes of laws become pavement for the soles of my shoes. Many things are said by the professional men in the feelings and warmth of debate, which, in their cooler moments, they would gladly retract. Upon the manner and measure of resentment or self-defense, is there no law fixed, but the different feelings of men? Are there men, nay, a multitude of men, who have a natural right, from their feelings and a high sense of honor, to defend themselves when and where others of less feelings could not do it in the same manner? And is this the voice of nature which makes the exception? Is this sense of honor and those feelings a privileged exception to those individuals above the rules of the gospel? Is the rule, do to others as you would be done unto, reduced to the standard that a juror shall acquit the defendant if he believes he should have acted himself by the same motives, or been seduced by the same temptation? Is there then a distinction between the would-be nobleman and the chimney sweeper? For I suppose these from the distinction taken by the defendant's counsel to the alpha and omega, the head and the tail, of the links that form civil society. Is there a distinction between them as to the privilege of self-defense? And is the push of the sweep, or a stroke with the scraper, at the head of his comrade to be murder in him, whilst the would-be noble shall be allowed with his gold-hilted cane, or his elegantly mounted pistol in defense of his honor, to play a secure but mortal game, and be justified in killing, on a like provocation, either his friend or his foe, or, as in this case, a man he is said hardly to know? You are not then to determine his case by the circumstances attending it, but by the nice sense of honor of the gentleman, or the distinction and dignity of his station in life. What then has become of that part of the Constitution which declares ours to be a government of laws and not of men? If the law does not apply equally to A and B, and so through every letter of the alphabet, how can it be said that every man holds his life and fortune by the same tenure as his fellow citizens, whatever may be his rank or his condition or standing in society? We are told that there are a number of men in society who will, with their own arm, vindicate their rights and stand the guardians of their own honor. There may be such men, but I do not know them. I hope I shall not meet with any citizen who does not rely for his safety on the laws of the government and the justice of civil society. But we are told that the laws of Christianity lend us a defense by our own arm, and we are asked how then the laws of society can regulate this matter. I do not admit this position to be just. All men are bound to surrender their natural rights upon entering into civil society, and the laws become the guardians of the equal rights of all men. Why are duels criminal if the men who engage in them have this privilege of maintaining their own honor? It is said the defendant was driven to such an awful crisis that he could not extricate his honor, and his counsel asked, what could he do? I answer, appeal to the laws. But say they, the laws are ineffectual. Suits are slow of remedy, and uncertain in their end. Where would such reasoning lead us? You have it in testimony that the defendant reasoned in this way, and that mode of reasoning brought on this sad event. You have heard his counsel in a strain of eloquence advance the same idea and make a personal application of the principle. No man, said he, is bound to surrender his own honor. If I do, I wish my arm may be shriveled by the palsy and dropped from its socket. No, I will vindicate mine own honor to the death. I would rather that he should retain the use of his limbs, as well as the faculties of his mind, in order to employ them in the true field of honor, the defense of his country, when necessity may require their exertion. The defendant's counsel are obliged to adopt the same erroneous course of reasoning in order to justify him. Have we then, as a civil society, higher authorities than our own law books to appeal to on such an occasion? Are they such as the counsel on the other side would not shrink from on the penalty of his life? We will not take up the glove. We will rest our defense, both of the lives and honor of our fellow citizens, upon the laws of the land. We will trust to them rather than to a deadly weapon for our protection. Such declarations as are made by the gentleman on the other side would countenance all the duels that have been fought in the world, and render unavailing all the laws that have been enacted for the punishment of illegal and savage combats. It is said that the defendant adopted this course because the tardy steps of the law were too slow to keep pace with his rapid stride to obtain immediate vengeance. What if his fame and character had been injured? Has he superior privileges? Or ought he not take the common lot of his countrymen? Has he any excuse more than others? Has he the excuse even of an officer? He is both a lawyer and a gentleman, but this does not give him a right beyond what all the individuals of this society possess. If the defendant suffers on this occasion, he will have to suffer no more than what every other person who should perpetrate a similar act must suffer, while controlled by the laws of his country. If he is innocent, he will be acquitted. If he is guilty, he will take the common lot of other men. I do not feel any interest in what your verdict may be, further than that justice in the common way and on general principles should be done. Is the measure of a man's conduct, when he leaps the bounds of written established law, to receive a standard from the feelings of his wife and children, or the notions of honor in the congregation of fashionable men? And can a man appeal to heaven in this way, and be a pious Christian? When I heard that this doctrine had been advised on this occasion by professional men, I shuddered at it. Gentlemen, not being able to fathom this abyss of troubled waters, not having the courage and firmness to cast away the guardianship of social protection and the laws, not having an imagination that can show the lines of security beyond those of the civil government, I will yet believe the laws to be fully adequate, where we have time to apply to them, and I will fondly suppose that I am, to every possible purpose, in a state of civil society and social security. The laws may be so imperfect, but human nature is so, that the remedy may be slow, and below my wishes, but I will not claim to be my own judge. I will not say that I have a right to appeal to this arm to avenge an injury, whilst the law affords me a complete remedy. The defendant's counsel asked how he could have gone home to his wife and children, with his honor stained by the blow he had received on the public exchange from young Austin. I put a case hypothetically. If a man of honor and great irritability of nerves should have received a blow, could he appeal to the laws of his country without tarnishing his honor or injuring his family? If his wife was a virtuous woman, she would applaud his moderation and be gratified in teaching her children to pursue a similar course through their future lives. No person would deem him disgraced by the blow, though he had not destroyed his adversary. If we are to return to the barbarous times so well described by Robertson in his History of Charles V, where every great man was to go armed with his trained bands behind him in order to encounter any whom he might meet, without regard to laws either human or divine. If heroism and honor and chivalry are to return, we may expect to see again those combats so well described in the well-known ballad of Chevy Chase, and this promised land flowing with milk and honey to be turned into a field of battle and crimsoned by the blood of our fellow citizens. I trust we are now too far advanced in civilization to return from the light of this day to the barbarisms of the 13th century, when the interposition of the authority of the Pope and his council became necessary in order to prohibit these misadventures. Whatever opinions we may have of the Roman Catholic religion, we are indebted to its influence for this one good deed, which all the potentates of Europe combined together could not have effected. There is something in this cause which has unnecessarily been introduced, and which I wish to lay out of the question before we proceed. The gentleman on the other side is above personalities in a cause of this importance, but he draws a picture in the darkest colors, and leaves you to point to the original. He says that someone has been standing in the gutter for 20 years past, throwing mud at every well-dressed gentleman that passed by, and that he can have no ground of complaint if he should be a little spattered himself. I ask whether, if this was true, that a man had done this, is he to be outlawed? Is he and his family to be hunted and shot down at noonday? That is not the punishment for libels. If he is to be condemned for libeling, let the innocent man among his accusers cast the first stone. I have had my share of such opprobrium, but it never came into my mind to redress myself by shooting one of my fellow citizens. He wrote against Washington, they say. So did Hamilton. He wrote against Adams and others of his administration. So did Alexander Hamilton and others. But Austin authorizes me to deny the charge of his writing against Washington. Who wrote against Hancock and Samuel Adams and Washington and all the great men who produced the Revolution? Are all those writers outlawed? If any of them were punished, it was in pursuance of the laws of the country. We have no check beyond that. Who is there of consequence enough to deserve notice, but is the object of daily slander? Does Benjamin Austin do all this? Where will these ideas carry us? Are they compatible with the elegant expostulations of both my brethren against party political prejudice? I think they would carry us back to the barbarous ages, in which case it will become necessary for every man to become an expert combatant. These ideas will, I presume, excuse robbery in those who are too proud to beg. Should we lower our notions of honor and condescend to bring our feelings to the rules of law, we should then have to inquire whether the defendant has proved beyond a reasonable doubt that the fact of killing was committed in such a manner as to render it lawful, and excuse him of all blame. In this, the first inquiry is, was the death a voluntary killing? That is to be decided by the weapon and manner. Was it by justifiable or legal warrant? Was it an accident? Was it on a sudden provocation? Was it on a sudden combat? Or was it done in pursuance of a design unlawful in itself and unjustifiable by the established laws of our government? Should you be satisfied from the opinion of the court that it is of no consequence, as the evidence is, whether the pistol was fired before a blow was given by the deceased, you will be much relieved. But if that fact should be considered as important in this case, you will then have to inquire. First, was the assault previous to the mortal wound? Second, was it at the same instant? Or, third, was it after the mortal stroke? In these inquiries, what shall guide you? Are you left to the nice feelings of a man of honor, to be decided on his apprehensions of the moment, to make a separate law in each case as it arises? Or are there established laws to guide you? The Constitution has fixed a system by which the courts of justice are to be governed. These books which have been cited contain those laws, which are laws, though they were not made by the legislative authority. They were made by the voice of the people, and this, which is the highest authority, has said that these books shall be the law of the land. For this I refer you to the 6th section of the 6th chapter of the Constitution, where it is declared that all the laws, rules, and practices in the judiciary department, which have been heretofore adopted, shall continue to be law, until they shall be altered by the general court of this Commonwealth. They were brought by your ancestors from the land of slavery. They have been wet with the mists of the Red Sea, washed in the waters of Jordan, and are now our garments of comfort in the promised land. Yes, in the promised land. You, young men, who have only heard of the Revolution, may smile at the simile, but the venerable and aged members of this community, many of whom I see around me, know what it was to have passed through the wilderness, through difficulties and dangers almost unparalleled. Those will not willingly relinquish their principles. But these rules, if the defendant entertained a grudge or ill will against the father of the deceased, can the malice in such a case be transferred to the son? If it should appear that the defendant went out armed with a deadly weapon, with an expectation of beating the elder Mr. Austen, and did therefore kill the son, it would be such a malice as to constitute the crime of manslaughter at least. Now we come to an examination of the testimony which has been laid before you, and from which you will have to determine the degree of guilt incurred by the defendant. Was the assault of young Austen made upon Selfridge previously to the firing of the pistol, that instrument which gave the mortal wound? To this point we had the testimony of John M. Lane and Joe Bass. I will make one or two observations on Lane's evidence. Mr. Lane said he was standing in the shop door and saw Selfridge fire the pistol, and the person who was fired at raised the stick and struck at Selfridge after the pistol was discharged. The evidence of shooting before the blow is from the testimony of Bass and Lane. Howe, Frost, and others say they did not see any blow struck before the pistol was fired, but perhaps these two witnesses will be sufficient to satisfy your minds that the deadly wound was given before a blow was struck. And there is a distinction in law between an assault and battery. The counsel for the defendant have attempted to disparage the testimony of Mr. Lane without intending to impeach his moral character. Mr. Lane's standing in society is above imputations of that sort. For my part, I am astonished that the circumstances of this case should not have been attended with greater variations than they appear to have from the witnesses on both sides. It is an extraordinary thing in a scuffle of this kind, at noonday, on the public exchange, done on the sudden, that the testimony should come so near together as they do in respect to the time, place, etc. I shall not, however, insist that the pistol was fired before the assault was made. I come now to the second question, whether the killing and the blow were at the same instant of time, and here you have the testimony of a number of witnesses to prove that both happened at the same moment. I do not deny that from their testimonies an assault may be inferred, and that there was an intention on the part of young Mr. Austen to commit a battery, but I do deny that it was such an assault as would justify the defendant in putting the assailant to death with a deadly mortal weapon prepared and charged on premeditation for the purpose. I now come to the consideration of another point, that the blow was given by Mr. Austen before the defendant gave the mortal wound. On this head you have only the solitary testimony of Lewis Glover. I know nothing of his prejudices or party feelings, but he is quite a stranger to me. While on the stand, he told you that he had expected something would take place in the course of the day between Selfridge and Austen, the father of the deceased, that he meant to amuse himself by attending the exhibition. As in former days the Romans had gladiators to amuse the public, so this witness watched the parties that he might see them sink below the character of men. He owns, however, that he might have been better employed. There I agree with him. I think he would have been better employed if he had gone to a magistrate and apprised him of his suspicions, in which case the magistrate would have taken a necessary precaution to prevent the town of Boston being disgraced by actions of this kind. He says that he saw the deceased give one violent blow, which struck Selfridge on the hat, that he recovered his cane in order to repeat the stroke, and that the second blow and pistol went together. This, I say, is the solitary testimony of Glover, unless you take the testimony of Mr. Wigan as a corroboration of it. And even then, there are upwards of 30 others who were present at the time that know nothing of the circumstance. Mr. Wigan has said that he thought he heard a blow which sounded as if it had been struck upon a coat. Mr. Glover may be right and Mr. Wigan correct. Their stories are consistent, But Glover says the first blow was not so severe as those which followed. Therefore its sound might be softened. There is another circumstance urged in the defense as going in support of this testimony. The defendant's hat was indented and broken, and there was a contusion on his forehead. This is answered in this way. All the witnesses agree to the fact that the subsequent blows were given with increased violence, so much so that several of the witnesses thought the charge had not taken effect, or the pistol had been only loaded with powder. You have heard the opinion of the physicians, and you learn from them that a wound in the lungs is not always mortal. They have mentioned a case where a part of the lobe of the lungs has been separated and the patient survived. You have heard of animals being mortally wounded, and yet leaping from the ground with increased muscular strength 6 or 8 feet high. Similar observations must be familiar to every one of you, gentlemen. Even the worm that you crush beneath your feet springs with manifest vigor from the assault. We need no argument in support of these remarks. Give pain to a fly or a spider, and you have ocular proof. Have we not, then, very full proof that this fracture of the hat and contusion of the forehead was the consequence of one or more of the blows subsequent to the discharge of the pistol? In that case, as it must have been done after the pistol was fired, and the deceased had received his death wound, however grievous and heavy the stroke might be, it furnishes no excuse for a mortal wound previously given. I am requested to make an observation upon the testimony of young Mr. Fales, the favorite and classmate of the deceased. I do this merely because it is desired, not because it is necessary. The court and you have already seen that his testimony is correct. It is on facts which happened on the agitation of hurry and confusion, and can only be according to the best of his recollection. The defendant has brought Perkins Nichols and J. Osborne in order to discredit the testimony of young Fales. They say that they went to Mr. Austin's house, not, I apprehend, as the friends of Mr. Austin, to condole with him on the unfortunate death of his son, but to find and lay hold of any circumstance that might be beneficial at this trial, to their friend Selfridge. One of them, Mr. Nichols, made a memorandum of the conversation that had taken place, and he swears from that memorandum that Mr. Fales had said that the young man, meaning Mr. C. Austin, struck Selfridge before the pistol was fired, that at the time of this conversation Mr. Fales appeared to be extremely agitated. There are 2 other witnesses, however, who were present at the same time, that declare that they did not hear any such declaration. But suppose such a declaration had been made by Mr. Fales to the father of the deceased. Can it not be accounted for by supposing that Mr. Fales, in order to soothe the parent, who perhaps was half distracted at the horrid circumstance, that he should insinuate that his son was not wholly free from blame, and that he had struck at the defendant before the pistol was discharged? The character of that young gentleman would have been safe if I had said nothing about it. You have seen with what caution and diffidence he has delivered his testimony. It appears that his mind was in a state of confusion, occasioned by the death of his friend, and that he does not even to this day pretend to have a perfect recollection of the order of time in which the facts took place. But admitting that the assault was made by the deceased before the defendant gave the mortal wound, you will have to inquire whether it was such an assault or such a battery as would justify the defendant in killing the deceased at that time, in such a place, and in that manner, with a formed intention and with a deadly weapon. My state of health and want of strength seem to forbid my doing full justice to a cause of this magnitude. I will, however, endeavor to add something more. To do this, I return to the inquiry, whether it is of any consequence that the blow was given after or before the mortal wound. This brings us to another question, whether, if the assault was made before the discharge of the pistol, the killing in that manner, and with such a weapon, was excusable. Was the defendant in such imminent danger of his life that he was obliged to slay the deceased as the only means of saving himself? The law on this point will be found in Foster's C.L., pages 276, 277, and 278. 2 cases of self-defense are supposed. In the one, a forfeiture of goods was incurred, in the other, not. What, therefore, is the true import of the word self-defense upon chance medley, which the statute uses as description of that offense which did incur the forfeiture homicide, per importunism, which hath been styled chance medley, cannot possibly be meant, for in that case the party killing is supposed to have no intention of hurt, whereas in the case the statute mentioneth, he is presumed to have an intention to kill or do some great bodily harm at the time the death happened at least, but to have done for the preservation of his own life. The word chance medley, therefore, as it standeth in this statute, connected with self-defense, must be understood in the sense which Coke and Kelling, in the passage already cited, say was the original import of it. A sudden casual affray commenced, and carried on in heat of blood, and consequently self-defense upon chance medley must, as I apprehend, imply that the person, when engaged in a sudden affray, quitted the combat before a mortal wound be given, and retreated or fled as far as he could with safety, and then, urged by mere necessity, killed his adversary for the preservation of his own life. This case bordereth very nearly upon manslaughter, and in fact and experience the boundaries are in some instances scarcely perceivable, but in consideration of law they have been fixed. In both cases it is supposed that passion hath kindled on each side, and blows have passed between the parties. But in the case of manslaughter, it is either presumed that the combat on both sides hath continued to the time the mortal stroke was given, or that the party giving such stroke was not at that time in imminent danger of death. He therefore, who in the case of a mutual conflict would excuse himself upon the fault of self-defense, must show that before a mortal stroke given, he had declined any farther combat, and retreated as far as he could with safety, and also that he killed his adversary through mere necessity and to avoid immediate death. If he faileth in either of these circumstances, he will incur the penalties of manslaughter. End of section 60. Section 61 of American State Trials, Volume 2. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 2 by John D. Lawson. Trial of Thomas O. Selfridge for the killing of Charles Austin, Boston, Massachusetts, 1806. Part 12. Whatever may have been advanced by the counsel to the contrary in this trial, yet by all the authorities it appears that while a man may defend himself against a felonious attack, there is a difference in the law between a felonious and a simple assault, and that this difference is determined by the circumstances of each case. If a man is assaulted by another with his fist or stick, not likely to kill, the other is not justified in employing a deadly weapon to kill the assailant. This runs through all the books, and it marks the intention of the person who employs such a weapon as being malicious. What were the facts in the rencontre between the defendant and the deceased? Supposing the former to have been attacked, was he likely to have been killed? You have seen the cane with which the deceased struck Selfridge. You know the place where the affray happened, and you have heard that it was done in the presence of numerous witnesses. Is it possible that under all the circumstances of this case, the defendant can be justified by the defense in preservation of his life, or that of his person from great bodily harm? Does it not absolutely appear to you in testimony that the defendant went to the exchange with a deadly weapon, concealed in his pocket or behind him, and that he was assaulted by young Austin with a walking cane. I will not stop to inquire whether the defendant was lawfully on the exchange, though an attempt has been made to prove to you that he was there by appointment on its lawful occasions. They have produced Mr. Ingraham to show that there was an appointment to meet at the exchange, that the appointment was made on Sunday, 3rd August, to meet the next day, in order to receive an execution which the defendant was to procure for Mr. Ingraham. This, the jury will observe, was an arrangement made by the defendant subsequent to his writing the advertisement against Austin, which appeared in Monday's paper, and from the publication of which the affray is supposed to have arisen, and which he intentionally provoked by that piece of abuse. Laying aside every suspicion which may arise from these circumstances, yet we must inquire whether it was lawful for him to be there with a loaded pistol concealed in his pocket. Had he reason to apprehend, when he went on 'change, that he was in imminent danger of his life? From the testimonies of Mr. Richardson and Cabot, it does appear that this danger could have been avoided by a more prudent mode of conduct, and what was not his taking such measures, full evidence of a heart void of social duty, and so fatally bent on mischief as to be completely that kind of malice known in law under the description of malice aforethought. In the conversation he had with Cabot and Welsh, it was observed very clearly and deliberately that an attack would be made upon his person by someone employed by Mr. Austin. It does not appear, however, from the testimony that this information was correct, and the words used in the conversations were varied by the imagination of the reporter, who is one of those witnesses. He went so far in his supposition as to believe that a gentleman standing on the opposite side of the way, with a whip in his hand, was the person employed to chastise the defendant and caution the defendant against it. Selfridge replied to him with a nod and air of indifference that he was prepared for the attack. Now, gentlemen of the jury, under these circumstances, what would you do? Would you conceal a weapon to kill your antagonist, as if you would act the assassin? Or would you not say openly, "I am not good at fisticuffs, neither have I learned the art of cudgeling, but if I am attacked and my life put in jeopardy, I carry openly in my hand a loaded pistol to defend myself against any felonious attack which may be attempted, if I cannot save myself without." Gentlemen, you would not have put a deadly murderous weapon in your pocket to conceal it until the voice of death should give utterance to a municipal right. Circumstanced in this way, you would carry it openly in your hand, and by such manly, open conduct would preserve yourself from any assault. But if the defendant brought the assault upon himself, by his previous conduct in the publication of an advertisement, calling the father of the deceased a liar, scoundrel, and a coward, if he has provoked to combat by such opprobrious and abusive language, where are his grounds of defense? From the conversation he had a few minutes before with Mr. Richardson and Cabot, it is apparent that he was determined on shooting any person who might assault him in any manner, however lightly, on the exchange, that he had prepared himself for that purpose, and that he intended this 2 days before, when he purchased the lead or the shot for casting the bullet. What is the law on this premeditation? Clearly that the party was guilty of murder, that without such premeditation, if it was done on a sudden affray, the slayer is guilty of manslaughter. Will this feeble habit of body be a justification under this premeditation? A man who is a cripple and can walk only with a crutch will be privileged to arm himself with a deadly weapon in order to kill any man who may assault him. He cannot be required to retreat to the wall, because his lameness prevents him from running. The ground upon which he stands, or the crutch upon which he leans, is to him a wall, and he may shoot down his assailant. Thus the misfortune of decrepitude throws a subject into a state of nature, and raises him above the control of, or dependence on, the laws of his country. Ought not the defendant in this case to have made some attempt to retreat, or have called for help before he employed his deadly weapon in shooting the deceased? It will not be pretended that the attack was made with a felonious intent, that Austin intended to rob or to kill him. Neither did the defendant understand it in that way, for he said in the conversation with Cabot and Richardson, which I have already alluded to, that he was not good at fisticuffs or cudgeling, but had prepared himself in another way. By this it appears clearly that the defendant expected to be attacked with a whip or a cane, and that he had determined to kill anyone who assaulted him in that manner. Was not the language he had used in the scurrilous advertisement calling B. Austin a liar, a coward, and a scoundrel, such abuse as he might and did expect would be resented by a kicking or a caning? Is this reasonable view of a situation he courted? How is it possible that the defendant could apprehend any other assault than a chastisement for his insolence, not an assault with a felonious intention? Even if the defendant had reason to fear a felonious attack, was there not such a want of caution and such premeditation, such malice on a previous quarrel, as will deprive him of the excuse he would otherwise have had? Shall we go into an examination of the right of one man to kill another for a simple assault? The counsel for the defendant have advanced this doctrine. The authorities they rely on are Grecian, Hawkins, and Fourth Blackstone. Where a man is unexpectedly assaulted and kills another with a weapon he has in hand, and without time to reflect, these authorities do not infer malice from the nature of the instrument. But where a deadly weapon is prepared for the purpose, the case is widely different. Whether it was prepared for the purpose and whether it was worn as a part of dress are prime considerations in all questions of this kind. We have much law on this point. In the trial of the soldiers in this town for a homicide, which took place on March 5, 1770, on the very place where Austin was killed. In Wyer's case and Abbott's case, more recently the distinction I now make were agreed to. In the trial of the soldiers it was agreed that their arms were legally in their hands, that they marched into the street in obedience to the orders of Captain Preston, that they were sent to support and protect the sentries stationed at the door of the custom house, and it was admitted by the court that if they had not been there in obedience to the captain's order, they would have been guilty of murder, that the instruments they used were lawful instruments of labor, being such as by which they obtained their living. Had they laid down their guns and taken up other weapons, such as axes, hatchets, spades, or hammers, that would have brought the crime up to murder. It is true only 2 of them were convicted of manslaughter, but that arose from the particular circumstance of the case. Those men at that time were found guilty of manslaughter for doing that which was deemed to be their duty and attempted to be justified by the repeated assaults made by the townspeople, by throwing lumps of ice, brickbats, and other missiles. And though, in fact, they did retreat to the wall, it was held to be manslaughter. Are the times so changed, and the law so altered, that what was then held to be a felonious homicide shall now be considered in this town without any extenuating circumstances justifiable homicide? Has the distinction between Republicans and Federalists overset our Constitution? Is the one under the protection of the law and the other left to a simple state of nature for his protection? I now come to a question which will fix the different shades of guilt on the various views of the fact. Was the defendant in nothing to blame in this unfortunate and bloody catastrophe? Was he, or was he not the provoker of this quarrel? If he was in any wise to blame in that respect, all the books concur that he cannot avail himself of any circumstances that may be set up in justification or excuse under pretense of necessity. And is there nothing to show that he promoted this quarrel? What is the nature of the advertisement that he wrote and caused to be published? Did he not understand and expect in the morning of the publication that it would provoke an assault, in consequence of which he unlawfully armed himself to be his own avenger? Before he put in this advertisement, could he not have informed Mr. Austen that he would defend himself as a gentleman? Why did he not write his advertisement in another manner? Could he not say that my reputation as a lawyer is of the first consequence to me, that Mr. Austen has represented that I solicited a lawsuit from the man who furnished the entertainment of the Republicans on the 4th day of July, that I prevailed upon the man to bring this suit against the Republican committee, that I had convinced Mr. Austen that he was mistaken in the fact, and he promised me to contradict it, which he has hitherto neglected to do? Would not this statement have obtained the same credit with those who knew him? Where was the necessity of calling Mr. Austen a liar, coward, and a scoundrel? Admitting the mistake, why was it necessary to use the epithet coward, unless he meant to provoke him up to an act of violence, that he might have a pretext to kill him? That a combat of some kind was intended by the defendant is very apparent. Several of the witnesses have told you that they expected an attack by Mr. Austen upon Selfridge as the inevitable consequence of that publication. Did he recollect, when he gave this challenge, the feebleness of his frame, or the weakness of his nerves and limbs? And why did he not add, in order to put Mr. Austen upon his guard, I will not join with you in fisticuffs or cudgeling, but I carry a loaded pistol concealed in my pocket to kill anyone who shall dare attempt to horsewhip or cane me? Is it not true that the advertisement was the origin of this quarrel? If he was to blame in provoking it, if he went out unlawfully armed with a deadly weapon concealed in his pocket, expecting to be assaulted, and thereupon was assaulted, under a determined resolution to shoot the person who should assault him, and did actually kill the deceased the instant the assault was made, pursuant to a premeditated but concealed design, where is his ground of excuse or justification? If he has not made out to you, beyond any reasonable doubt, that he was compelled to kill young Austen in his own defense, it is your duty, and you are bound by your oath, to return a verdict that he is guilty. If he is not guilty of manslaughter, he is guilty of nothing on this indictment. His being guilty of murder cannot excuse him on this issue. Suppose the assault was not felonious, but the person assaulted had some reason to suppose it so. Is the person who is put upon his defense warranted in killing the assailant? It is a fixed principle in our laws that no man can be justified in killing another, but from unavoidable necessity to preserve his own life or property, which may be feloniously attacked. In every affray, where there is no felonious intent, it is a fixed principle that the person put upon his defense shall retreat as far as possible before he is justified in killing the assailant. A robber on the highway may be killed the instant he makes the assault. So may a burglar in the attempt to rob a house. So a woman may kill a man in the necessary defense of her chastity. But a woman, knowing her chastity is to be assaulted, must not put herself in the way of the assailant and kill him, for in that case it will be considered that she had premeditated the destruction of the man's life, and this would constitute the crime of murder. And in like manner, if another expects to be assaulted, he must not go in way of the assailant with the intention of killing by a concealed deadly weapon. Was such homicide to be allowed as lawful? Where would it lead us? Duels might openly and excusably be fought at noonday in the open street in the bosom of the town. Suppose a truckman to be taken by the nose, and with the butt of his whip he strikes the person who assaults him and kills him dead with the stroke. He is held guilty of manslaughter only. It is not excusable homicide, because the assault was not of that dangerous nature as to put his life in jeopardy. The instrument I have mentioned in this case is one belonging to his profession, and which he lawfully uses in pursuing his ordinary avocation. But suppose a truckman, imitating those gentlemen of nice honor we have heard of, was to drive his truck about the streets armed with a sword by his side, and another truckman had run against his horses or his truck. The first had drawn his sword and killed the other with the thrust. This certainly would change the nature of the offense. Instead of manslaughter, it would be murder. Thus the degree of guilt resulting from the nature of the instrument is fully exemplified. A loaded pistol against a cane is equal to a sword against a truckman's whip. The truckman has nothing to do with the sword. The lawyer has no concern with this pistol. If a gentleman riding in his carriage should be run against by a hackney coachman, and he conceives that it was intended to injure his property in the carriage, or intended to kill his wife or children who may be with him, has he a right to fire his pistol and kill the hackney coachman on his box? This principle is contended for by the counsel on the other side, if supported, will go a much greater length than they acknowledge. He is not only justified in killing the coachman upon the assault, but he may be justified upon the mere apprehension, and supposing that the hackney coachman intend to cross him and struck the wheels of his carriage. He may spring out, and with a sword, which is a gentlemanly weapon, run the coachman through the body, under a pretense of apparent necessity to save his wife or children. Shall I add anything more in order to expose these extravagant and novel ideas of the privilege of self-defense? If, on every small misadventure or trifling assault, a man has a right to lay another dead at his feet, what nice calculations we are under necessity to be compelled to make. A man desirous of killing another should only go to a lawyer and inquire the degrees of assault that would bring down murder to manslaughter, and manslaughter to excusable or justifiable homicide. One man has a higher notion of honor than another, and the various notions of honor must be the graduated scale upon which a jury is to determine the true degrees of guilt on homicide. This cannot be the law of our country, yet some authorities have been read by the defendant's counsel to give it this coloring. I thought when they were read, they were but partially quoted. Grotius has been cited to show that the right of self-defense is what nature has implanted in every creature, without any regard to the intention of the aggressors. I suspected that this general rule had some qualifications, and a little further on, I find in the same author that the danger to which the person is exposed must be that of losing a limb or a principal member of his body or his life, and that there must be no possibility of avoiding the misfortune otherwise. These are the circumstances that authorize him lawfully and instantly to kill the aggressor. Further on he observes that self-defense may sometimes be omitted, that it is not lawful for a Christian to murder a man for a box on the ear, or such other slight injury, or to avoid his running away. That murder in defense of our goods is permitted by the law of nature, but even here there must be an absolute necessity of killing the thief to save the goods. But this treatise of Grotius on the rights of war and peace, explaining the laws and claims of nature and of nations, and the principles that relate either to the civil government or the conduct of private life, is a treatise that was written on what was the law among the Romans and other ancient nations, particularly what is termed the civil law. He explains what is the law of nature, and he describes God as nature herself, and infers that men have all the rights in society which they possessed under the revealed will of their Creator, where the protecting laws of the government cannot be applied. In this case, Selfridge had the whole state to protect him, even in a quarrel he provoked himself. In 1 Hawkins, B. 1, Chapter 30, Section 1, it is held that homicide against the life of another, amounting to felony, is either with or without malice. That which is without malice is called manslaughter, or sometimes chance medley, by which we understand such killing as happens either on a sudden quarrel or in the commission of an unlawful act, without any deliberate intention of doing any mischief at all. The same author lays it down that if he, who kills another on a sudden quarrel, was master of his temper at the time, he is guilty of murder, as if after the quarrel he fall into other discourse and talk calmly thereon. In 4 Blackstone 184, it is laid down as a principle that the person who kills another in his own defense should have retired as far as he conveniently or safely can, to avoid the violence of the assault, before he turns upon the assailant. There is a distinction in the law between a combat and a sudden affray. A combat is when 2 men meet by agreement to fight. In the present case, the defendant appears to be within the meaning of the word combat, for it appears he was told that there would be an assault, and to make it a combat he went armed with a loaded pistol. The same author proceeds to say that the person shall not fictitiously appear to retire or to avoid the affray in order to catch his opportunity of killing the assailant, but from a real tenderness of shedding his brother's blood. Apply this doctrine to the present case, and examine whether the evidence has shown to you that the defendant entertained this tenderness in shedding the blood of young Austin, when he armed himself with a deadly weapon and concealed it in his pocket, in order to shoot down anyone who should assault him. Can it be thought he had a tenderness against shedding human blood? When he declined having a recourse to the laws of his country for protection, when he chose to take the vengeance into his own hands and perpetrated this act, can it be thought he had the tenderness which the law requires in him, who shall unfortunately be driven from the necessity to shed his brother's blood? If the defendant had not written the advertisement, this quarrel would not have taken place. It was that which produced it. It appears that the consequences were produced exactly as he intended they should be, except that he killed one man instead of another. Retrace the whole of the transaction, and you will see the defendant bent on a bloody purpose. The letters of the 29th and 30th of July appear to have been intended to provoke a duel, but his counsel tell you that he was provoked to take these measures on account of the injurious words spoken by B. Austin. Suppose it true that Mr. Austin had spoken disrespectfully of the defendant, or that he had printed the most opprobrious slander of him, would it justify the defendant's going armed with a loaded pistol concealed in his pocket? The law holds that words either spoken or written can never justify an assault. It is of no consequence, therefore, whether B. Austin was to blame or not. The defendant ought not to have defended himself in this way. It is true that the reputation of a lawyer is of great importance to himself and to some of the community. As one of the profession, I wish the order was more respectable than the conduct of some of its members have lately rendered it. In that case, we should not at this day have heard the outcry against them, which seems to prevail too much throughout the United States. To me, the original conversation which is said to have occasioned this unhappy event does not appear necessarily to have involved the affront which the defendant seems to have conceived. From the testimony of Mr. Scott, we find that same gentleman had been joking Mr. Austin at Russell's insurance office on the Republican committee being sued for the expense of the dinner the party had on Copp's Hill, and that Mr. Austin, when he was going away, laughingly retorted that if a federal lawyer had not interfered, it would not have happened. It was a reply upon the other party, and was not a personal attack upon Mr. Selfridge. Mr. Scott inferred that he alluded to Mr. Selfridge because he thought Mr. Austin addressed himself to him, as he was one of the federal party. Mr. Selfridge's reputation was not affected, but he pursues him with a dreadful vengeance, and throughout the whole appears to be determined to have him at his feet, alive or dead. How could he have suffered in his character or his business? Is there any Federalist who thinks it dishonorable to sue a Democrat? Or is there any Federalist who would decline to employ suffrage on that account? For my part, I apprehend from what I have seen on the present trial, there was no ground for what is said to be the apprehension of the defendant. One further observation. Mr. Carroll says that he heard the report of the pistol when he was at the post office, immediately after he saw Mr. Ritchie and Selfridge together, and Mr. Ritchie said to the defendant that he was extremely agitated, to which the defendant replied, "I am not agitated. I have done what I intended to do or meant to do." Mr. Hastings says that he heard Selfridge speak also when it was inquired who had done the deed, and say, "I am the man. I am not agitated." Mr. Ritchie says that the defendant said, "I know what I have done. I am not so much agitated as you are," and that he stood firm, erect, and upright. Does this look as if the killing was done upon a sudden affray? Would either of you gentlemen, who should have been driving your carriage, and had the misfortune to run over a poor child begging alms in the street, and kill him, stop short and say, "I am the man who has done it. I know what I have done. I am not agitated"? I am totally unacquainted with human nature, even at this advanced period of life. If there is a man among you, but who would shudder at the accident, and lament the effect of such carelessness. If any of you, in firing a gun, should be so unfortunate as to kill one of your neighbors without intending it, your hearts would be too full, and you would be too much affected to vaunt in a confident manner that you were the man that had done it, that you had done nothing more than what you intended. If the defendant had killed young Austin by accident, he must have shown some degree of agitation, but he was cool and collected, and did no more than what he intended to do. This was true, or why did he carry with him a loaded pistol? If there is, in your opinion, any degree of premeditation, he must be at least guilty of manslaughter. I have, I think, candidly examined the case, and have done only that which appeared to me to be my duty to do. I did expect that the indictment would have been for murder. It ought on every principle to have been so. There is no precedent to the contrary. The testimony I had heard rendered such an indictment proper. Not that I wished that he should have been convicted of that offense, but because I thought it would furnish an opportunity for a full examination of the unfortunate event. The grand jury, having found a bill for manslaughter only, have, in some measure, restrained us from such an inquiry, and the opportunity we may have had of conducting the trial before a full bench of the Supreme Court. I have no doubt but what His Honor, the judge who presides, will give you correct directions in his charge, but still it is not the charge of a full bench, and therefore cannot be so satisfactory as it might have been. I ought to have no expectation either that a wrong verdict will be given, or that the verdict, be it what it may, will throw the community into convulsions. Fear of consequences is an inadmissible principle in our judicial proceedings. Higher motives must urge us to our duty, and the base principle of fear can have no effect in the trial. If the defendant has suffered or must suffer, is it not the consequence of his own fault? And is it not right that one who avowedly raises himself above the laws should suffer, rather than that the essential laws of society, the first laws of natural reason, and the law of God, promulgated by the highest sanctions, shall be set at defiance? Gentlemen, I consign this cause to you, to be decided according to the laws of our country, which laws His Honor will state to you from the bench. You will decide as in the presence of Him who knows all our motives, and before whom we must all soon appear and have to answer, and in the presence of the whole human race, for the motives on which the present decision shall be formed. End of section 61. Section 62 of American State Trials, Volume 2. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials Volume 2 by John D. Lawson. Trial of Thomas O. Selfridge for the killing of Charles Austin. Boston, Massachusetts, 1806. Part 13. The Judge's Charge. Parker J. Gentlemen of the jury, as this most interesting trial has already occupied 4 days, and as you must by this time be nearly exhausted, I shall endeavor, in discharging the duty incumbent on me, to consume as little more of your time as may be consistent with a clear exposition of the principles necessary to be understood, in order to form a just and legal decision. You have heard the important facts in the case, minutely and distinctly stated by the witnesses, ably and ingeniously commented upon by the counsel, and the principles of law, elaborately discussed and illustrated in as forcible and eloquent arguments as were ever witnessed in any court of justice in our country. It is now left to you, upon the whole view of the case, both of the law as it shall be declared to you by the court, and the facts as proved by the testimony, to pronounce a verdict between the defendant and your country. That in so important a trial, it should have devolved upon me alone to preside over its forms, as well as to declare the principles upon which your decision is to rest, is by no means a subject of congratulation. It is a situation which of all others I should have avoided, had not official duty imperiously imposed it upon me. But the organization of the court and distribution of the services of its members are such as to have rendered any such arrangement difficult, if not impossible. Under our present judiciary establishment, all criminal cases other than capital are triable before one judge, and this system has proved itself to be eminently calculated for the dispatch of public business. Other provisions in the system ensure as great a degree of correctness as can be expected of any human institution. It is true that although at a term holden by one judge, if others are present, they may proceed together. But at this time, the court being in session in 3, if not 4 several counties, it was impracticable. Had it been desirable to have more than 2 judges engaged in the present trial, the great delay which would have taken place, in consequence of a division of opinion, a case not unlikely to happen in the course of any trial, between 2 judges, rendered it altogether inexpedient that more than one should attend. And as this term has been previously assigned to me, the unpleasant task of officiating in the present case seemed unavoidably to belong to me. Since it has thus fallen to me to execute a painful and anxious duty, I shall not shrink from the task of declaring to you the principles of law by which you are to be governed in your investigation and decision of this case. If in doing this I should be found capable, in order to retain the favor of one class of the community, or to court that of another, of abusing my office by stating that to be law which I know to be otherwise, this is the last time I should be suffered to sit upon this bench, and I ought to meet the execration and contempt of the society to which I belong. The crime charged by the grand jury upon the defendant is manslaughter, a crime of high consideration in the eye of the law. This crime, however, is not defined by our statute, but its punishment is by it provided for. In order, therefore, to ascertain the nature and character of the crime, it is necessary to resort to the books of the common law, the principles of which by the constitution of our government are made the law of our land, until they shall be changed or repealed by our own legislature. The counsel for the government, as well as for the defendant, had therefore wisely and properly searched the most approved authorities of the common law for the principles upon which the prosecution or the defense must be supported. It is from those books alone that any clear ideas of the offense which is on trial, or the defense which has been set up can be attained. The crime of manslaughter, according to those authorities, consists in the unlawful and willful killing of a reasonable being, without malice express or implied, and without any justification or excuse. That the killing of a human being, under some circumstances, is not only excusable, but justifiable, is proved by the very terms of this definition. Some persons, however, have affected to entertain the visionary notion that it is in no instance lawful to destroy the life of another, grounding their opinion upon the general proposition in the Mosaic Code, that whosoever sheddeth man's blood, by man shall have his blood be shed. There is always danger in taking general propositions as the rules of faith or action, without attending to those exceptions, which, if not expressly declared, necessarily grow out of the subject matter of the proposition. Were the position above alluded to true in the extent contended for by some, then the judge who sits in the trial of a capital offense, the jury who may convict, the magistrate who shall order execution, and the sheriff who shall execute, will all fall within this general denunciation, as by their instrumentality the blood of man has been shed. The same observations may be applied to one of the precepts in the Decalogue. Thou shalt not kill is the mandate of God himself. Should this be construed literally and strictly, then a man who, attacked by a robber, or in defense of the chastity of his wife, or of his habitation from the midnight invader, should kill the assailant, would offend against the divine command, and be obnoxious to punishment. But the common understanding of mankind will readily perceive that the very nature of man and principles of self-preservation will supply exceptions to these general denunciations. Our laws, like those of all other civilized countries, abundantly negative such unqualified definitions of crime, and have adopted certain principles by which the same act may be ascertained to be more or less criminal or entirely innocent, according to the motive and intent of the party committing it. Thus, when the killing is the effect of particular malice or general depravity, it is murder and punished with death. When, without malice, but caused by sudden passion and heat of blood, it is manslaughter. When in defense of life, it is excusable. When in advancement of public justice, in obedience to laws of the government, it is justifiable. These principles are all sanctioned by law and morality, and yet they all contradict the dogma that whosoever sheddeth man's blood, by man shall his blood be shed. It is not necessary for you to run a nice distinction between justifiable and excusable homicide. If the one now on trial be either the one or the other, it is sufficient for the purpose of the defendant. A distinction existed in England, which does not exist here. There the man who had committed inexcusable homicide forfeited his goods and chattels, while he who had a justification forfeited nothing. Here, whether the homicide be justifiable or excusable, there must be an entire acquittal. Numerous authorities, ancient and modern, have been read to you upon this subject. Were it necessary for you to take those books with you and compare the different principles and cases which have been cited, your minds might meet with some embarrassments, there being in some instances an apparent, though in none, a real incongruity. But I apprehend you need not trouble yourselves with the books out of court, for I think I shall be able to state all the principles you will have occasion to consider, there being in fact no disagreement about them from the time of Sir Edward Coke, one of the earliest sages of the law, down to Sir William Blackstone, one of its brightest ornaments. These same principles, although taken from English books, have been immemorially discussed and practiced upon by our lawyers, adopted and enforced by our courts and juries, and recognized by our legislature. To prove this, I now need say no more than that the same learned Judge Trowbridge, who was quoted by the Attorney General in his charge to the jury in the trial of the soldiers of the massacre of 1770, laid down, discussed, and illustrated with great precision and clearness every principle which can come in question in the present trial. These principles I will endeavor to simplify for your consideration. First, a man who in the lawful pursuit of his business is attacked by another under circumstances which denote an intention to take away his life, or do him some enormous bodily harm, may lawfully kill the assailant, provided he use all the means in his power otherwise to save his own life or prevent the intended harm, such as retreating as far as he can, or disabling his adversary without killing him, if it be in his power. Secondly, when the attack upon him is so sudden, fierce, and violent, that a retreat would not diminish but increase his danger, he may instantly kill his adversary without retreating at all. Thirdly, when from the nature of the attack there is reasonable ground to believe that there is a design to destroy his life or commit any felony upon his person, the killing the assailant will be excusable homicide, although it should afterwards appear that no felony was intended. Of these three propositions, the last is the only one which will be contested anywhere, and this will not be doubted by any who are conversant in the principles of criminal law. Indeed, if this last proposition be not true, the preceding ones, however true and universally admitted, would in most cases be entirely inefficacious. And when it is considered that the jury who try the cause are to decide upon the grounds of apprehension, no danger can flow from the example. To illustrate this principle, take the following case. A, in the peaceable pursuit of his affairs, sees B running rapidly towards him, with an outstretched arm and a pistol in his hand, and using violent menaces against his life as he advances. Having approached near enough, in the same attitude, A, who has a club in his hand, strikes B over the head before or at the instant the pistol is discharged, and of the wound B dies. It turns out that the pistol was loaded with powder only, and that the real design of B was only to terrify A. Will any reasonable man say that A is more criminal than he would have been if there had been a bullet in the pistol? Those who hold such doctrines must require that a man so attacked must, before he strike the assailant, stop and ascertain how the pistol is loaded, a doctrine which would entirely take away the essential right of self-defense. And when it is considered that the jury who try the cause, and not the party killing, are to judge of the reasonable grounds of his apprehension, no danger can be supposed to flow from this principle. These are the principles of law, gentlemen, to which I call your attention. Having done this, I might leave the cause with you, were it not necessary to take a brief view of some other parts of it. As to the evidence, I have no intention to guide or interfere with its just and natural operation upon your minds. I hold the privilege of the jury to ascertain the facts, and that of the court to declare the law, to be distinct and independent. Should I interfere with my opinion on the testimony in order to influence your minds to incline either way, I would certainly step out of the province of a judge into that of an advocate, all which I conceive necessary or proper for me to do in this part of the cause is to call your attention to the points of fact on which the cause may turn, state the prominent testimony in the case which may tend to establish or disprove those points, give you some rules by which you are to weigh testimony, if a contrariety should have occurred, and leave you to form a decision according to your best judgment, without giving you to understand, if it can be avoided, what my opinion of the subject is. Where the inquiry is merely into matters of fact, or where the facts of the law can be clearly discriminated, I should always wish the jury to leave the stand without being able to ascertain what the opinion of the court as to those facts may be, that their minds may be left entirely unprejudiced, to weigh the testimony and settle the merits of the case. An important rule in the present trial is, that on a charge for murder or manslaughter, the killing being confessed or proved, the law presumes that the crime as charged in the indictment has been committed, unless it should appear by the evidence for the prosecutor, or be shown by the defendant on trial, that the killing was under such circumstances as entitle him to justification or excuse. On the point of killing, there is no doubt in this case. The young man named in the indictment unquestionably came to his death by means of the discharge of a pistol by the defendant at the bar. This part is confessed as well as proved. The great question in the case is whether, according to the facts shown to you on the part of the prosecution or by the defendant, any reasonable legal justification or excuse has been proved. Whether the killing were malicious or not is no farther a subject of inquiry than that if you had evidence of malice. Although the crime charged does not imply malice, it may be considered as proving this crime, because it effectually disproves the only defense which can be set up after killing is established. From the testimony of several witnesses examined by the solicitor and attorney generals, it appears that on the day set forth in the indictment, the defendant was in his office a little before 1 o'clock, that in a conversation about his quarrel with the father of the deceased, he intimated that he had been informed an attack upon him was intended, and that he was prepared. That a short time afterward, he went down from his office, which is in the old State House, crossing State Street diagonally, tending towards the United States Bank. That, as he passed down, his hands were behind him, outside of his coat, without anything in them, is proved by the testimony of Mr. Brooks, who saw him pass down, and by that of young Mr. Irving, who saw him when the deceased approached, put his right hand in his pocket and take out his pistol, while his left arm was raised to protect his head from an impending blow. The manner of his going down upon change, the weapon which he had with him, the previous intimation of an attack which he seems to have received from Mr. Cabot or Mr. Welch, and the errand upon which he went down, as stated by Mr. Ingraham, are all circumstances worthy of your deliberate attention. Passing down State Street, as before described, several witnesses testified that the deceased, who was standing with a cane in his hand, near the corner of the Suffolk buildings, having cast his eye upon the defendant, shifted his cane into his right hand, stepped quick from the sidewalk onto the pavement, advanced upon the defendant, with his arm uplifted, that the defendant turned, stepped 1 foot back, and that a blow fell upon the head of the defendant, and the pistol was discharged at the deceased at one and the same instant. Several blows were afterward given and attempted to be parried by the defendant, who threw his pistol at the deceased, seized upon his cane, which was wrested from him by the deceased, who, becoming exhausted, fell down, and in a few minutes expired. This is the general course of the testimony. The scene was a shocking one, and all the witnesses state to you that they were exceedingly agitated. This will account for the relation given by Mr. Lane and one other witness, I believe Mr. Howe, who state the facts so differently from all the other witnesses produced by the government, as well as by defendant, that however honest we may think them, it is impossible not to suppose they are mistaken. Indeed, the Attorney General has wisely and candidly laid their testimony, so far as it differs from that of the other witnesses, out of the case. There is one witness, Mr. Glover, who states the transaction somewhat differently from the other witnesses. He says that having expected to see a quarrel upon exchange, in consequence of the publication against the deceased's father, in the morning, he went there for the express purpose of seeing what should pass, that he saw Mr. Selfridge coming down street, saw young Austin advance upon him, that he had a full view of both parties, was within 15 feet of them, that he saw a blow fall upon the head of Selfridge with violence, the arm of the deceased raised to give a second blow, which fell the instant the pistol was discharged. This is the only witness who swears to a blow before the discharge of the pistol, but he swears positively and says he has a clear, distinct recollection of the fact. His character is left without impeachment. If you consider it important to ascertain whether a blow was or was not actually given before the pistol was fired, you will inquire whether there are any circumstances proved by other witnesses which may corroborate or weaken the testimony of Mr. Glover. On this point you will attend to the testimony of Mr. Wigan, who swears that he heard a blow as if on the clothes of some person, that he turned and saw the deceased's arm uplifted, and another blow and the discharge of the pistol whirred together. You will consider the testimony of young Irving, who swears that the left arm of the defendant was over his forehead, as though defending himself from blows, when he saw the blow fall. You will consider that all the witnesses but Glover state that the blow which they saw and thought the first was a long blow across the head, that the blow which Glover says was the first was a direct, perpendicular blow, and that he then saw the second blow, which was a cross one, as testified by the other witnesses. If you find a difficulty in settling the fact of the priority of the blow, take this for your rule, that a witness who swears positively to the existence of a fact, if of good character and sufficient intelligence, may be believed, although 20 witnesses of equally good character swear that they were present and did not see the same fact. The confusion and horror of the scene was such that it was easy for the best and most intelligent of men to be mistaken. As to the order of blows, which followed each other in such rapid succession that the eye could scarcely discern an interval, you will, therefore, compare the testimony of the witnesses, where it appears to vary, attending to their different situation, power of seeing and capacity of recollecting and relating, and settle this fact according to your best judgment, never believing a witness who swears positively to be perjured, unless you are irresistibly driven to such a conclusion. Upon this point you will also attend to the testimony of Mr. Fales, and of Mr. Osborne and Mr. Perkins Nichols, touching the testimony of Mr. Fales. The counsel for the defendant seem, however, to deem it of little importance to ascertain whether the blow was given before the pistol was discharged or not, as there is evidence from all the witnesses that an assault at least was made by the deceased before the pistol was fired. I think differently from them upon this point, when the defense is that the assault was so violent and fierce that the defendant could not retreat, but was obliged to kill the deceased to save himself. It surely is of importance to ascertain whether the violent blow he received on his forehead, which at the same time that it would put him off his guard, would satisfy him of the design of the assailant, was struck before he fired or not. I doubt whether self-defense could in any case be set up, where the killing happened in consequence of an assault only, unless the assault be made with a weapon which, if used at all, would probably produce death. When a weapon of another sort is used, it seems to me that the effect produced is the best evidence of the power and intention of the assailant to do that degree of bodily harm, which would alone authorize the taking of his life on the principles of self-defense. But whether the firing of the pistol was before or after a blow struck by the deceased, there is another point of more importance for you to settle, and about which you must make up your minds, from all the circumstances proved in the case, such as the rapidity and violence of the attack, the nature of the weapon with which it was made, the place where the catastrophe happened, the muscular debility or vigor of the defendant, and his power to resist or to fly. The point, I mean, is whether he could probably have saved himself from death or enormous bodily harm by retreating to the wall, or throwing himself into the arms of friends who would protect him. This is the real stress of the case. If you believe under all the circumstances, the defendant could have escaped his adversary's vengeance at the time of the attack without killing him, the defense set up has failed, and the defendant must be convicted. If you believe his only resort for safety was to take the life of his antagonist, he must be acquitted, unless his conduct has been such prior to the attack upon him as will deprive him of the privilege of setting up a defense of his nature. It has, however, been suggested by the defendant's counsel that even if his life had not been in danger, or no great bodily harm, but only disgrace was intended by the deceased, there are certain principles of honor and natural right by which the killing may be justified. These are principles which you as jurors and I as a judge cannot recognize. The laws which we are sworn to administer are not founded upon them. Let those who choose such principles for their guidance erect a court for the trial of points and principles of honor. But let the courts of law adhere to those principles which are laid down in the books, and whose wisdom ages of experience have sanctioned. I therefore declare it to you as the law of the land, that unless the defendant has satisfactorily proved to you that no means of saving his life or his person from the great bodily harm which was apparently intended by the deceased against him, except killing his adversary, were in his power, he has been guilty of manslaughter, notwithstanding you may believe with the grand jury who found the bill that the case does not present the least evidence of malice or premeditated design in the defendant to kill the deceased or any other person. I ought not to rest here, for although I have stated to you that when a man's person is fiercely and violently assaulted under circumstances which jeopardize his life or important members, he may protect himself by killing his adversary, yet he may, when the existence of other circumstances proved against him, forfeit his right to a defense which the laws of God and man would otherwise have given him. If a man, for the purpose of bringing another into a quarrel, provokes him so that an affray is commenced, and the person causing the quarrel is overmatched, and to save himself from apparent danger kill his adversary, he would be guilty of manslaughter, if not of murder, because the necessity being of his own creating shall not operate in his excuse. You are therefore to inquire whether this assault upon the defendant by the deceased was or was not by the procurement of the defendant. If it were, he cannot avail himself of the defense now set up by him. And here you are called upon to distinguish pretty nicely, and to attend to a part of the case which I thought was going too far back to have an influence upon this trial, but which the urgency of the Attorney General and the consent of defendant's counsel finally induced me to admit. You have heard the whole story of the misunderstanding between the defendant and the father of the deceased, who was originally in the wrong. It is not for me to say, but I feel constrained to say, that whatever provocation the defendant may have conceived to have been given him, and however great the injury which the deceased father may have done him, he certain proceeded a step too far in making the publication which appeared in the paper which came out on the morning of this unhappy disaster. To call a man coward, liar, and scoundrel in the public newspapers, and to call upon other printers to publish the same, is not justifiable under any circumstances whatever. Such a publication is libelous in its very nature, as it necessarily excites to revenge and ill blood. Indeed, I believe a court of honor, if such existed, to settle disputes of this nature, would not justify such a proclamation as the one alluded to. A posting upon 'change or in some public place we have heard of, but I never before such a violent denunciation as this in a public newspaper. Neither can I refrain from censuring the managers of the paper who admitted such a publication, or so readily receiving and publishing what in its very nature would tend to disturb the public peace. But, gentlemen, it is one thing for a man to have done wrong, and another thing for that wrong to be of a nature to justify an attack upon his person. If personal wrong, done by the father of the deceased to the defendant, would not justify him in publishing a libel, neither would the libel have justified the deceased or his father in attacking the person of the author of the libel. No man can take vengeance into his own hands, He can use violence only in defense of his person. No words, however aggravating, no libel, however scandalous, will authorize the suffering party to revenge himself by blows. If, therefore, Mr. Austin himself, the object of the newspaper publication, would not be justified had he attacked the defendant and beat him with a cane, still less would the circumstances have justified the unfortunate young man who fell a victim to the most unhappy and ever to be lamented dispute. For, however a young and ardent son may find advocates in every generous breast for espousing his father's quarrel, from motives of filial affection and just family pride, yet the same laws which govern the other parts of the case would have pronounced him guilty had he lived to answer for the attack which was the cause of his death. The laws allow a son to aid his father if beaten and to protect him from a threatened felony or personal mischief, and in like cases a father may assist a son, and should a killing in either case take place, it is excusable. But neither one nor the other can justify resorting to force to avenge an injury consisting in words however opprobrious, or writings however defamatory. You will therefore consider whether these facts antecedent to the meeting on 'Change can have much operation in the cause. Let which party will be founded by you to be in the wrong. Upon the whole, therefore, of these circumstances, should you be of opinion that the defendant, in order to avenge himself upon the father of the deceased, prepared himself with a deadly weapon which he afterwards used, went upon 'Change with a view to meet his adversary, and exposed himself to an attack, in order that he might take advantage and kill him, intending to resort to no other means of defense in case he should be overpowered. There is no doubt that killing amounted to manslaughter, but if from the evidence in the case you should believe that the defendant had no other view but to defend his life and person from an attack which he expected, without knowing from whom it was to come, that he did not purposely throw himself in the way of the attack, but was merely pursuing his lawful vocations, and that in fact he could not have saved himself otherwise than by the death of the assailant, then the killing was excusable, provided the circumstances of the attack would justify a reasonable apprehension of the harm which he would thus have a right to prevent. Of all this you are to judge and determine, having regard to the testimony of the several witnesses who have given evidence to these several points in the defense. The principles which I have thus stated are recognized by all the books which have been read, and are founded in the natural and civil rights, and in the social duties of man. The last subject on which I shall trouble you is the address which has been so forcibly urged upon your minds by the counsel on one side, and is zealously and ably commented on by the Attorney General on the other, touching the necessity of excluding all prejudices and prepossessions relative to this cause. I do not apprehend these observations were in any degree necessary, as I cannot bring my mind to fear that the verdict of 12 upright, intelligent jurors, selected by lot from the mass of their fellow citizens, will be founded on anything beside the law and evidence applicable to the case. Every person of this numerous assembly, let his own opinion of the merits of the cause be as it may, must be satisfied of the fairness, regularity, and impartiality of the trial, up to the present period. And sure I am that nothing which is left to be done by you will impair the general character of the trial. If you discharge your duty conscientiously, as I have no doubt you will, whether your verdict be popular or unpopular, you may defy the censure, as I know you will disregard the applause of the surrounding multitude. Least of all do I apprehend that party spirit will come to influence your opinions. However the storms of party rage may beat without these walls, I do not believe the time has yet come when they shall find their way within. Nor do I believe that a general apprehension is entertained that a man accused of a crime is to be saved or destroyed according to political notions he entertains. If ever the time should come when a general belief shall be entertained that trials are conducted and judgments given with a view to the political character of the parties interested. Vain and ineffectual will be the forms of your Constitution, and useless the attempt to administer the laws. A general resistance would be the consequence, and if this belief should be founded in fact and truth, that resistance would, in my apprehension, be perfectly justifiable. But no people would be bound to respect the forms of justice when the substance shall have vanished, when the fountains of justice shall be manifestly corrupt, and the forms in parade adhered to for the purpose of imposing on the citizens and subjecting them to oppression under the garb of law. You, gentlemen, will not be the first to violate the solemn oath you have taken, and seek for a conviction or an acquittal of the defendant upon any other principle than those which that oath has sanctioned. And as I trust that in performing my duty, I have conscientiously regarded that oath which obliges me, faithfully and impartially, to administer the laws according to my best skill and judgment, so that in discharging yours, you will have due regard to that which imposes upon you the obligation well and truly to try the cause between the Commonwealth and the defendant, according to law and the evidence which has been given you. The verdict, the jury retired and returned in a short time with the verdict of not guilty. End of section 62.
Section 63 of American State Trials, Volume 2. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Claire. American State Trials, Volume 2 by John D. Lawson. The Trial of John Morris for Assault and Battery, New York City, 1816. The Narrative. Nash's private school for boys and girls in New York City was in the early part of the 19th century patronized by the leading citizens of the metropolis. Mr. John Morris had 2 children there, boys of 7 and 12. The younger was inclined to be unruly, and his father had requested Mrs. Nash, who was also a teacher in the school, to punish him if he persisted in lending his books to associates, a habit which the father evidently desired to stop. The boy having done so again, he was reprimanded by his teacher, who repeated his father's order, whereupon the boy made an impudent reply, on which the teacher told him to hold out his hand for the strap. He refused and swore at his teacher, when she called on Hedden, the assistant master, to put him on the table as an example to the school, a mode of punishment in vogue then, and this was done. Some time previous to this, the older Morris boy had been punished by the assistant master and had complained to his father, who asked Mr. Nash not to allow his children to be punished by anyone but himself. Mr. Nash's answer was that all the scholars must be treated alike, that if his children behaved well, they would be treated well. If they behaved badly, they would be punished. Mr. Morris made no further objection and continued to send the 2 boys to the school. When the elder brother saw the younger one on the table of disgrace, he ran out of the room and carried the news to his father, who a short time after appeared in the schoolroom and demanded in a loud, angry voice, who had put his child on the table. Hedden replied that he had. "You place my child there, you rascal," returned Morris with an oath, and he ordered the child to come down from the table, which he did. Hedden ordered him to leave the room, but he refused, whereupon he seized him by the collar and tried to put him out, a struggle ensuing, which Morris got the better of, Hedden being so injured as to be confined to his room for several days. During the affray, the entire school was in a state of great confusion and alarm, Mr. Nash's whole energies being devoted to preventing a panic, and the scholars rushing down the stairs into the street. Morris, being indicted for assault and battery, was found guilty and fined, the court instructing the jury that what the master had done was right and lawful, and what the prisoner had done was illegal and inexcusable. The Trial. In the Court of General Sessions of New York City, March 1816, Honorable Richard Riker, Recorder, William Coulthard, Thomas R. Smith, Alderman. The prisoner, John Morris, having been indicted by the grand jury for an assault and battery on William B. Hedden, the trial came on today. John Rodman, prosecuting attorney, and Mr. Fay for the people. Mr. Wilkin for the prisoner. The jurors have been sworn. Mr. Frey briefly stated the nature of the case, alleging that it was a cause of unusual interest, inasmuch as concerned not only the peace and good order of society, but was intimately connected with the rights of teachers, the government of schools, the interest of literature, and the general happiness of the community. It involved the important question how far and in what manner the master of a school should take the place and hold the authority of a parent, while the child is under his care, and in what way a parent, dissatisfied with the discipline of the instructor of his child, should interpose his authority, whether by threat, violence, and outrage, or by mild and rational methods. The peculiar features of the case, said the counsel, will be presented by the testimony, and I shall reserve any further comment until the evidence has been heard and the defense exhibited to the jury. The evidence. William B. Hedden. I am 20 years of age and the son of William Nash. Am assistant in my father's school, which is located in Broadway. This school is large, composed of about 80 scholars, young misses and young masters, from among the most respectable families in the city. Mr. John Morris had 2 children at the school, one about 7, the other about 12 years of age. He had given orders to Mrs. Nash, who was also an assistant teacher in the school and had the particular superintendence of the class to which his younger son belonged, to prohibit that boy from lending out his book and to punish him should he disobey. Notwithstanding the orders of the parent imparted by Mrs. Nash, the child lent the book to one of his mates, whereupon the lady reprimanded him and repeated his father's order. The boy replied with some impudent, insulting words, on which she required him to approach her and hold out his hand to be punished by the ferule, a knife strap. The boy peremptorily disobeyed the order, resisted the mistress, imprecated the curse of God on her, and called her abusive names. Finding it difficult to subdue his temper, she called on me to place him on the table as an example to the school. This was done. Mr. Morris's older lad had formerly been punished by me, and having complained to his father, he expostulated with Mr. Nash and requested him not to suffer any punishment to be inflicted on his children except by himself. Mr. Nash replied that the children in his school must all be treated alike, and that if the children of Morris behaved well, they should be treated well. If ill, they must be punished in the same manner as others were. To this Morris made no further objection, and continued his children at the school. The elder brother ran out of the school about the time Mr. Nash was making arrangements to dismiss the scholars, and made some representation to him. The father in short time came to the door of the schoolroom, which he had burst open with violence, flew into the room with his hat on his countenance, indicating the most ungovernable rage, and demanded who had placed the child on the table. I stepped towards the defendant and informed him that the child had been placed there by my means, and that he had not been treated improperly. Defendant raised his fist and said, "You placed my child there, you rascal," and immediately ordered the child to come down from the table, which he did. I then ordered him to quit the room. The school was in a state of alarm and uproar, and Mr. Nash, to prevent the scholars from rushing out of the door and going down a narrow pair of stairs, whereby their lives might have been endangered, and a mob at least raised about the house, was solely employed at this juncture in closing the doors and quietening the scholars. I repeated my orders to the defendant to quit the school, which being refused, I seized him by the collar, and attempted to push him out. A violent struggle between us ensued, in which it appears that I threw the defendant, but permitted him to rise. Defendant then seized and threw me, beat me when down, and attempted to gouge out one of my eyes. By reason of the injury received, I was incapable of attending to business for several days. Attempts were made by the defendant to prove that the child had been injured in the spine, that it was weak in the head in consequence of a former complaint, and that it was punished with much severity, but the proof failed, and it clearly appeared that neither the mistress nor Hedden had been guilty of any impropriety towards the child in the infliction of the punishment. Mr. Wilkin, the assistant teacher, had no right to order the defendant to quit the school. That right only belonged to the master. The conduct of Hedden was calculated to invite aggression rather than to conciliate and soothe the angry passions. He was, in fact, the first aggressor. He undertook to put the defendant out of the school, and first committed the assault and battery himself. The father had given orders to the master not to suffer Hedden to correct his children, and from the representations made to him he believed the child abused by Hedden. Under this belief, and possessed with the feelings of every father, he entered the school. Mr. Wilkin here detailed the circumstances of the fray, the commencement of which he attributed to the assistant teacher, and concluded by urging the jury to bring home the case to themselves, and to make all due allowances for the influence of passion, induced by the belief of a real injury inflicted on a child of tender years by a person in school which had no right, and had been forbidden by the order of the father to inflict such punishment. Mr. Fay: Gentlemen of the jury, it is not because I think my talents equal to those of the learned counsel, who in his official station advocates the rights of the people, that I appear on this occasion as the public prosecutor. This complaint was first made to me by this injured individual, who has this day appeared before you at a time when the district attorney was absent, and when it was supposed his business might not permit him to return to this city in season to conduct this prosecution. It is from no apprehension that you will not by your verdict pronounce the defendant guilty, that I undertake to reply to the ingenious arguments advanced by his counsel. Nor do I entertain a fear that the court will not, by their sentence, punish this culprit as he deserves. But I feel it a duty which I owe to this injured complainant, to this court and jury, to the audience who now listen to me, and the community at large, to express my utter abhorrence of this crime, this daring outrage, and to exhibit it to the public eye in all its glaring deformity. The history of this affair may be comprised in a few words. The mistress had been directed by the defendant not to suffer the young child to lend his book. The order was imparted to the child. He disobeyed, and the lady, impressed with a sense of duty, undertook to correct the child, in pursuance of the order of the father. The child resists, and he resists with force. He not only resists with force, but calls his mistress abusive names, and far worse than all, he calls aloud on the name of his God, and imprecates a curse, a bitter curse, on the head of his instructor. Not willing to wrestle with this young rebel, Mrs. Nash requests her son, the assistant teacher, to place the boy on the table, as a spectacle of shame to the school. This is done in a mild manner, in the mode related by the testimony. Here this affair would have ended, but for the malicious and wicked interference of the elder brother. He had once smarted under the lash for his disobedience, and a favorable moment presented itself for vengeance. Slyly stealing from the school, he flies to his father, and no doubt tells him a most lamentable tale. What course, under such circumstances, would a prudent, discreet parent, solicitous for the future welfare and happiness of his child, have taken? Every good father is sensible that the surest way to ruin his child is to take his part against a master's authority. He would therefore first have inquired with calmness into the truth of such representation, and if unfounded, as the event has justified, would have punished the author, or if even there had been truth in the report, the father would rather have sought a private conference with the master, and with reason have expostulated on the impropriety of such chastisement. But the defendant did not on this occasion think proper to adopt a course mild, pacific, or rational. Indignant at the fallacious idea with which his mind was possessed, or rather destitute of any definite idea, he starts for the school. Incited with rage, fury, and madness, he burst open the door and rushed like a demon of destruction into this assembly of infants. Pale with anger, his eyes flashing terror, his fists clenched, his whole frame agitated with rage, in the situation in which he has been described by the testimony, he was utterly destitute of reason, nay, more dangerous than the most ferocious animal. As such, it was justifiable for any person, by any means, to have expelled him headlong from the school. He enters, gentlemen, in the manner I have described, without any regard to the sacredness of the place, to decorum, to common decency, and with his hat on, impudently demands with a horrible oath, "Who has placed my child on that table?" Mr. Nash attempts to explain. The school begins to be confused. Hedden undertakes to pacify. The defendant storms and rages, and all things assume such a threatening aspect that the master flies to prevent the scholars from rushing into the street in this state of trepidation and alarm. At this crisis, Mr. Hedden very properly requires the defendant to quit the school. He refuses with threats and bitter execrations, raises his fists in the attitude of striking Hedden, who then attempts to expel him by force from school. Here ensues a scene of disgrace, outrage, and horror so appalling to the feelings, so disgusting, that I shall not attempt a description, but shall leave it to yourselves, aided by the testimony, to imagine the mortification of a respectable teacher, the fear of the young ladies, the terror and dismay of all, the injury sustained by Hedden, the brutality of the defendant, and the bloody catastrophe which terminated this disgusting scene. That Hedden was torn and lacerated by this tiger, as to endanger his eyesight, that the rights of a teacher have been assailed, that the sacred sanctity of a school has been polluted, and the peace of society broken by this defendant, are all too clearly proved to admit a doubt. But we have been told, gentlemen, that the conduct of Hedden provoked aggression, that he injured the child in the punishment, and was insolent to that parent. It is not so. The child was not injured. It is only the cunning of the father that has framed this suggestion, which is so faintly supported by the testimony, that even the ingenuity of the counsel has not given it the color of plausibility. So far was the conduct of Hedden from being aggressive, that I am surprised he did not fly instantly to this madman, and at the first sight have him thrust headlong down the steps of this entrance. The very manner of the defendant was an assault. His threatening aspect, his ungovernable fury, his entrance into this school, were of themselves an indecent, unjustifiable attack on the master, whom Hedden, as a son and assistant, was bound to defend. The first step taken by the defendant was a breach of the peace, and his very look contained a declaration of war against the whole school. After the defendant came into the school with his hat on, his fist closed for battle, to say that Hedden could by any possibility have been the aggressor brings to mind the wolf in the fable, who, drinking in the stream on the hill, first accused and next tore the lamb who stood drinking in the stream below for disturbing the water. I can only account for the fact that the master and Hedden did not instantly hurl Morris out of the school, but by the supposition that the attack carried panic and dismay into the hearts of all. Well, it might. What a spectacle did his conduct exhibit to little children, a tiger in the sheepfold exciting terror, dismay, and consternation in the flock. And, gentlemen, this defendant merits the censure of the good, the frowns of all considerate fathers, the marked punishment of public justice. Before I close, I beg leave to add a few remarks by way of comment on the impropriety of this man's conduct in trampling on magisterial authority. For myself, gentlemen, from the years of my earliest infancy, I have been taught to believe that a school was a place for the improvement of manners as well as of mind. Whenever I entered a school, I was taught to pull off my hat, to make a bow of respect to my instructor, to march in silence to my station, and if I only whispered so as to disturb others, I was sure to be punished according to my deserts. It was this wholesome discipline that has formed in my mind a habitual respect for authority, a love of good order, an attachment to study, and a sacred regard for that noble institution, a public school. Here I first contemplated civil society in miniature, and learned in early years that obedience and respect to superiors, that principle of subordination which binds together, cements and supports society in all its various gradations. In a school, where the human mind is first placed under human care, to be fitted for the grand purpose of life, the child should be taught to consider his instructor, in many respects, superior to the father in point of authority. The infant mind early apprehends and distinguishes with a surprising sagacity, and is more influenced by example than precept. When a child, therefore, sees his parent entering the school, pulling off his hat and making a bow of respect, thereby acknowledging the tutor for a higher authority, the respect and obedience, and love from the pupil towards the master are strengthened, and the principle of subordination is engrafted in the mind of the child by the influence of example. It is by this happy conspiracy between the tutor and the father that a new power and influence is acquired over the infant mind, which it is in the interest of the parent to cherish and support, and is of infinite importance to the welfare and happiness of society. What a wretch must he be who would aim a blow at that power! Yet of this crime is the defendant guilty. He struck at the very basis of magisterial authority. It was to support that important principle that a learned and judicious schoolmaster said to Charles II, in the plenitude of his power, "Sire, pull off thy hat in my school, for if my scholars discover that the king is above me in authority, they will soon cease to respect me." And although the turbulent and unthinking Morris on this occasion dared to trample on the sacred principle, that august and accomplished prince pulled of his hat to demonstrate by example that magisterial authority should be supported and protected even by the monarch. And now, gentlemen, what ought to be done with that rash and passionate man whose ungovernable rage has driven him into one of the most respectable institutions of our country, into an extensive school of harmless innocence, and who, in that sacred place, at the very altar of science, has displayed the ferocity of a tiger, prostrating that altar, and inhumanly violating the person of the master? May he feel the weight of law in court, and out of court may he meet with merited scorn. The Recorder. Gentlemen of the jury, the rules of law applicable to this case are plain and simple. Every master has a right to correct his scholar with moderation, and as long as he confines himself within proper bounds is protected in law. In this case, no fault in the mode or extent of the punishment of this child can be reasonably imputed to the master, the mistress, or Hedon. The correction was mild, without passion, and not exercised with any degree of severity. The father, without doubt, had a right to go into the school to make inquiry relative to the truth of the representation made by the elder brother, but he had no right to enter the school in a passion and commit a breach of the peace. It will be your duty on this occasion to determine who was the first aggressor, and if you find that the defendant first committed an assault on Hedon, it will be your duty to find him guilty. Should you, moreover, believe that after the defendant was suffered to rise by Hedon, he again commenced the contest, or struck Hedon after he was down, and attempted to pluck out his eye, you must undoubtedly pronounce him guilty, even should you believe that Hedon committed the first assault, because a man has no right to employ more force than is absolutely necessary in repelling an attack. The court also charge you to return with your verdict, should it be against the defendant, the fact, as you may find, whether the defendant, during this affray, did attempt to deprive his adversary of an eye, for the decision of the jury on that point will furnish a criterion to the court in affixing the punishment. The jury pronounce the defendant generally guilty. The court. There are some circumstances in this case which the court has considered in mitigation of the punishment. Hedon was a very young man, the defendant a man in years and the head of a family. The conduct of Hedon in ordering a man older than himself to quit the school perhaps was not the most discreet course which could have been taken to allay the fervor of a mind under the strong influence of passion. The court also understands from the counsel that suits have been commenced against the defendant for private damages. Under these circumstances, the court thinks proper to impose a fine of $20 on the defendant, and to require from him a security by recognizance, himself in the sum of $500, and 2 sureties in the sum of $250 each, to keep the peace generally and especially towards William B. Hedon. End of section 63.
Section 64 of American State Trials, Volume 2. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Danielle Schultz. American State Trials, Volume 2, by John D. Lawson. On the 9th of August, 1865, John W. Hughes, physician and surgeon of Cleveland, Ohio, committed a murder in the small neighboring village of Bedford, which from the nature of the case, the character of the parties to the tragedy, and the antecedents of the deed forced him upon the attention of the city of Cleveland and of the whole of the state of Ohio. The public was shocked the following morning by the publication in the newspapers that Miss Tamsin Parsons, a young lady of 17 years of age, had been shot down in the streets of Bedford by this man who had been her lover and who, under the cover of a forged decree of divorce from his wife, had married her in Pittsburgh in December 1864, and suffered in the Pennsylvania penitentiary the penalty attaching to the crime of bigamy. Dr. Hughes was born in the Isle of Man, educated at a Scotch university, and emigrated with his wife to the United States in 1862. After practicing his profession of a physician for a few months in Chicago and Cleveland, he enlisted in an Ohio regiment as a private, but was very soon promoted to the position of assistant surgeon of the 49th United States Infantry. After serving for about a year, he resigned on account of the illness of his son in November 1864. He now began the practice of medicine in Cleveland, but making the acquaintance of Tamsin Parsons, he induced her to go with him to Pittsburgh, after showing her a paper which he persuaded her was a decree of divorce from his wife. For this he was convicted and sentenced to 1 year's imprisonment in a Pennsylvania penitentiary, but was pardoned after serving 5 months. Returning to Cleveland, he resumed the practice of medicine, and after having sent his wife and child back to the Isle of Man on a visit, he endeavored to win again the affections of Tamsin, who refused to have anything more to do with him. One night in July, after drinking deeply, he went to the house of her father in the village of Bedford at night, and, by his noise, aroused the old gentleman, who tried to eject. Hughes refused to leave the house, and objected with sufficient force to give ground for a charge of assault and battery, which was brought on the following day. Tamsin herself appearing, making the affidavit against him, an act which enraged him. Personal differences, however, were at length adjusted, and legal proceedings stayed. The doctor solemnly promised that he would thenceforth have nothing to do with the Parsons family. But alas, a drunken revel with a companion, Oscar Russell, on the night of the 8th of August, ended in their driving to Bedford and drinking at all the roadhouses along the way. Hughes, Russell, and their driver Carr issued from a hotel in Bedford and drove to the home of Mr. Parsons. Dr. Hughes entered the house and learned that Tamsin and her mother had gone blackberrying. They drove on, but soon met the women, and the doctor sought a private conference with Tamsin. A neighbor, however, came along in a wagon and took her home, while the men drove to the grocery, where they held a drunken revel for 2 hours. Hughes, learning that all the Parsons family had gone to Bedford for safety and to arrest him, started to the village, and seeing Tamsin come out of the home, he ran after her, calling on her to stop. She flipped the walk, saying, "No, I will not stop," and rushed through the gate, endeavoring to reach the front door. But before that asylum was reached, the pursuer laid hands on her, and shouting, "You won't stop, will you?" fired his revolver. The ball glanced off her head. She screamed, but the piteous cry was instantly hushed by a second and fatal discharge of the deadly weapon. The noise attracted a number of persons, who pursued Hughes, who jumped into the carriage with Russell and Carr, and, menacing the crowd with his revolver, succeeded in getting a good start of his pursuers. But he was captured in a few hours and landed in jail. Indicted by the grand jury for murder, after a trial lasting 18 days, he was convicted through his counsel, tried very hard to prove that he was insane at the time he committed the act. On February 9, 1866, he was hanged in the yard of the Cleveland jail. The trial. In the Court of Common Pleas of Cuyahoga County, Cleveland, December 1865. Honorable James M. Coffinberry, Judge, December 2nd. The grand jury, having previously, in parentheses, November 25th, returned an indictment against John W. Hughes for the murder of Tamsin Parsons. The day was occupied in impaneling a special jury, which was composed of the following: Moses Hunt, Brecksville; William Barr, Brecksville; Buell Stearns, Olmsted; Jesse H. Luce, Orange; Henry Fish, Brooklyn; William C. Snow, Parma; Dr. Marius Moore, Dover, in parentheses, Foreman; John G. Hasserat, Cleveland; Thomas Garfield, Newburgh; Joseph Slaught, Cleveland; Lawton Ross, Brooklyn; Alfred Kellogg, Charles W. Palmer and Albert T. Slade for the state; M.S. Castle, R.C. Knight, and William Kurish for the prisoner. An application was made by the defense for the postponement, and after argument the court continued the case until Wednesday, December 6th. December 6th. The court was opened by Mr. Palmer, who gave a summary of the incidents which led to the tragic death of Miss Parsons. Witnesses for the state. Joseph B. Haynes, reside in village of Bedford, knew Tamsin Parsons, who was sister of my wife, have known the defendant since December 1864. Having had information that Tamsin had gone to Pittsburgh with Dr. Hughes, I started, at the instance of her parents, for that place on December 20th, 1864. Went to the mayor's office on 21st, and, aided by policemen, succeeded in finding Tamsin in a room at the St. Clair Hotel, where I was shown by her a certificate of her marriage with Dr. Hughes. The doctor was soon after arrested in the office of the hotel and taken to lockup. He was soon brought before the mayor, where he declared he would never live with his wife again on account of her dissipated habits. He had been home 2 or 3 times and found her beastly drunk, and was resolved to leave her. He proposed to me then to go as a substitute in the army, and give Tamsin his bounty, and leave the country if the prosecution could be stopped, adding that it would be better for her as a continuation of it would lead to unpleasant disclosures. Saw Hughes later at Pittsburgh in jail. He still expressed anxiety to have the prosecution stopped. Next saw him on the day of his trial. Saw him again on the day of the murder in Bedford, near the Franklin House. In the village, about 2:00 p.m. He had seen Tamsin 5 minutes previous, as she and her mother had come to my house. Miss Parsons went out in a few minutes, and Mrs. Parsons started after Tamsin. I soon followed and saw a considerable number of excited people running to and from Mr. Christian's house. Saw a carriage move off towards Cleveland with Dr. Hughes in it. People were running around inquiring what the matter was. Heard some say Tamsin Parsons was shot. I got a horse from the stable and started in pursuit of the carriage. Was joined by Alicia Matthews on horseback. Met a Mr. Scott. He took Matthews' horse, Scott having a revolver. After passing railroad about 1/2 of a mile, saw the carriage stop and a man get out who jumped over the fence and ran towards the woods. We came back with the carriage to the railroad crossing. Scott took the carriage and I parted with him there. Went to Newburgh and with Cleveland officers came towards Bedford, and when 2 miles this side of Bedford, met a carriage containing Dr. Hughes, Andrews, and others. Did not identify the person who jumped out of the carriage and ran into the woods. When Tamsin left my house, she said she was going to Mr. Christian's. Left my house in less than 5 minutes after Tamsin left. Eliza Crum, reside in Bedford Township, just across the street from Thomas Parsons, on the Plank Road, 1 mile from the village of Bedford. Saw defendant about 2 weeks before the death of Tamsin, about 12:00 at night. Mr. Parsons came to our house, woke us up, and requested me and my husband go over and stay with his daughter while he went to Bedford for her mother. We went immediately, my son and myself. Dr. Hughes stood outside on the front doorstep. Tamsin opened the front door and spoke to Dr. Hughes, saying, "I see you there, behind the bushes." He advanced when she shut the door. He asked for a drink of water. She inside, he outside. She got a light, procured a glass of water, took it to the front door, and opened the same. He had driven down in front of the door, in the road. She spoke to him, saying, "You must be thirsty." He asked her to come out to the gate to speak. She went out and talked with him until her father returned. She went into the house, got a shawl, and went out the second time. Shortly after, the doctor and she went into the house. She said, "Doctor, I wish you would go away, for father won't talk with you." Mr. Pearsons, who was in the kitchen, took hold of him and attempted to put him out the door. The doctor came into the sitting room and said to her, "I have a home already furnished nicely for you, and will make a lady of you." She told him she would not go. He asked my son to get a pail of water for his horse, and soon got into his buggy and drove toward the Plank Road house. He was gone an hour, saw him come back. He went into the kitchen at Mr. Parsons, sat down and smoked a pipe. When I went in, he asked Tamsin who I was. She said, "A neighbor." Went back home, leaving my son with Tamsin. Saw him go away again toward the Plank House. Tamsin told the doctor that she wouldn't go with him to Cleveland, for he had deceived her once, and she was afraid he would again. He told her his wife had gone home. He had given her money, and she had gone home to her friends. When the doctor was on the steps, she went to him, and he put his arms around her and tried to coax her to go to Cleveland. Next saw the doctor at his examination for housebreaking. Saw him again the day after. He was at Mr. Thomas Parsons' house with a man named Parsons from the city. They took supper at my house that night, the doctor and his companion, Parsons, and left for Cleveland. Next saw the doctor the day of the murder. Came to our house about 10 that morning with a man whom he called either Major Hazen or Hanson. He asked how Miss Parsons got along and where she was. Was told she had gone blackberrying. Mr. Parsons came through our gate, and they shook hands. When they went round the side of the house and talked about half an hour, when they, the doctor and his companion, went away towards the Plank Road house. Before that I went to Parsons and found Miss Christensen, who said, "You needn't worry yourself, doctor, for her affections are elsewhere placed." He got up immediately and left the room. He looked as if he felt bad and hateful. Saw Dr. Hughes drive back and stop at our gate. Tamsin had left for Bedford with her father. The doctor asked my husband to get in and ride down to the village. His companion, Major Hanson, wanted us to get them something to eat, My husband joined them and rode to Bedford. Told the doctor before he started that Mr. Parsons' people were going to arrest him again. He replied that he would have that business all settled and did not see Hughes again before the murder. Half an hour after they left, I heard of the murder. William Crum was at home the night Dr. Hughes entered the house of Thomas Parsons about 2 weeks before the death of his daughter. Dr. Hughes was in his own buggy in the road, and Tamsin was standing in her father's yard by the fence. Hughes asked her to get into the buggy and go with him to Cleveland. She said he had deceived her once and he couldn't again. He said he had a room in Cleveland, well furnished, and added she had no need to alarm the neighborhood. He added, "I suppose I'll go down tomorrow. They might have a talk, and no one know anything about it, that the old man had gone down to Bedford to get help. But better believe I am pretty damn well armed." He added, "I suppose you'll go down tomorrow and spread it around." She replied that she thought she should. He said, "You can tell Joe Haynes that if I meet him in the street, I'll wring his nose for him." She said, "What will you do to me if you meet me?" He said he wouldn't hurt a hair of her head. The conversation between Hughes and Tamsin was tender, though he called her once or twice a fool. Next Sunday, Hughes told me he had a friend over at Mr. Parsons' house who was trying to, quote, settle his difficulty with them, unquote, referring to his trial for breaking into Mr. Parsons' house. While Hughes was talking with Tamsin in the buggy, I heard him say, "I am the drunkest I've been since," and that was all I heard. On the day of the murder, was cradling oats near the Plank Roadhouse, and saw the carriage driving toward the house from Bedford. Went to the house to get a glass of beer. Dr. Hughes slapped me on the shoulder and said, "Old man, are you just in time to get a glass of beer?" He handed me a glass, and I drank it. By the alternate orders of Hughes and Russell, the glasses were filled and drank half a dozen times. About that time, a Dutchman came in. Russell said, "Mother, get us some beer for this Dutchman." He drank from 10 to a dozen glasses. He had several glasses after that. Hughes and Russell went into another room, and I went home. While the Dutchman was there, he did all the drinking. The beer drinking was in the grocery opposite the Plank Roadhouse, not in that house. It was remarked then that Hughes' face was very red, and Russell, in parentheses, the major, rubbed flour on it. Do not think the beer drank at the grocery was very intoxicating. Was as sober when I drank the last glass as I was at first. After taking dinner at home, I started back to work when my boy said, "There comes Hughes's carriage." The doctor asked me if Mr. Parsons' folks were at home. I told him I thought not, that I heard they had gone down to Bedford. Asked me to get into the buggy and go to the village, and I got in with the doctor and the major. There was a driver on the box. Hughes told the latter to drive pretty fast. When we got opposite the post office in Bedford, Hughes got out and went into Mr. Christian's tailor shop and was there a moment or two. Was going to get into the carriage when he saw Mr. Thomas Parsons in a wagon just back of us. The doctor walked back and met Mr. Parsons and talked a minute, and then got into the carriage. Got out to go into Mr. Hammond's store. When I got to the post office, heard that the doctor had killed Tamsin Parsons. Turned about and saw the carriage starting off toward Cleveland. Did not discover anything wrong in the doctor when he came into my house the last time from the Plank Roadhouse. Don't know that he spoke a word going down to Bedford. Dr. Ben F. Ray. No Hughes. Saw him at Warrensville 2 weeks before Tamsin's death, when he told me he had been to Chagrin Falls to perform a surgical operation. Had been to Parsons' house the night before, he said. Found him asleep on the sofa in my office. After dinner, he got up and wanted to know how long he had been sleeping. We went to the bar room and drank a glass of beer. He inquired if I knew where Miss Parsons was. I told him I did not know. He said she was calling herself Mrs. Hughes, and said it was a disgrace to him. Asked me if I had a revolver or pistol. I told him I had neither one. I then said, "Doc, what do you want it for?" He replied that if Miss Parsons persisted in calling herself Mrs. Hughes, he would blow her and would also do likewise by Joseph Haynes. Said at the time of his arrest in Pittsburgh he had given some valuable papers to Miss Parsons, and wished to get them in his possession again, that he was going to her father's house. Hughes at this time first said he had been at Chagrin Falls making an amputation, and got $300 for it. Next saw Hughes some time afterward. He told me he had been arrested for an insult upon Parsons, and asked me what time it was that he came to see me that morning, and what conversation took place between us. He said that Parsons went over the way and got someone from the house opposite, that his examination on charge of assault would take place the next day, and wanted me to come and attend it. Ori Carr. Live in Cleveland, Dr. Hughes and Russell came to my carriage on Bank Street between 9 and 10 p.m. the night before Tamsin was shot. They called me Bug, a nickname. Russell introduced me to Hughes, and he asked me what I'd charge to go to Bedford. Told him $10. Russell has a saloon under Hughes's old office. They got into the carriage, and I drove to several houses to get some women to go with them, but did not succeed. Hughes took some liquor from a flask he had. Then he drove down to Bedford, stopped at the Franklin house. Drove on until we came to Mr. Crumb's house, where Hughes and Russell got out. A little boy from Crumb's house went over to Parsons, came back and said, "They ain't there. They've gone a blackberrying." Mr. Parsons came from his house into the road, and Hughes called to him. Parsons came to Hughes and talked with him, and Hughes afterward went over to Parsons' house, staying there half or 3/4 of an hour. Then we drove toward the Plank Roadhouse, and in about a mile we saw 2 women coming along, with tin pails in their hands. Hughes called, "Miss Parsons, Miss Parsons." She turned around. "What do you want?" Hughes said, "Nothing, only I want to talk to you." She started on, saying, "I don't want nothing to do with you." Hughes watched them a few minutes and then got out and followed them. They walking as fast as they could. He walking fast too. Could see the old lady motioning her hand toward Hughes, as if she was talking loud to him. The old lady got into a wagon. Hughes approached the girl who stood near the wagon and talked with her a minute, and then she got into the wagon. Hughes put his hand on her and talked to her for some time, until the wagon was driven off. I said to him, "The old lady was laying it down to you pretty hot." He said yes, but that it is all right. He directed me to go to the Plank Roadhouse, where we stopped. We went to a grocery across the road and had some beer, drank about 2 glasses when Crumb came in, and we had 2 or 3 more glasses of beer. Then a Dutchman came in, and all drank 5 or 6 glasses of beer. Went to Crumb's and stopped. Hughes got out and asked the lady if the Parsons folks were at home, and was told they had gone to town. Heard somebody tell Hughes that Parsons' folks had gone to Bedford and were going to have him, in parentheses, Hughes, arrested. He said something about settling or fixing it. We went to Bedford, Crumb going with us. Hughes said, "Drive on as fast as you can to Bedford." We went to the Fountain House to get some beer. Hughes saw Parsons come along in a wagon, and Hughes asked him to have a glass of beer. Parsons said, "No, I don't want to be shot." They got out at the Fountain House, and Hughes, as we were going in, turned around and went out. We had been there quite a little while when I started outdoors, and saw a lot of people running toward Columbus Street, followed, and saw a crowd gathering, and heard someone say that Hughes had shot somebody. I went back to the Fountain House and told Russell, who said, "Let's go and see." Drove down toward the place where the crowd was. Saw Hughes coming along with a man bolting on his arm, stopped my carriage. Hughes shook the man off his arm, took out a revolver, swung it around, and said, "Don't another man lay hold of me." He came to the carriage and jumped in. As he jumped in, I jumped off the carriage and went to the door and said, "What do you want?" He said, "Drive on." I hesitated, and he said, "Drive on, as I tell you." I got on the carriage and drove down a few feet when a lot of men cried out to me to stop the team. I stopped when Hughes shook his pistol at me and said, "Drive on, as I tell you." I drove ahead when a man said, "Stop the carriage. There's a murderer in it." I stopped when Hughes said, "You drive on or I'll blow you through." I drove on at a pretty good pace, and soon Russell came up and got into the carriage. We went a few rods when Russell got out and got on the carriage with me. I mentioned to the people to come after and overtake me. Was not going very fast. Russell told me, "For God's sake, drive faster or we'll shoot." I drove on as fast as we could till we got to a piece of woods when Hughes got out, stood a minute, asked Russell for some money. Russell gave him some, though he said he hadn't much. He went to the woods. The people were coming on after us, and I drove on with Russell. Saw Hughes next to the Fountain House after he was arrested. When last I saw Hughes before he was arrested, he was running in the woods on the right-hand side of the road. The man Russell also was called Major Hanson or Hampson. Hughes told me to call him so. When we left the Franklin house the morning of the murder, Hughes appeared very well. At Crumb's he appeared as usual, and also when we left the grocery to go back to Bedford. Nothing attracted my attention to his manner while we were going to Bedford. While in the grocery, Hughes's conduct did not differ from that on the night previous. He didn't seem drunk. Couldn't see that the ale affected any of the party. Almeida, Eddie, live at Warrensville, at the Plank Roadhouse. About 2 weeks before Tamsin's death, Hughes stayed at our house that night, retiring early. He got up about 7 o'clock and took breakfast. Ellen Van Allen, Ellen Eddy, and myself were present while he ate. He asked me if I had seen Tamsin Parsons lately. Told him she was at our house to hire Margaret Tier to work for her sister at Oil Creek. Said she has been shot at lately. He asked who done it. We don't know, I answered. The ball went through her parasol. He said it's a pity it didn't blow her brains out. It would have saved me the trouble, some time. He left going towards Bedford after breakfast. Saw him next the forenoon of the day he killed her, at a grocery opposite our house. He came into our barroom and washed himself and combed his hair. Saw them drive toward Bedford. His face was very red, eyes shone, walked straight, his voice was firm as usual. Ella Van Ellen, live in Bedford Village. Saw Dr. Hughes at the breakfast table at the Plank Roadhouse once. Mrs. Eddy, the doctor, and Ellen Eddy were there. Mrs. Eddy wanted to know of Dr. Hughes if he knew that Tamsin had been shot at. He said, "No, I didn't. Who shot her?" Mrs. Eddy said the ball went through her parasol. He said it was a pity it had not blown her brains out and saved him the trouble, some time. Mrs. Eddy said, "Why, doctor, do you intend to kill her?" He said, "Oh, no." Ellen Eddy. Saw Hughes at our house about 2 weeks before the death of Tamsin. Doctor asked Mother if she had seen Tamsin lately. She said, yes, she was up here the other day to hire a girl to work for her sister Libby. Mother said she's been shot at lately. He made the answer that Mother has just related. Vial Salisbury. Live in Bedford Village. The latter part of July. Met Dr. Hughes in the door of the Franklin house in the morning. He asked me if I had seen Tamsin lately or knew where she was. He said he must come down soon and look her up, for if she wouldn't live with him, he was going to kill her. J. S. Eli. Live in Newburgh. Keep the Cataract House. About 11 o'clock the night before Tamsin was shot, Dr. Hughes and Russell came to my house in a carriage with a driver. They went into the bar room, drank, smoked. They spoke of going up in the country to see a patient. The doctor had a limb to amputate. Next saw Dr. H. about 4 o'clock the next afternoon. He went in the washroom of my hotel, washed, combed his hair, and had something to drink. Looked as if he had been drinking a good deal the day previous. Vincent Salisbury. Kept the Franklin house in Bedford last July and August. Was at home the day Tamsin Parsons was shot. Dr. Hughes stayed at my house a part of the night previous, arriving there between midnight and 2 o'clock in the morning. Saw the party, Hughes, Russell, and Carr, to speak to them about 7 o'clock the next morning, when they came into the bar room from taking breakfast. Knew only Dr. Hughes. He introduced me to Russell as Major Handsome. He said he had been to Independence to amputate a limb. Asked him how business was. He said, good enough for 10 more like myself. They drank whiskey twice after breakfast, and one of them, I think Dr. Hughes, had his flask filled with whiskey. Sophia Stainbridge, live opposite the Plank Roadhouse. Dr. Hughes was at my house the forenoon before Tamsin was shot. Party of 3 came at 11 o'clock and were drinking present use ale at my house. They drank all I had, but my husband came from Cleveland with more a little after 12 o'clock. Dr. Hughes brought the half-barrel into the grocery. He had no difficulty in standing on the barrel. The doctor quit drinking before he left the house. He would drink a little and throw the rest on the floor, and I saw him put down 2 or 3 glasses behind the scales. Noticed that Dr. H.'s face was very red, and the Major put flour on it. Noticed nothing unusual in his manner. Seemed to walk straight. Francis Powell. Live in Bedford. I was working in my lot when Tamsin was shot. Dr. Christian lived on that lot. The house is about 30 feet back from the front fence. I was about 10 or 12 feet west of the spot where the murder occurred. Saw Tamsin in the yard walking rapidly toward the house, and Dr. Hughes was following her very closely. She tried to get into the house, but before she could reach it, Dr. H. overhauled her and took hold of her dress and shot her. Asked Dr. H. what he had done. He faced me and said he had to shoot her dead. He stood half a moment, turned around, and went up to the girl, turned her head around and examined the wound. He said, yes, she's dead. Was looking towards them when he fired. He set the pistol right in her neck, taking hold of her dress near the shoulders with his left hand. While he was examining the wound, I jumped over the fence and ran down and alarmed the people. Saw him next going down Columbus Street. John Price had hold of his arm as they walked down together. They went clear down to the corner when Hughes jerked Price off. Saw the carriage come from the tavern. Russell opened the carriage, and Hughes got in, followed by Russell, when they drove off toward Cleveland. Amos Lamson. Live in Bedford. Was at my house when I saw a crowd gather about the corners. Saw Price catch hold of a man, who jerked away from him. Saw Price catch hold of him again, and once more he jerked away. Saw this man, in parentheses Hughes, go to the carriage and get in. Heard a cry of, stop the carriage, and a cry of, murder, Went where the girl was shot and saw her body in the yard. 2 of us got into a buggy and started in pursuit of the carriage. On Independence Road, met the carriage coming back. Hughes had taken to the woods. Some 6 or 8 of us crossed the field several times, but couldn't find him. Searched along the railroad track. Hughes was ahead of us in some bushes close to the track. 6 or 8 of us went up to him. He said he was willing to give himself up. Mr. Wells searched him, and we started towards Bedford. Found a common knife, a few small cartridges, and a small pistol on his person. On the way to the village, Hughes talked some. Told him all I could do or say would not make him any better or worse. Think I proposed hanging him on the spot. He said, I would as soon as you hang me here on a tree as anywhere. I knew the penalty before I did it. I bought the revolver or pistol on purpose to shoot her, and have done it. He said, I have not done it under any excitement or impulse of the moment, but had studied the thing over. I think he had said for 2 weeks. He drew a flask out of his pocket and took a drink when I told the men not to let him drink, for he probably had poison in the flask. His manner did not differ from that which I have always seen in him. He showed no excitement. End of section 64, read by Danielle Schultz.
Section 65 of American State Trials, Volume 2. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Claire. American State Trials, Volume 2 by John D. Lawson. Trial of Dr. John W. Hughes for the murder of Tamsin Parsons, Cleveland, Ohio, 1865, Part 2. E.S. Libby, when the alarm was given, saw a man coming down Columbus Street, men having hold of his arms. As this man reached Columbus Street, he jerked away from the men holding him, drew a revolver, told the crowd to keep off, got into the carriage, and ordered the driver to go on. The driver started, hesitated when called on to stop, but finally drove off as though afraid to stop. Saw the carriage come back with Russell and Carr. They were locked up, and I took a double-barreled shotgun, got in the carriage with others, and started in pursuit. Hughes was found in a little ditch covered by an oak bush just large enough for a man to hide under. I discovered him lying down with his coat off. Heard him say, Gentlemen, you can do what you please with me. Hang me up to the first pole if you choose. I came out here with that intention, and I've done it. As some of them were afterwards firing off their guns, he said, Gentlemen, you can't scare me. I've been under fire before. I'm not at all alarmed. I also understood him to say, I'm a murderer, when he first spoke, but I'm not positive. He was cool and unconcerned. Cross-examined. Several of the crowd said hang him, shoot him. Saw him take out a flask and drink. Think it was 3 hours from the time he left the village in the carriage till we found him. We were searching the field about 3/4 of an hour. Dr. D. G. Streeter. Am a physician living in Bedford. I saw Tamsin Parsons' body about a half hour after she was shot. It was still warm. Saw a wound in the back of the neck, just below the base of the brain, and in the center of the neck. Next day I made an examination, the body being in a vault. Found that the wound was caused by a small ball entering the neck just below the base of the brain. The ball passed through the vertebrae of the neck into the very upper portion of the spinal marrow. The ball went upwards. About 3 inches from that, above the back of the right ear, there was a mark about 1 inch long. Don't think that which produced the first wound could have produced the second. My opinion is that the mark was occasioned by a pistol ball striking there and glancing off. A ball striking as the first did, and penetrating the upper portion of the spinal marrow, or medulla oblongata, would cause instant death. Susan Parsons. Am the mother of Tamsin. Tamsin and I started blackberrying between 5 and 6 o'clock in the morning, the day she was shot. On our way back, we noticed a city carriage coming. Tamsin called my attention to it. We passed and looked in and saw Dr. Hughes. I said, Why, Tamsin, there's the doctor. Dr. H. said, Mrs. Parsons. We made no reply. Then he spoke again when Tamsin told him to go along. We didn't want him. He next called to me, saying, Mrs. Parsons, it's you I want. On looking around, he was out of the carriage. He said he wanted to talk with me. I told him not to come nearer than he was. He said he wanted to talk with me and have Tamsin give him a paper that she would not trouble him any more. I told him there is no paper needed. She isn't your wife, and you have no claim on her. He said he had Major Hanson with him in the carriage, that he had come to give him, Hughes, a situation in Cincinnati, and he, Hughes, wanted to give Tamsin a check on the bank to get some money. I told him, we don't want you or your money. All we ask of you is to keep away and leave us alone. About an hour after reaching the house, we started for Bedford. Got out of the wagon near the junction of the roads in Bedford. I went with Tamsin to the house of Joseph Haynes. Stayed there 10 minutes or so when Tamsin started for Mrs. Christian's house. She went out of the house alone, but turned to me while in the yard and said, "The carriage has come back." I went to the gate to her and saw another carriage at the fountain house, but did not see the doctor. Next saw her on the sidewalk and Hughes a piece behind. Went back into Mr. Haynes's house, took my bonnet and started out. Got up a little way on that street when the doctor came down on the other side of the road, buttoning up his coat. Saw Mr. Powell coming, who said, "Oh, Mrs. Parsons, the doctor has shot your daughter dead." Went to the yard as quick as I could, was the first one there. Mrs. Christian opened her front door just as I got in the front yard. Tamsin's body was lying in the yard. John Price was working with Mr. Powell in Christian's yard, digging a trench the day Tamsin Parsons was shot. Heard a pistol shot and a scream. I turned around and saw the girl fall. Jumped out of the trench and saw Dr. Hughes step about 3 steps from the girl toward the gate. When he walked back, stooped down and put his finger in the wound, saying, "You are a dead girl." He then walked out to the gate, down street, went to the body and saw the blood flowing down her face. Followed him and caught hold of his right arm about 4 yards from where the murder was committed and led him down to the junction of the roads. He said, "What are you going to do with me?" Told him I would let him know when we got down to the corner. Nothing more was said till we got down to the corner. When there, he pulled away, drew his revolver, and said, "No man touch me." Saw his carriage coming up, containing Russell and a driver. He got in, Russell helping him, when they tried to start away from the crowd. Mr. Golden and I stepped up to drag Hughes out. Russell sat on the front seat, Dr. H. on the back. Laid my hand on Hughes's shoulder when Russell pulled his revolver and putting it near my face said, "Let go of that man or I'll blow your brains out." Heard Russell holler to the driver to drive on. Went back to the yard and found the body still lying there. Amelia Christian, daughter of William Christian and 13 years old. Came down to Bedford with Mr. Thomas Parsons' people the day of Tamsin's death. Saw Tamsin. She was in the road and Dr. Hughes was just stepping off the sidewalk on the opposite side of the road. When he got nearly to the gate at the side of the road, he pulled out his pistol, pushed the gate open, and when he got to her, put his hand on her shoulder and shot her. After he had shot her the first time, he cocked his pistol and shot her again. She screamed and fell down. Mother was standing by me. Mother said to Dr. H., "How could you do it? The poor girl is dead." We then went in and shut the door. Stood at the front window and looked out. Saw Dr. H. go down near the gate when he came back. He looked at her a while when he went away. Dr. H. said nothing when my mother spoke to him. He was looking at her at the time. Matthew O. Christian. Am a son of Mr. Christian and 16-year-old. Between 1 or 2 o'clock on the day of the murder, saw Tamsin coming toward our gate, and Dr. Hughes after her. When opposite our house, she turned her head and said to Dr. H., "No, I won't stop." Then she turned across the street toward our gate. Ran and opened the gate. She passed through, and I let the gate go too. The doctor crossed the road, and when near the gate, took a pistol from his pocket, cocked it, and went through the gate. When about 10 feet from the door, he caught hold of her, put his left hand on her shoulder, and said, "You won't stop, will you?" and put the pistol to the back of her head and fired. She dropped her head a little and said, "Oh dear." When he cocked his pistol again, fired, and she dropped. My mother was standing in the front door and said, "Oh, doctor, how could you do so?" or something like that. He said nothing. Mr. Powell, standing in the ditch, said, "You old villain, what have you done?" He said, "She is shot dead," and turned toward the gate. Saw him go down the street, followed by Mr. Price. Tamsin seemed to be scared when she went through the gate and in a great hurry. W. M. Heston. The day of the murder, when the alarm was raised, heard Hughes say he had done what he had intended to do if she would not be willing to consent to go with him, that she was his lawful wife. He was explaining to Wells where he intended to shoot her. He put his finger up to Wells's head and used some medical term I don't know. Hughes took a flask from his pocket and held it up and shook it, drank the contents and gave the flask to Mr. Strong. He then gave the pistol or revolver to Mr. Wells. Hughes said he had been from the highest circles of Europe to the lowest of this country, had been in the Crimean War and had been in service in this country, that half his life was spent in the manor and now the balance would end in a love tragedy. Handed the pistol to Hughes, and he took it apart and showed us the inside and handed it back to Mr. Wells. He said he had replaced the cartridges he had fired from his pistol and thought at one time he would put it in his mouth and blow his brains out. Then thought he would lie down and take a nap. I said he took it very cool. He said in response that he was no coward. A. O. Strong was present when Hughes was arrested. I said to him, "Doctor, you might as well give yourself up. There are too many of us." He said he would, said he bought that revolver for the purpose of doing the deed he did if she didn't comply with his wishes, said he had relieved his mind of a great load and that he would meet her on the other side of the great water, spoke of sending his first wife to the Isle of Man for the purpose of getting this girl to live with him, that the first time he saw her he set his affection on her, said he was willing to give his life for her, that they could do what they chose with him, hang him, or what they chose. Said he meant that no other man should ever possess Tamsin. Asked Hughes if he would have shot Joe Haines if he had seen him. Said he might have done it at the time his excitement raged so high, that he wouldn't wish harm anybody else. He said that some might think he was deranged, but he was not. He was in his right mind. His manner was not excited. William Christian. On the day of the murder, Hughes came to my shop about 1 o'clock, asked me if I had seen Miss Parsons that day. Told him I had not. He asked me where my wife was. Told him she had gone to Mr. Parsons' house some hours ago, and I had not seen her since. He then said, "My friend, you have been too busy in my affairs of late," and related what a good friend he had been to me and my family. At this time Cornelius Haynes entered and said he wanted me to measure him for a pair of pants. The doctor lowered his tone then, and I could not hear all he said, but it seemed to be something of a threatening character. In 15 or 20 minutes after he left, I heard of Tamsin being shot. Never saw Hughes intoxicated. A.J. Wells. On the way to Cleveland, Hughes said he came out there for the purpose of killing the girl, as she didn't comply with his wishes. Asked him what reason he had, and he replied that he didn't want anybody else to possess her, that she should not become anybody else's wife. He said he had bought the pistol for the express purpose of killing her, that he had sent his wife home to the island and he wanted to live with her, Tamsin, that he understood she was going to marry somebody. He put his finger on my head and showed the place he shot her. He wanted to kill her instantly so that she would not suffer. He crossed his fingers in explaining how he shot her, and said a shot given as indicated would be instant death. He said he shot twice, and the last time he had his left hand on her shoulder. Asked him if he would have shot any of us that were in pursuit of him, and he said no one except Joe Haines. Asked him why he would have shot Haines, and he said Haines had caused all this trouble. He said he had not slept well for some time back, but he could sleep well tonight, that he had been thinking over this matter. He gave me the pistol to remember him by, and it would probably have to come into court as evidence, and after they got through with it, I could have it. His manner was cool and calm. Witnesses for the defense. Thomas Lowe. Have known Dr. Hughes 2 years and a half, making his acquaintance in Warrensville. He left my house in January 1864 and went to Bedford to live and practice medicine. About a month after he went into the Army. Saw Dr. H. at my house in Warrensville after he returned from the Army. He came to my house in the same cutter, Miss Tamsin Parsons with him. They occupied the public sitting room after dinner. Occupied no other room together that I know of. They left about 5 o'clock, going towards Cleveland. Talked with them about half an hour. They seemed to be on friendly terms. Have seen Dr. H. under the influence of liquor. Never saw him so affected that his walk was not good. His face would assume a purple color. He was nervous the next day, but not when tight. Was always very easily excited when drunk, and looked wild with his eyes. Have seen him in that condition several days and even a week on a stretch. This excitement would increase as he continued drunk. Once he acted so bad, fighting with his wife, etc., that I ordered him to leave the house. Have seen him reel a few times when he was far gone with drink, but he usually carried himself well. Mrs. Kate Owens. Reside in Cleveland. Have known Dr. H. between 3 and 4 years. Was at his office on the 6th and 7th of August. He was there on Sunday the 6th, but not on the 7th. Word was left on his slate that he would be back in a little while. That was his habit. On Monday evening before the murder, I found this entry. I will be back in a few moments. Dr. H. had been my family physician off and on about 3 years. Oscar Russell. Have known Hughes about 2 years. Was with him the day of the murder and all the night before. Met him at the St. Nicholas Saloon about 8 or 9 o'clock that evening. We drank there, don't know what, for I was drunk. I don't know that Hughes was drunk. We stayed there 5 or 10 minutes and then went to several drinking places. Went to Carr's carriage, and Hughes asked him what he would charge to take us riding all night and come back in the morning. Saw a pistol lying in Hughes's trunk in his office when we were there. I said, "That's a nice shooter you have." Hughes said, "Yes, I'll put it in my pocket." He also took a flask and had it filled downstairs. When the driver said he could not find some women he had been looking for to go with us, Dr. H said he could find some in the country, and we started. At Newburgh, Hughes engaged rooms at the Cataract House and said we would be back and stay there all night. I was asleep on the way to Newburgh, and also when going from Newburgh to Bedford. At Bedford, we were to be called at 7 in the morning. Hughes said we had better get home and attend to business. In the morning, we drank whiskey several times, both before and after breakfast. We started home, and I asked Hughes where the women were he was going to see, and he said he would show them to me on the road home. At the grocery opposite the Plank Road house, Hughes and I drank ale about 25 times. At Crumb's house, Hughes proposed to me to go to Parsons' house, introduce myself as Major Hanson, tell them he was out there and they would send out for him, which I refused to do. While going back to Bedford from Crumb's, I was asleep. Was sitting in the bar room of the Fountain House, Hughes having gone out, when the driver car came in and told me there was a muss. Ran out and saw Hughes coming around the corner, keeping all off him with a revolver in his hand. He came to me just at the carriage and told me to get in, which I did. He got in and pointed the revolver at the driver and told him to drive on, saying, "Drive or I'll shoot." Got out then and climbed up to the driver. I never told any man to let Hughes alone or I'd blow his brains out. I hadn't anything to blow anybody's brains out with. When Hughes came up to me at the carriage, his face was red as fire, his eyes just as if popping out, and he was mightily excited. Told the driver to drive, or we would both be shot, and he drove as fast as he knew how. Don't remember of giving Hughes any money after the shooting. Hughes boarded with me from July 14, 1865, till the time of his shooting. Saw Hughes drunk once before this affair. His face was very red, and he talked a great deal. Saw him only once deep in liquor. He talked fast, his face was very red, and he told me of his troubles. I came near going to the penitentiary, he said. I asked why. For having 2 wives, he replied. J.D. Keegan. Have known Hughes since the spring of 1862. Am a druggist. Have seen Hughes quite frequently under the influence of liquor. The effect of liquor on him was always very marked. It made him very reckless. He seemed to have no regard for his character and to be indifferent as to what he might do while in that condition. When drunk, he seemed utterly demented and senseless. Was always much flushed then, eyes bloodshot, talkative, and so offensive in what he said that I forbade him coming to my store. Didn't affect his walk much. When sober, he was very gentlemanly. Paul McGuire. Keep a grocery on Ontario Street. Hughes was in my place between 8 and 9 o'clock with Russell, the evening they went to Bedford. They drank something then. Dr. Hughes got a half-a-pint flask filled with whiskey there. Was going into the country, he said, to see a patient. Have seen Hughes in liquor. When drunk, his face was red. Never knew him to stagger any, no matter how much intoxicated. He was ugly at such times. James Brown. Keep a saloon in this city, Bolivar and Pittsburgh Streets. Dr. Hughes was in my saloon the night before the murder with Russell and a hack driver, about 9 o'clock. They drank there. Saw nothing out of the way in them. T.J. Quinlan. Have known Dr. Hughes 3 or 4 years. He opened an office opposite my place last summer. Saw him the evening before the murder in my store. Said he was sleepy and tired and was going home to bed. Have seen him under the influence of liquor. His face would get red when drunk and his eyes grow larger, but his walk was steady. Very few would ever know he was drunk. Edward Nichols. Am 14 years old, know Dr. Hughes. Was in his employ 2 weeks and 3 days. The engagement ended on the arrest of Dr. Hughes. Ran errands, made his bed, etc. Saw the pistol under his pillow every morning when I made the bed. Alfred Eastwood. Am not acquainted with Dr. Hughes. Saw him last at a grocery near Plank Road House the day Tamsin Parsons was shot. He and the rest were pretty well set up when I went in. John Cubbin. Have lived in the city 23 years. Born in the Isle of Man. Knew Hughes there when a boy, and his parents. Was brought up in Hughes's father's house from time I was 10 years old till I came to this country. His grandmother, Jane Kenwich, was insane and committed suicide about a year after her husband's death. Other members of the family on the grandmother's side were insane. 1 and I think 2 committed suicide. The conduct of Hughes when he is sober is gentlemanly and proper. Mr. Castle. What effect had drink upon the prisoner's father? The question was objected to by the state, and the court ruled that it was not relevant. Mr. Andrews. Know Hughes, saw him on the day of the murder after his arrest. He looked like a man that had been drinking considerably. His face was red, his eyes looked very wild. Have seen Hughes drink several times, but never saw him stagger. He is very slow in speech when drunk. Have never seen him excited. Jazz Tear. Have known Hughes since he had been in Ohio and knew his father and grandfather. His grandfather committed suicide when insane. It was common talk that an uncle of his committed suicide in Demara, but I don't know of it positively. Edward B. Campbell. Have known Hughes for 5 years. Saw Hughes when a member of the 5th Dragoon Guards in the English Army during the Crimean War. Also saw him when he was assistant surgeon of the 85th Regimental Corps d'Afrique in the Federal Army at Vicksburg, in charge of a Marine hospital. Have never seen him stagger when drunk, and a person not acquainted with him would not discover that he was drunk. I.S. Eli. Have known Hughes about 2 years. Saw him at my home on the day of the murder after his arrest. He did not seem to be intoxicated, but his face was very red and his eyes wild and excited. Saw him the night before and judged he had been drinking a great deal. William Lewis. Knew Hughes when he was a boy at school and when he lived at Warrensville. Knew nothing bad of his general character. Charlotte Parsons. Have known Hughes 2 or 3 years. Am sister-in-law to Tamsin Parsons' father. Was at Hughes' office the day before his trial at Justice Porter's. He engaged to come to my house on Sunday to treat my ears. At Tamsin's house, I told her that Dr. Hughes was going to operate on my ears at my house, and asked her when she was coming. She said she wanted to come the worst way, but her mother was up to Haynes's, and she said, "You know I mustn't say any more." I told Tamsin Hughes was coming up Sunday and asked her if she wasn't coming up. She replied as before. Mrs. Harriet Robinson. Live in Bedford, know Hughes by sight, not personally. Was well acquainted with Tamsin Parsons. She was at my house twice after Hughes's arrest for assault. She called at my house to get a carriage to attend the trial. I said, "Tamsin, I should think you would be afraid to be out at night, for fear you will be disturbed." She replied she thought he would not injure her or hurt a hair on her head. She told me what had happened the night he was at her house, and said next morning she was going to withdraw the suit. O. B. Judd. Have known Hughes since 1861. His reputation was that of a quiet, gentlemanly man. Saw him once intoxicated. He was apparently wild and did not know what he was about. John Burke. Knew Dr. Hughes in Warrensville. His reputation was that of a good moral man when attending to his business. Until the affair with Tamsin, his reputation was good. William Crum. Recalled. At the grocery near the Plank Road house, Hughes said to me he wanted to see Miss Parsons, that he wanted to have a talk with her. He said he had met them on the road, but Suxy, Mrs. P., was so full of hell he could not talk to her. He said he wanted to make provision for her support so she could draw her money every 3 or 6 months or year, or if she got married, he would give her a check for $500 on a bank. Said he had word from Governor Breaux to go to Nashville and take charge of a general hospital. P. Roeder, physician of the county jail, was called to see Hughes next morning after his arrest about 9 o'clock. He labored under great mental excitement and showed some of the symptoms of delirium tremens. His face was flushed, eyes protruding, and his pulse was frequent and weak. His tongue was coated and feverish. I ordered whiskey, did not visit him again until next day, and continued to call frequently. The symptoms of delirium are those I have described. Dr. P. Thayer, physician, have known Hughes since his arrival in Warrensville. Saw him under the influence of intoxicating liquors frequently. Could always notice by his face if he had been drinking. At one time in July last I saw him perform an operation when he had been drinking. He was nervous, but he performed the operation. During the time I saw no muscular effect of liquor. Sheriff Nicola, sheriff of Cuyahoga County. Saw Hughes at the door when he was brought in night of his arrest. Next morning between 8 and 9 o'clock, Hughes appeared to be under great nervous excitement. Was advised to give him whiskey, which I refused unless advised by the jail physicians, who were called and gave him as before stated. Was present at all interviews between the prisoner and others. I had no conversation the first night, but about 10 o'clock he begged for liquor, saying, "For God's sake, give me some beer." H. S. Smith, jailer of the county jail, saw Dr. Hughes the first time when he was brought in after his arrest. Should judge he was pretty drunk. His face was very red, and he had a wild look on his countenance. Next morning he had the shakes. Called Dr. Roeder, who ordered me to give him whiskey and laudanum in doses of about 25 drops of laudanum with a drink of whiskey 3 or 4 times a day for about a week. Also gave him valerian 3 or 4 times a day. While giving him the medicine, his appearance was one of being troubled with the delirium tremens. His appearance and conduct since then has been good. Dr. Strong, Am a physician and surgeon, have treated cases of delirium tremens to the number of over 100. The higher and greater the development of the brain, the greater the excitement produced. Have known Hughes 4 or 5 years, have seen him intoxicated. His face was florid, language very intemperate, but when sober found him to be a perfect gentleman. Think that the effect of liquor on him would be that of excessive excitement. He was, when intoxicated, inclined to be quarrelsome, but did not stagger. Dr. D. G. Streeter. Know Hughes. I boarded with him at the Franklin House. Have seen him intoxicated 3 or 4 days at a time. Liquor seemed to increase his muscular power. Saw him once after several days' excessive drinking start to see a patient to perform an amputation. He asked me if I would not go. Had with him a mechanic's saw and a butcher knife. He said that a French surgeon had recommended them in a case of emergency. He was going to use them. Think he had surgery on the brain. Eliza Crum. Remember the night Dr. Hughes was at Parsons' house in July last. Saw his buggy in the road, searched it and found a bottle of liquor in it. Took it home with me. It would hold near a quart. Should think it was either cherry or blackberry brandy. Thomas McKinstry, M. policeman. Remember the day in August of the arrest of Hughes. Left in pursuance of a dispatch received from Bedford to make the arrest. Just before getting there, met the carriage with Hughes in it, he having been arrested. Got into the carriage and came to the jail. Hughes looked to me like a man who had been on a long drunk. That was his general appearance. He is evidently a man who can stand a great deal of liquor. His walk was not affected, but his face and talk revealed the fact of intoxication. Have known him 4 or 5 years. His face was bloated a good deal and of purple color, his eyes very much bloodshot. He was very nervous, was close by him in the hotel, and when combing his hair, his hands showed that his nerves were all unstrung. He talked in a bravado manner, rather boasting of what he had done. After he washed, the doctor went to the bar and drank a glass of ale. Think he drank 2 glasses. Have frequently seen Dr. Hughes intoxicated. When in liquor he was foolish and did not seem to care what he did. When intoxicated he would talk foolishly and incoherently and do foolish things. He seemed to know perfectly well what was going on around him when I saw him in the carriage. He recognized me and spoke to me. He conversed freely and coolly about the transaction. Mary Quillman. Lived in Hughes's family 3 years ago, about 5 weeks. Have seen him under the influence of drink. He appeared very sullen, his eyes were glassy, his face very red, seemed very nervous, and sometimes got very much excited. His walk was never noticeably different when drunk. Saw him once when very ugly. He had been away all night. He came to me in the kitchen. I asked him what he wanted. He took hold of me with both hands, and I had to defend myself. I had the stove handle in my hand, struck him across the arm with it, and he let go. Have seen him drunk several times since I left his house. An affidavit of the defendant made to support a motion for continuance of the case was here read by his counsel. It alleged that the defendant was unable to procure the attendance of J.J. Patterson and G.O.S. Kimball, medical officers of the United States Army, well acquainted with defendant, who would swear they have often seen him intoxicated, and in this state very singularly affected, suffering under total aberration of mind, while his muscular system was unaffected, that it was essentially necessary to arrest him often to prevent injury to himself and best friends, and that this effect was, in their opinion, entirely due to the influence of liquor, but was involuntary. The motion for continuance having been disallowed, the allegations of the affidavit were admitted as testimony. The speeches of counsel. Mr. Slade. Gentlemen of the jury, after a long and patient examination of this extraordinary case, we are now drawing our labors to a close. This is a case involving the highest consequences not only to the prisoner but to the community. Subsequent developments have fully sustained the position taken by the prosecutor at the opening. Against the prisoner at the bar we can have no personal feeling, but we must deal with him as a criminal who has committed the highest crime known to law. The prisoner has had every lenity shown him by the court. Eminent counsel has been assigned him, and nothing has been left undone to extenuate his great offense. But while every man is presumed to be innocent till proven guilty, when once shown to have violated the law, then to waver in conviction is treason to duty. The highest sanction is necessary to protect life. For the frightful increase of murder, robbery, and other high crimes there must be some cause. What is it? It is because when crimes are detected, there is so much uncertainty of punishment. There is even admiration for the great criminal after the momentary excitement has passed away. The people everywhere are asking if a man can be convicted of murder in the 1st degree in Ohio. Now, what is the crime alleged against the defendant? The learned prosecutor has stated that it is the highest crime known to the law of the state. Let us now turn and examine and review the law and evidence in the case. What is the crime of murder? In the common law of England, murder was the taking of life by a man in his right mind, with malice, etc. In our statutes, discrimination is made. Murder in the first and second degrees and manslaughter are recognized. Murder in the first degree is the taking of the life of another with deliberation and premeditated malice. Murder in the second degree is the taking of life purposely and maliciously, but without premeditated malice. To constitute murder in the first degree under our statutes, the act must be done purposely, deliberately, premeditatively, and with malice. Purpose means intention, the making up of mind to commit an act. The second element to be considered is deliberation. Premeditation may be ranked with deliberation. It means to weigh, consider, revolve in mind, and enact before its accomplishment. The third ingredient is malice. There are two kinds, expressed and implied. In the first, there is a lying in wait to commit the act, and the committing of it with a sedate, deliberate mind and with a formal design. The evidence is circumstantial. In the second, the act may be perpetrated or consummated while the person is doing another unlawful act. This will suffice for the statement of the law in the case. Of the fact of murder by this defendant there is no question. Let us now turn to review the evidence in the case by way of refreshing our memories. End of section 65. Section 66 of American State Trials, Volume 2. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Claire. American State Trials, Volume 2 by John D. Lawson. Trial of Dr. John W. Hughes for the murder of Tamsin Parsons, Cleveland, Ohio, 1865, Part 3. Mr. Slade then reviewed the history of the affair, commencing with the seduction of Tamsin Parsons, an unsophisticated country girl whose youth and ignorance made her the easy victim of this cool, calculating man. He narrated the flight to Pittsburgh, the marriage, the pursuit of Haynes, the discovery by Tamsin that her husband was a bigamist, his arrest and trial, his incarceration and her return home, his sudden appearance 4 or 5 months later and immediate attentions to Tamsin, telling her he had sent away his first wife, that he might take her to live with him in Cleveland. He detailed his subsequent actions, his breaking into Mr. Parsons's house on the night of the 25th of July, his visit to Dr. Ray at Warrensville the next day, asked him if he had a pistol, and saying on Ray's asking him what he wanted of it, "If that damned bitch don't stop calling herself Mrs. Hughes, I'll shoot her," his stay at Plank Road House that night, and his remarks to Mrs. Eddy at breakfast the next morning, Wednesday the 16th. "Pity it hadn't blown her damned brains out and saved me the trouble some time," in response to Mrs. E.'s telling him that Tamsin had a ball recently passed through her parasol, his drive to Bedford that morning, and statement to Mr. Salisbury that he must hunt up Tamsin, and if she won't live with me, I'll kill her. His trial before Justice Porter the next Saturday for the crime of housebreaking, his settlement of the difficulty with Tamsin through the mediation of Mr. Henry Parsons, and Hughes's solemn promise never to have more to do with or to say to this girl, his violation of the promise within 2 weeks, all this going to show the threat of the intention in Hughes's mind to kill this girl as an alternative. He was not intoxicated when he made these statements to Mrs. Eddy and Mr. Salisbury, and from them we can see the latent purpose, the absorbing thought of Tamsin, the desire to have her live with him, and his deepening intention to slay her if she refuses to comply. The precision with which Hughes fired, aiming at the vital point, his taking money from Russell as he left the carriage in flight, and his run to the woods to reach the cars, his coolness after the capture, and the statements of intention by the defendant on the ride to the city show that he was in his right mind, that the murder was a deliberate, rational act. There was nothing to show that he was in a frenzy and in such a mental state as to make him irresponsible for his act. Mr. Slade then entered on the consideration how far the question of drunkenness should enter into the palliation or mitigation of crime. If a man has formed the purpose to commit murder, it makes no difference if he became drunk before committing the deed. Voluntary drunkenness is no excuse for crime committed in that state of intoxication. Though it reduces a man to a state of temporary insanity, it is no defense of crime. It would not shield a man if he was sane before he became drunk. A drunk malice is as dangerous and quite as wicked as a sober one. Intoxication must be considered like any other fact, to discover the status of a man's mind. If counterfeit money is found on the person of a man so drunk that he knows nothing of it, the fact of drunkenness refutes the evidence of crime. But if he had it before he became intoxicated, the fact of intoxication should have no weight, and precisely the same application must be made in this case. It makes no difference whether Hughes formed the purpose to kill Tamsin Parsons 2 weeks or 2 months before the deed was committed. He is as guilty in one case as in the other. Nor does it matter how much liquor he may have drunk if he knew what he was about at the time of the murder. Gentlemen, let us for a moment pass in review of this case, bloodiest in the annals of crime. The facts cannot be denied. The defendant himself boasted over the ruin he had wrought, that he should meet the murdered one across the great waters. It seems to me even now and here he might see her wandering by a shadow like an angel with bright hair dabbled in blood. Tamsin Parsons died in defense of her virtue. When the seducer came in the person of a man pleasing address and finished education, with a forged degree of divorce in his hand, he found her a mere child yet at school. She yielded to his machinations and was lured from home and friends. The forger became the bigamist and wrote on his forehead the horrid crime of adultery. Her friends followed. She learned of his deception and was rescued from the jaws of her remorseless prostitution. Anon the forger, the bigamist, the adulterer was doomed to confinement for a year within the walls of a prison. After 4 months, we find his poor wife, the mother of his child, true to her womanly instincts, wending her way out to our city, procuring signatures for his pardon. She obtained it. What promises he makes we know not. Does he not come to her with contrition and gratitude? No, he banishes her and the child. For what? That he may again set his snares for the young and unsuspecting Tamsin, that he may lead her into a life of prostitution to end her days with those fallen ones who are bought with a price. The forger, the bigamist, the adulterer seeks again his prey, plies his arts. The mother of the child hovers near. Tamsin says, "You have deceived me once, you cannot again." He will not desist, counts upon his strong control. He is mistaken, she will not yield. She seeks the house of refuge given by a Christian woman, nearly entered. He sees all is lost. He cannot possess her. He draws, takes deadly aim, fires, and Tamsin dies to live in heaven. The forger, the bigamist, the adulterer, John W. Hughes, walks forth a murderer. Let a monument be raised in memory of fallen virtue, which the young and fair can look upon when we are dead and gone. From this sad tragedy we learn, quote, "The triumphs that on vice attend shall ever in confusion end. The good man suffers but to gain, and every virtue springs from pain. As aromatic plants bestow no spicy fragrance while they grow, but crushed or trodden to the ground, diffuse their balmy sweets around." End quote. Gentlemen, we throw upon you the burden of this case. It rests with you. You have solemnly sworn to decide this issue according to the law and the evidence. Mercy rests not with you, not with the judge, but with the governor of the chair of state. You are to do justice, nothing more, nothing less. I ask you in the name of that community so cruelly outraged that waits patiently to see whether under any circumstances the highest penalty can be enforced. I ask you in the name of violated chastity everywhere. I ask you in the name of God, whose image has been so cruelly defaced, and finally, I ask you in the name of the very law itself, to this day mark by your verdict your estimate of the protection which shall be given to the poor man's child. Mr. Knight, gentlemen of the jury, the business here committed to your charge is one of the most important that ever arises in the affairs of men. The inquest that you now hold is one that involves the life of the unfortunate prisoner at the bar. And in a matter of such great importance, it is of utmost importance to the faithful discharge of that duty, that you look well to yourselves, and see that in making up your judgment you shall be uninfluenced in any degree by prejudice or passion, and that your deliberations shall be entirely free, and your conclusions totally unaffected by either passion or prejudice. A man of great uniformity of temper and strong predispositions to vice, after hours of drunken revelry and dissipation, and in an unfortunate moment when madness, like a destroying angel, has usurped the dominion of his mind and subverted reason from her seat, committed what the prosecution and the populace see fit to characterize as murder. And hence there has arisen a powerful prejudice against the defendant. I ask you in behalf of justice, in the name of liberty, which is your duty to shield and protect, that you shall remain unaffected by it. Let it storm walls as wildly, madly, and furiously as they may around this temple, and gather and beat until it shall rock upon its foundations, still no breath should enter here. I pass now, gentlemen, to a consideration of the law as applicable to this case. The defendant is charged with murder in the first degree. To make that out, the state have to establish 5 things. First, the killing. Second, that it was malicious. Third, that it was purposely done. Fourth, that it was done with deliberation. And fifth, that it was done with premeditation. What now are we to understand by these several elements which constitute murder? It is a rule of interpretation that we are to give effect to each of the words of the statute or of an instrument which we wish to interpret. Mr. Knight cited various authorities to throw the meaning of the several words above named, and the general conclusion deduced that the meaning of the first section of the Crimes Act containing the above words and under which the defendant is charged is that the killing must be done in pursuance of an intention or design to kill, which intention must have been formed before the party attempted to execute that design, and that he must have stopped to consider, to weigh in his mind that design, that if the act was committed whilst the defendant was in a fit of anger or of rage induced by the deceased, he would not be guilty of the charge, that if the intention to kill was formed whilst the defendant was subject to any passion which disqualified him for deliberation, and that intention was executed while still under the influence of that passion, he would not be guilty, that the intent to kill, although not essential to constitute murder at the common law, is by the first section of the Crimes Act made an ingredient of that crime, that deliberation and premeditation, although not an essential element of murder at common law, is by the same section made an element of that crime, that the presumption of law arising from proof of killing alone is that it was murder in the second degree and not murder in the first degree, that the jury have, in addition to the finding of a homicide, to find expressly and from proof an additional element of deliberation and premeditation, that no extent of proof of malice simply will warrant the finding of deliberation and premeditation, but that in addition to the proof of malice, there must be proof of deliberation and premeditation as distinct facts and elements of crime, that drunkenness is competent in a charge of murder in the first degree to be proved to the jury for the purpose of showing that the defendant did not at the time of committing the act have sufficient understanding to intend the act, and that drunkenness is competent in all cases where the intention is an element of the crime. Now, gentlemen, this much with regard to the law for the present. I wish to call your attention to a few facts which have been given you in proof, and first I wish to invite your attention to a startling fact disclosed in this investigation in regard to the peculiarity of the defendant's troubles and the melancholy results, and the troubles of his ancestors and their equally unfortunate results. You cannot fail to remark it as impressive coincidence that the kind of trouble which led his ancestor, his grandmother, to commit suicide was the deep grief that gathered and settled upon her heart at the loss of her husband. Thus she became at once subject to fearful visits of awful madness, and in a few months after her loss, in one of her fits of insanity, she terminated her life. So when the defendant realized the fact that she, whom he most loved, had forsaken him, he, like his unfortunate ancestor, became suddenly wild, a maniac, and in its awful visitation he took the life of Tamsin Parsons and contemplated taking his own. It is a singular coincidence that the same character of trouble should befall him as befell his ancestor, and it is equally singular that it should fall with such fearful and yet singular effect upon each. It certainly indicates clearly that some infirmity, defect, or predisposition on the part of his ancestors has been transmitted to him as the hereditary accumulation of the morbid predispositions of his ancestors for generations, exalted and intensified in the organization of the defendant. And it is also a singular coincidence that the same character of trouble which led his grandmother to commit suicide led him to contemplate the same melancholy purpose. Nothing is better settled than the predispositions to insanity are transmissible from parent to offspring. Nay more, I cite you the authority of Wharton and Stell, medical jurisprudence, to the fact that the predispositions to lying, cheating, drunkenness, theft, and all other moral vices are as transmissible as gout, consumption, deafness, blindness, and almost all other constitutional diseases. And if that be so, and it is so, then I can clearly understand how the unfortunate defendant comes to be possessed of peculiarities of temper and mental tendencies and susceptibilities which characterized his ancestors, and you then have also the key to the fact that the effect of a great disappointment on him would be like the same on his ancestor. The doctrine of hereditary insanity is comparatively new. Not long ago, insanity in all its forms was simply believed to be a visitation of God, on which we might look with wonder and grief, but to which it was our duty to bow submissively. It was not thought that it was a condition of the mind, which might be traced to a proper and adequate cause, either growing out of some hereditary defect or developed by the circumstances of habits of its unfortunate subject. But now it has come to be well understood that insanity is attributable, like any disease of the body, to causes which operate to its development. And now, in the light of recent investigations, the origin and causes of insanity have been searched out, and the great truth established that insanity is transmissible by inheritance. The birthright of my unfortunate client was a powerful tendency to insanity, derived from his ancestors generations ago. In the early part of the present century, insanity was not permitted to be given in defense of crime, but as its origin and extent were gradually studied and understood, its claim to a hearing and excuse for crime came to be recognized and adopted, and now not only the insanity of the defendant himself, but the insanity of his ancestors may be shown in his defense. Man is a peculiar being, and strangely compounded of different natures marvelously mixed. On the one hand is the nobility of his reason and the infinity of his faculties. He is allied to angels and to God. And on the other, in his passions and necessities, he is linked by an inevitable fatality to the beasts of the field. Quote, "How poor, how rich, how abject, how august, how complicit, how wonderful is man." End quote. It was the full realization of the marvelous mixing up of large extremes which led the poet in astonishment to exclaim, quote, "Oh, what a miracle to man is man." End quote. My client was subject to a wild and foolish infatuation in affairs of love, but he is not the first or only one who has become the deluded victim of infatuation. They have existed in all ages of the world. But sometimes this infatuation takes one hue and sometimes another. It has manifested itself in one person in a morbid and overruling desire for money. Midas, for some service that was rendered by him to Bacchus, was told he should have whatever he wished. And so absorbing was his desire for gold that he wished that whatever he touched might turn into gold. And from those mythological times until now, there have been these whose whole being has been absorbed and overshadowed by this ruling passion. Sometimes it manifests itself in dreams of ambition and glory. A diadem casts its maddening gleams into the eyes of ambitious men, and they long for that giddy elevation and are ready to wade through slaughter to the throne. Every desire is for that end, and every thought is how they can gain it. Sometimes it takes a religious turn, and from the time when Peter the Hermit went back from Asia to Europe and kindled a fire of enthusiasm which lighted up all Europe, and which led to the famous Crusades, until today, there have been religious enthusiasts who, in the wilderness and blindness of their enthusiasm, have looked on a martyr's death with indifference. Again, it takes the more tender form of love. Paris stole the Grecian Helen and fled with her to Troy, and this illicit love led to the siege and utter destruction of Troy. Mark Antony, the greatest of Rome, gave up the world for Cleopatra. Leander swarmed the Hellespont for his love. Henry VIII of England, under the influence of this passion, threw off the power of the Church of Rome in England, and established himself as the head of both church and state, and thus led the way for the emancipation of the English people from the fearful, tyrannous grasp and authority of the Roman Church. And so all through the world's history, both in ancient fable and in ancient and modern history, we find numberless examples of those over whom the tender passion held complete control. My unfortunate client is one of the latter class. Love is the ruling passion with him. It absorbs all others. It rises out of his temperament as natural as perfume issues from the rose. To this peculiar tendency of his temperament he adds the morbid predisposition in the same direction which he inherited from his ancestor, and to both of these he superadds the stimulating and exciting effect of intoxication. These tendencies of temperament and hereditary morbid predisposition, excited and intensified by intoxication, give that passion a supreme and absolute control over him. And the whole strength and current of his being sets in that direction and makes the object of his love everything to him. But the prosecutions say, and truly too, that the defendant is a person of extraordinary intellect and of rare learning. We admit it. But is a great genius proof against vice and temptation? By no means. The power to control our sections lies not in the greatness of our intellect or the power and activity of our moral force. If the intellect alone is the power which exercises moral control over any individual, then the most intellectual man would be the best. But is such the case? No, gentlemen. Lord Bacon, one of the most intellectual of men, on account of his vice and crime, has been characterized as the brightest, wisest, meanest of mankind. And it was in a felon's cell that he gave birth to those wonderful lucubrations which fell on the earth like an apocalypse of nature, and from which arose the exaltations of a new intellectual morning that has arisen into a still increasing day, the genial sun of which has warmed into life a giant brood of useful arts and a still more giant brood of useful sciences, and which rolled back that cloud of darkness which enveloped the earth for 1,000 years. Our safety from vice cannot be found in the strength of intellect, but alone in the complete ascendancy of the moral natures. The great intellect and attainments of defendant could have no force in restraining the wild, morbid, and overpowering passions which were his inheritance. With a weak nature, the defendant was possessed of a most powerful, passionate nature, which, when it found an object meeting its fancy, made him become wildly and madly attached thereto. Tamsin Parsons, the deceased, was that object. He loved her madly and blindly, and when he found the object of that love had forsaken him and turned away from him, the awful passion of love was disappointed, and he, under the influence of disappointment, became insane, and when that fearful cloud and paroxysm crossed his mind, his intellect became eclipsed, and failing in self-control and judgment, perpetrated the fearful deed. We ask you, when you retire for deliberation, to so decide that when you shall separate from your labors here and return home again, you may say in your devotions and prayers to God, quote, "That mercy I show to others, that mercy show to me." End quote. Mr. Castle discussed the evidence taken by the state, reviewing it generally and with analysis and criticism, and putting upon it such construction as he claimed was warranted by fact or proof in the light of reason. He worked his way through this mountain of evidence with industry, persistency, and endurance. His argument abounded with passages of eloquence, pathos, invective, satire, and impassioned appeal. His theory of the case, came by evidence, was that Tamsin Parsons was not a mere child, as represented, but a person come to responsible womanhood, that there was a mutually reciprocal passion burning in the hearts of her and Hughes, that she knew he was a married man, that the claimed forged bill of divorce must have been executed in Pittsburgh after the elopement and with her knowledge, that she never gave over her love for him, albeit she listened to the solicitations of her friends and returned home, for, on the night of the 24th of July last, she testified her willingness and even desire to keep his company when her father had gone to Bedford for an officer to arrest Hughes for housebreaking and assault, and by holding an interview of 2 hours' duration with him at the yard fence, that at no subsequent time did she manifest the slightest ill will toward him, that he loved her with a wild idolatry, albeit it was an illicit love, that all his day was but a thought of her, and she his dreams by night, so that life was nothing to him without her, that, when baffled by the opposition of her friends, and set on fire of hell by excessive drinking with his predispositions, while intoxicated to insanity, reason forsook her seat as Tamsin flitted across his path on that dark day when he slew her, that the murder was the sudden impulse of a brain crazed by drink, and no deliberate malicious act. Mr. Castle devoted much time to the ventilation of the alleged threats made by Hughes to take Tamsin's life, that to Dr. Ray on the 25th of July, when he said that if she did not stop calling herself Mrs. Hughes, he would kill her, that to Mrs. Eddy the next morning at breakfast at the Plank Road house, in response to her informing him that a bullet had been fired through her parasol, "Pity it hadn't gone a little lower and blown her damned brains out, and saved me the trouble some day." And that to Vile Salisbury at Bedford the same day, "I must hunt her, Tamsin, up, and if she won't live with me, I'll kill her." He dwelt long and loud on the essential absurdity and improbability of his making such statements when his love for her is considered his desires and efforts to get her to live with him. It is inconceivable that, if he meditated her murder, or desired to take her life, that he should thus drum up witnesses of the contemplated deed, and so plan things as to make his conviction fatally sure. It was the poison he had swallowed in copious draughts which killed Tamsin Parsons, not John W. Hughes. End of section 66. Section 67 of American State Trials, Volume 2. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Claire. American State Trials, Volume 2 by John D. Lawson. Trial of Dr. John W. Hughes for the murder of Tamsin Parsons, Cleveland, Ohio, 1865, Part 4. Mr. Palmer, gentlemen of the jury, I stand before you for the last time in the discharge of the responsible duties connected with the investigation of this important case, not to measure rhetorical blades with my friend who opened for the defense in the shadowy region of metaphysical and theoretical speculation, in which for the greater part of his address he roamed, nor to test pinions with my other friend who closed for the defense, who has so long delighted us by his adventurous flights of eloquence. The business of this hour requires of me to render such aid as I may in elucidating the truth from the testimony rehearsed in your hearing, and to that task, impressed with the solemnity of the duty I have to discharge, I now address myself. It is truth which is at issue here. I shall show you that we have established every point made in our opening statement. That is a complete drama, with a beginning, all the consecutive stages of development, and a tragedy for a fitting conclusion. 1 year ago, this defendant was brought before the mayor of Pittsburgh, charged with bigamy. All this tragedy has been developed in 1 short year. Let us review it. The curtain rises in the quiet village of Bedford, and 2 characters came upon the stage, a little over 1 year ago. Who are they? One has been before you for the last 2 weeks, a mature man of the world, educated and polished. The other, an unsuspecting country maiden, 17 years of age, inexperienced, confiding, who now sleeps quietly in the cemetery at Bedford. This man sought that virtuous, artless maiden in her secluded home, at a time when she was deprived of her mother's watchful care, and plied the arts and fascinations at the command of a cultivated, experienced man of the world. His honeyed words meant lust, love. Forgotten by him were all the lessons of childhood, solemn marriage vows, the pleadings of his innocent boy, who claimed from him the legacy of a fair name. On Monday, December 19, 1864, the parties leave Bedford for Pittsburgh. The mother of Tamsin hears of the flight on the same day, and sends her son-in-law in pursuit on the 20th. Lured thither by the tempter, he prevailed over this unsuspecting maiden's heart, and induced her to take this step by the exhibition of a bill of divorce, which he had forged for that purpose. They had been married. On the 21st he was arrested on the charge of bigamy and flung into jail to await trial, and she, bitterly deceived, returned to her father's house. And the curtain falls upon a felon's cell, its inmate leprous with lust, a forger, a bigamist, and an adulterer. In January he was convicted and sentenced to the penitentiary of Pennsylvania. During those 4 or 5 months of imprisonment, what was passing in his mind? This imperious nature brooded over his failure to carry out his designs. He could not brook it. He would show Tamsin Parsons, when he got out, that he would accomplish his purpose. His will becomes more relentless and determined, and he makes a resolve not to be foiled again. For accepting, in early summon, the boon of liberty from the hands of his devoted wife, whom he treated with equal cruelty and meanness, he was no sooner released from the penitentiary than he makes his appearance here in July last, and sets about completing his foiled purpose. He sends away his wife and child to his native Isle of Man, that they may offer no impediment. 3 several times the defendant himself expressly said that he sent them away in order that he might get Tamsin to live with him. He will live with her. On the night of the 24th of July, these characters come upon the stage again. He enters her father's house late at night, seeking an interview with Tamsin. For 4 long hours he exercises all his powers of fascination and persuasion in vain. "You have deceived me once, and you shall never do it again," she reiterates in answer to his passionate urgings and entreaties. He drives off, foiled again, and by this young girl, towards Warrensville. That imperious will has once more been balked, and his spirit chafes and rages at the result of the interview. He sees Dr. Ray at the Warrensville house on the morning of the 25th, and in conversation with him the feelings of Dr. Hughes's heart are shown and his purpose vaguely expressed. He is provoked, angry, and the first sparks of a kindling revenge show themselves. He asks Dr. Ray if he had a pistol. "No, why?" "That damned Tamsin is calling herself Mrs. Hughes, and if she doesn't stop, I'll blow her brains out." He indulges freely in drink, and when he arrives that night at the Plank Road house he is drunk. His purpose is more distinctly stated before Mrs. Eddy at breakfast on the morning of the 26th. When, in response to her information that a ball recently passed through Tamsin's parasol, he said, "Pity it hadn't gone a little lower and blown her brains out, and saved me the trouble some time." He is still brooding over his disappointment, the thwarting of his darling purpose, and in these statements we get glimpses of the state of his mind toward the girl. A few hours later he meets Vile Salisbury, and the expression of his purpose is no longer vague or even indistinct. "If she will not live with me, I'll kill her." He is arrested on Thursday on the charge of housebreaking, examined on Saturday before Justice Porter in this city, Tamsin herself making an affidavit against him. This act of hers makes his failure all the more apparent, and his prospect of success now seems hopeless. He buys the pistol that day, the pistol with which 2 weeks later he shot her. He meets Henry Parsons that evening, who advises him to settle that difficulty and offers himself as a mediator. Here is a gleam of hope to Dr. Hughes's mind. If she can be reconciled unto him, he thinks he may still win her with his charms. They go to her house the next day, Sunday, when Henry Parsons, after a 4 hours' interview with Tamsin, gains her consent to stay the prosecution, but on the proviso that the doctor shall solemnly promise to molest her no more. He was maddened by reason of the length of time taken to settle, even on these terms. The settlement was made, the promise given. Here was a new hope for the successful issue of another effort. That strong will, never yet balked, was not willing to acknowledge itself conquered by a village maiden. He awaited an opportunity, and on Tuesday evening, August 8th, it occurred. He met Russell, they drank. Russell proposed to drive. The defendant engaged for a ride to Bedford. Here is a twin villain who will aid him perchance. If they meet Tamsin and she refuses to go with him, they may kidnap her. The pistol and flask of whiskey are taken by Hughes. They are necessary attendants in all purposes and deeds of violence and blood. They start with a double lie of calling Russell Major Hanson, and that their errand is the amputation of a limb. Hughes was not drunk. He gave all the directions on the road. Arriving at the crossroads near Bedford, Hughes ordered the driver to stop. Why? He was debating whether it were better to go there that night or wait until morning. He had failed in one nocturnal visitation. He would try his fortune in daylight. They stop at the hotel. It is not corroborated that Hughes drinks much the next morning. They set out, see Mr. Christian in the street. Hughes sends for him with the remark, "That man cost me $50. It was he, her warm personal friend, who brought Tamsin into the city to file an affidavit against the doctor. It shows that he was brooding over the matter. He evidently wished to learn where Tamsin was, whether at his house in the village or at her father's, so as not to lose his journey. They drove on, Hughes ordering the driver to turn to the left on the road where Mr. Parsons lived. He sought a private interview, believing it in his power to revive her love for him. He meets Mrs. Christian at Mrs. Parsons's house and learns that Tamsin and her mother have gone blackberrying. When she tells him not to trouble himself, for Tamsin had set her affections elsewhere, he looked venomous, and drove off toward the Plank Road house. Soon meeting the object of his search, Hughes orders the driver to stop. The women would not stop, but he followed on, overtook them, and parleyed about matters of receiving papers, giving checks on the bank, as a ruse to throw Mrs. Parsons off her guard, and gain a private talk with Tamsin. It is refused. Robinson comes along in a wagon, and will take the women home. Hughes parleys, the interview is refused. He tells Tamsin he will live with her if he has to hang for it. No one else shall have her if he has to swing for it. She still denies him an interview. He puts his hand to the pocket where his pistol was, but catches Robinson's eye, drops his hand, and as they drive on, walks back to his carriage, and thence to the Plank Road house. He needs stimulus, he falters in his purpose. They drink and post back to Crumb's, opposite Parsons' house, ask for Parsons' family, and learning that they have gone to Bedford, Hughes says drive on to Bedford. He goes first to Christian's shop. Why? To find out where Tamsin is, whether at his house, having rode to town with his wife, or at Joseph Haynes's. He accosts Mr. Parsons and asks him to drink. Why? To find out where Tamsin is. Just then he spies her going to Christian's house and gives pursuit. She was alone. Here and now or never was opportunity to see her alone. If he fail now, his final avowed purpose must be executed. She flies, he pursues, she says, "No, I will not stop," rushes through the gate, opened by the boy, Christian, which is then by him closed. Hughes draws his revolver, cocks it ere he reaches the gate, opens it, speeds up the walk, and within 10 feet of Mrs. Christian's open door, lays violent hand on Tamsin's shoulder and fires. She utters a cry so piteous it would have melted a heart other than adamant. He fires again, and Tamsin's spirit soars to where the wicked cease from troubling and the weary are at rest. Now what crime has been committed? Has any? We admit and accept the burden of proof as to deliberation and premeditation of this act. By 5 different declarations, 4 of which were made when sober, to Ray, Mrs. Eddy, Messrs. Salisbury, Parsons, and Robinson, we establish that deliberation. We have shown it by the circumstances of the act and by the declarations of the defendant after his capture. Now, what is the defense? It is hard to tell. Is it insanity? No one swears to it, but it was an uncontrollable impulse, say the defense. To what? Love? They cite Othello's love. But the love of the noble Moor was an honest love. He never committed forgery. Was it drunkenness? That was no excuse in the eye of the law, the purpose to kill her having been proven to have been formed 2 weeks before. If drunk, as claimed, he wrought himself into a frenzy by drink as a means to an end. But nobody swears that he was drunk. He was cool, collected, deliberate. The fact of intoxication, not the amount of liquor drank, must be proven. We must proceed to consider what were the mental states of the defendant, what inspired his acts, and named desire for an object, disappointment, anger, jealousy, and revenge as springs of action, and their power, natural operations, effects, consequences, etc., thus showing by his exercise of these, as well as by a consciousness of the act in all its bearings, his full memory of all the details, that the defendant acted like a rational, not an insane being, and this view is supported by his prior preparations and conduct, as well as subsequent action. Did he know what he was about? Was he mistaken when he told why he had done the deed? I will not stop to speak of the flimsy fabric reared on his appearance the morning after his arrest, and talk about delirium tremens. He was excited, it is claimed. He trembled and looked wild. Ah! We can imagine what the horrors of that night would be to his guilty soul. We can imagine in his dreams, if he could sleep at all, the ghost of his murdered victim passed before him, as did the visions of his murdered victims before the guilty, Richard on the eve of Bosworth Field. And like him, in terror, he started in his fitful sleep, exclaiming, quote, "O coward conscience, how thou dost afflict me! It is now dead midnight. Cold, fearful drops stand on my trembling flesh. What do I fear? Myself? There's none else by. Is there a murder here? No. Yes, I am. My conscience hath 1,000 several tongues, and every tongue brings in a several tale, and every tale condemns me for a villain. Perjury, perjury in the highest degree. Murder, stern murder in the direst degree. All several sins, all used in each degree, throng to the bar, crying all, guilty, guilty." End quote. Pray, gentlemen, what will make murder in the first degree? What by your verdict will you say? That 2 weeks' deliberation, 5 declarations of fell purpose, the purchase of a pistol for the avowed purpose, declaring motives, and doing all ordinary acts, resulting from such motive, exhibiting motive, reason, deliberation, will, consciousness, and after the deed, clear memory, describing the act with coolness? If all this not be murder in the first degree, pray, what is it? Is there such a crime possible? Gentlemen of the jury, my duty is done. I fully appreciate the solemnity of the issue that crowd thickly as I entrust this case to you for the performance of your duty. The consciousness of having so done will be an abiding consolation. The serenest reflection you can have in after years, on recalling the scenes of this memorable trial, will be the conviction that you here did your duty, responsive to the solemn obligations of your oath to render a verdict according to law and the testimony. And when these walls have crumbled, when judge and jury, counsel and spectators are gathered to meet the dread arbitrament of the future, may you each be able to say, in reference to this case, as I now can, I did my duty. End of section 67.